Lastly, one matter 230, Your Lordship. And acquisition matter where the amount is going to be dispersed, my lord, in spite of the injunction order granted by the trial court, Your Lordship. The land acquisition officer is bent upon passing the order.
That actually that's what 40 years back, madam.
What do you want?
Without acquisition proceedings, madam. Notice has been issued and it is not been listed. Several members have been moved, my lord.
Sarvagidya. Sarvagidya.
Sarvagide, Mudai.
And permission. madam. 4 times I moved the matter, madam, not coming. Rest matter, madam.
ಏನಕ್ಕೆ
Others, BD matter.
ಇಲ್ಲ ಏನಕ್ಕೆ ಬಿ ಗ್ರೂಪ್ ಗ ಏನಕ್ಕೆ
Big fresh matter. My 10th may be posted, madam.
One matter, my lord's lordship had heard and reserved MRPL amalgamation matter. Learned Senior Counsel Mr. Holla and Manmohan P and my lords had argued that lordship had asked us to give the notes, bullet points, my lords, what we have submitted, along with the pagination of all the annexures.
OMPL.
OMPL, please.
Your Lordship, may I mention one matter, Your Lord?
Yes.
My Lord, it's a press review petition, my Lord. That is a matter of termination, my Lord. And certain points and amendments which I have made has not been considered inadvertently, my Lord. It was filed in January, so Lordship may kindly put a date.
What have you filed?
My Lord, the petition was filed in January, review petition, my Lord.
Review, my lords.
Review petition.
Review petition, my Lord, yes.
Send a
My
memo.
Lord.
Send a memo.
My Lord, e-memo is not working. I am from Odisha and I have emailed, my Lord. So request is maybe oral request may be kindly considered.
He's from Orissa, my lords. He's not able to come and submit.
Oral memo. Can we act on an oral memo?
Lords, he's
My lord,
emailed it
I
to the
have sent
registrar.
one
The
post.
registrar may be directed to act.
What is the number, RP number?
56 of 2024, my Lord.
All right.
I have emailed, my Lord.
Next week. Next week.
My Lord.
Next Monday.
$49 man. Yearly. 2 weeks time ಬೇಕಾ statement ಹಾಕ್ಬೇಕಾಗುತ್ತೆ. And for the BDM.
ಅವ್ರು ಹೇಳಿದಾರಾ?
ಹೇಳಿ. List.
For petition, serial number 54 minutes for petitioner, prays for a week's time, man.
List. ಅವ್ರು ತಿಳಿಸ್ಬಿಡಿ ಅವ್ರು.
ಹೇಳ್ತೀನಿ.
68 lords. Lordships may kindly have to have it after the vacation. I for the petitioner.
Sorry. Next.
Please.
Please
67
inform
man.
the other side.
Yes, ma'am. 67 man. ವಕಾಲ ಬಂದಿಲ್ಲ.
ಅವ್ರು ಹೇಳಿದಾರಾ?
ಹೇಳ್ತೀನಿ. List.
My lords, serial number 41, my lords, may kindly be 1 week time may be given, my lords.
40.
41, my lords, 41.
Next week.
Much okay.
List.
ಯಾಕೆ ಅಷ್ಟೊಂದು ಮ್ಯಾಟ್ರ್ ಬಂದಿದೆ? 60 ಮ್ಯಾಟ್ರ್ ಬಂದಿದೆ. ನೆಕ್ಸ್ಟ್ ವೀಕ್.
Converted as RFA, my lord, in view of the dismissal of application 7 to 11 amounts to decree, my lord.
Counsel for the petitioner.
May I request for the limitation, my lord, section 14 may be,
For how many days are you pending?
in fact, I moved the matter, my lord, for the conversion itself.
You filed only in March.
Please, my lord,
Is within time?
with probably 10 days, the limitation will come, my lord, because of the conversion, it will take.
Conversion, it's all right, but when the revision is in time?
10 days delay, it may, office has not calculated the delay, my lord, as per copy application, that will not come in the delay, my lord.
For permission to convert this revision into an appeal. Permission sought for is granted. The time spent in prosecuting this revision shall be excluded for the purposes of computing the limitation. If however there is a delay in filing the revision, necessary application be made for condition of delay. For statistical purposes, revision stands disposed.
Obliged.
The respondent filed a suit seeking to declare that I am not the adopted son of the family of the respondent. And also subsequently, he had sought for another reliefs that to declare that the entries that were been, the compromise that was been held in the year 2002, they are not acted upon, my lords. Hence, I had filed an application for rejection of the plaint on the grounds of limitation, my lords.
Where is the amendment? Plain paras page 23, isn't it?
Lords,
Where is 23 page?
page 23, my lords.
What is the relief that you are saying?
Lords, the reliefs that were, I was sought for the rejection of the plaint, my lords.
Ah.
The respondent, the suit of the filed by the respondent, he was sought for the declaration of the declaration that the petitioner number 1 is not the adopted son in the family of their family, and subsequently that's also sought to declare that the compromise that was been held in 2002 between the respondent.
They said regarding compromise.
Well, it's you get the right to succeed or claim or anything right over the property as during the year 2002 itself, the first defendant had surrendered suit schedule property to the family of the plaintiff. He claims it in the. He
What is
claims
the-
in para 6 of the plaint, my lords, at page 20. Para 6, my lords. It is submitted that in subsequent development after conclusion of the case before the Honorable High Court, there was a sitting between defendant number 1 and also the family members of the plaintiff. And as per the meeting held, a conclusion was arrived in the month of September 2002, as per which the first defendant had agreed to cancel the revenue interest got in his name over the suit schedule property and also to surrender 8 acres of the land to the possession of the plaintiff's family. And accordingly, in the month of January 2003, he surrendered suit schedule property, suit schedule land to the family of the plaintiff, and however not prepared to get cancelled revenue entries found in his name against the land situated in old survey number 59. So this is his contention, lords. He has sought for a declaration of that.
What declaration is sought? He swore a declaration that you are not the adopted son.
Yes, my lord.
If he succeeds,
My lord,
then the entry made in your name on the basis of the adoption will go.
my lord, sir, this entry, my lords, was being challenged before the Assistant Commissioner and also before the High Court, Honorable High Court, my lords. In the year 2021 itself, my lords, one of the legal heirs, that is the family of the respondent, had appeared before in WP number 1072, my lords. It's para number 5, my lords. The WP of the respondent's family was being dismissed, my lords, and the revenue entries in the name of the plaintiff, the petitioner herein, was held.
Can you not go to the civil court against the decision of?
They are not approached the civil court subsequent to that. my
What
lords.
is the suit for?
My lords, the writ was in the year 2002, my lords. After around 20.
Does it make, it's a suit for declaration.
my lords,
All the revenue entries made by the revenue officer will be subject to the result of any civil suit.
my lords, they did not approach, my lord. They had given, they were.
What is the bar in law for filing such a suit?
My lords, the limitation is, my lords, 3 years from date of their knowledge, my lords.
Limitation of what?
Limitation of the entries that have been in my name, my lords.
Your entries, they don't give you any right. You sought for a declaration. If he gets a declaration, then automatically
My lords, even he is seeking the declaration of the adoption, my lords, to cancel the adoption.
he is not seeking for a declaration regarding the entries. He is seeking a declaration regarding your adoption. If your adoption is declared to be no adoption at all, then obviously you can't get your names entered there.
My lords, even the adoption is of the year 1975, my lords.
That is a
My lords, they had knowledge, my lords.
not under registered adoption deed.
It's a registered adoption deed, my lords.
Where have they said, where have they admitted it's registered adoption deed?
My lords,
In the plaint?
my lords, para 5, my lords. It is submitted that there was a serious dispute with the cousin brother of the plaintiff, Sri Odappa, son of Timapaya, and defendant number 1 regarding the above said MR entry. And in the beginning, it was held before the Honorable Assistant Commissioner Court, Shimoga in PDA number so and so, which was concluded on 21/1/1997. And subsequently, the order of the said case were challenged before the Honorable High Court of Karnataka for filing writ petitions.
Where has he admitted that the registered adoption?
But
to be
this
a
MR,
certified-
this MR entry was made on the registered adoption deed, my lords. The MR entry that was being challenged in the, before the Assistant Commission, my lords. That MR entry was made on the basis of the,
You have a copy of the MR?
of the registered deed, my lords. My lord, I have a certified copy of the,
Nowhere in your plaint you have said anything about the registered adoption deed. He has said anything about the adoption deed.
lords, that entry is
What is this? 84.
84, my lords. Adoption deed.
Where is the MR on the base of which? Yeah,
Yes, it's along with the writ petition, my lords. Earlier writ petition that was been filed, my lords.
MRL adoption deed, the one, then reference is recorded.
Yes, my lords. Lords.
Yeah. There's no reference to the partition deed here.
No partition, my lords. It is on the Dattuputra, my lords, and the adoption, my lords. There was no partition, my lords, with regard to,
No, if there's a registered adoption deed,
please, my lord.
there's a reference to the plaint, to a
After,
document which refers to this registered adoption deed, I can do something.
my lords, after the death of the mother, my lords, the MR got changed to the name of the first
But
petition, my
it
lords.
should be on the base of the registered adoption deed.
Lords,
If he tries to get over this adoption deed by not asking for a cancellation of this, is there any reference in the plain documents to the registered adoption deed?
my lords, I'll furnish the documents regarding that, my lords.
What are the documents that he produced along with the plaint?
My lords, my lords, the respondent has filed, my lords, at page 25, my lords. RTC extracts, legal notice, reply notice, Xerox copy of the order of the WP number, my lords, certificate copy of the index of the land, and certificate copy of the form 1.
Where does he refer to the registered adoption deed?
He has not, my lords, he doesn't make any reference, my lords, in the plaint, my lords.
One reference in the plaint, then I can take cognizance of that. Without there being a reference in the plaint or in the plaint document. I'll have to look at your defense to reject the plaint. That
Please.
would not be permissible.
My lords, para 4, he says regarding the knowledge, my lords.
This is regarding the partition. The prayer relates to the adoption first.
Please, my lords.
He admits there's a registered adoption deed of the year 84. Then the entire complexion of the case changes.
Please, my lord. That MR entry was being made as he was the adopted son, my lord.
Correct, but the adoption should again be admitted by him of the year 84.
My lords, that is the reason he's seeking that cancellation of that, my lords, to declare that the defendant is not adopted son in the branch of the family of the plaintiff, my lords. This adoption, this prayer came because of this MR entry, my lords. He was the adopted son.
Correct. Now, if you are saying that you are adopted by virtue of registered deed,
Please, my lords.
if there's a reference to the registered adoption deed of the year 84, then the suit of the year 2022 would probably be barred by limitation. For that, I need a reference in the plaint that there's an adoption deed. I cannot act on your defense. to say there's a residual or adoption need. That is your defense.
Yes, my lords.
I can't look at the defense to reject the plaint.
They had the knowledge of the adoption, my lords, in the year
If they had-
1996.
If they had knowledge of that, and if they disclose that in the plaint or in the plaint document, I'll act upon it.
The documents along with that, they're not sorted, my lords.
Or else I can't rely upon your written statement to reject the plaint.
Please, my lords. Because since, not this, the
Take
proceedings,
notice, let us notice.
lords, the proceedings before the assistant commissioner was because of this MR entry, my lords. So
No,
it
you
was
didn't,
based on the adoption deed.
Council is permitted to take out notice on the respondent plaintiff through the council who represents him in the trial court.
That is for the petitioners, my lord. But, Lordship's order dated 26th February, my lord, in CRP, my lord. For the facts are, my lord, we are the judgment debtors. The suit is one for possession, my lord, by the civil code. In the execution, my lord, we contended that, my lord, the suit premises, my lord, is a residential premises situated in Mangalore City Corporation, and under section 2, my lord, the provisions of the Rent Act applies. That objections we filed, my lord, under section 47 before the executing court. Executing court having dismissed our objections, my lord, and passed a delivery warrant and further proceeding. We approached before this honorable court in CRP. Your lordships were pleased to hold in the CRP, my lord, that para 6, my lord, page 13. Right through, my lord, we contended that we ourselves were owner and we were not tenants. Up to Supreme Court, my lord. Now we cannot be permitted to say that we are tenants. This is a stand taken by the tenant in a proceedings. My lord, the courts have held, if a tenant takes a stand that he himself is the owner, my lord, and if the courts are to hold that he's a tenant, the bar is for the court. Because the
Supreme Court hold a ground.
I will, there are direct decisions, my lord, 2, 3 decisions. At that point, my lord, I could not.
You can't re-argue the matter now. I've taken a view. Heard no grounds. Review is rejected.
Because our time alone, I could not.
The question involved in this petition is whether the award passed by the respondents under the provisions of the old Land Acquisition Act is correct or not, the question involved. Because after the amendment of KIDB Act 5/4/2020.
When is the award?
Award is 2022, my lord, next year. It was 19/12/2022. Act was amended on 5/4/2020. So this award was passed under the provisions.
After the amendment to the act?
After the amendment of the act. Take notice.
AG accepts notice for argument. C. Ramakrishna accepts notice for respondents 2 to 4.
This matter is also similar.
Same.
Same.
Ravindra Reddy. Ravindra Reddy for R2. Ramakrishna for sons. Same.
Same.
For mandamus, my lord, to change the entries in the CASAs, RTCs. Because the RTC KDB name has been shown. Now they want to change the name of the petitioners in the RTCs. my lord.
ದಾವ ಎಲ್ಲ ಹಾಕಿದ್ದಾರೆ ಏನಾದ್ರು?
Yes, my lord.
Is it to take notice for respondents?
For the petitioner, my lords, apology. Land was acquired in the name of my father, my lords. Father died after acquisition, my lords. Pauti Kata was entered in my mother's name, my lords. Award notice is issued, I have only received, my lords. My mother produced the family tree, my lords. There are three shares, my lords. The entire compensation amount is given to my mother.
When was the amount given? To the award notice, did you give any reply?
No, my lords. Award notice was given, my lords. I have received, to my address it was given, my lords. I've received the award notice.
And what did you reply?
I did not reply, my lords. We were agreeable for the compensation amount. 6/7/2023, she has received, my lords. I've produced the indemnity bond also.
1, 2, 3. Issue notice to R4 and R5.
My request for a date,
Until they are served, what is the point? You get them served, then move.
please.
I aware for the petitioner in this matter, my lord. The petitioner's mother, my lords, was in possession and ownership of the property from survey number 10/5 to 10/18, measuring to an extent of 7 acres, 37 guntas in Pina village, my lords, Yeshwantpura. My lords, by the sale he dated 2/3 to 1968. My lords, subsequently by in the mutation numbers, my lords, in the index of land.
KLR matter.
My lords,
What
this
changed the name of the entries in the RTCs, my lord?
entries in the RTC, but my lords, in the RTC, there is a notification in 1969 where the impugned.
Can I hear this matter? Because it appears to be, the prayer entirely relates to RTC entries.
Please, my lords, there is also removal of KIDB, the land, my lords.
That also is again a revenue entry, isn't it?
Please, my lords, that's
Let it go for the KLR bench.
that was my submission to the scrutiny bench, my lords.
They didn't agree with you.
They didn't agree with me.
It is noticed that the prayer in the writ petition relates to revenue entries. The matter therefore pertains to KLR. And the petition be posted accordingly before the appropriate roster.
Good. General order passed by the respondent is challenged, and KDB. But in this similar connected matter that has been set aside. So 2018 order, my lord, award
Take notice for R1.
take notice.
C. Krishna accepts notice for R2 and R3.
BMRCL, I may be permitted to.
PMS
ಇದೆ ಅವ್ರಿಗೆ ಒಂದು
BMS party ಮಾಡಿಲ್ಲ.
Then is regarding preliminary notification 28/1, my lords. Final notification is not issued in these matters, my lords. Because notice has to be issued.
EJD accepts notice for R1. Shri Ashok Naik accepts notice for R2 and R3. Nitin Prasad accepts
R4
notice
and
for
R5.
R4 and R5. R? R3 ಮಾತ್ರನಾ? R3 ಅವರು, R2 ಅಶೋಕ್ ನಾಯ್ಕ್, R3 ಅವರು, R4 and R5 ನಿತಿನ್ ಪ್ರಸಾದ್.
But 18. Next also same.
Same. Counsel for the petitioner has filed a memo seeking to withdraw the writ petition. As requested, provision is dismissed as without law.
Topic objection is, my lords, D2 is no more. And I.
Who's no more?
D2 is no more. As I not made as a party. So for this, the certificate.
Who's D2?
Ratnamma, he died on 10/6/2022.
Who's R3 and R4?
Sons of Ratnamma, R3 and R4.
ಬೇರೆ ಹೆಣ್ಮಕ್ಳು ಇಲ್ವಾ?
ಹೆಣ್ಮಕ್ಳು ಇದ್ದಾರೆ.
ಮತ್ತೆ ಅವ್ರನ್ನ ಪಾರ್ಟಿ ಮಾಡೋದು.
Respondent sue and the defendant is sued, application 7 to 11 was rejected. And the
ಇಲ್ಲ ಅವ್ರನ್ನ ಪಾರ್ಟಿ ಮಾಡಿ ಆಮೇಲೆ ನಾ ಇಲ್ಲಿ ಡಿಸ್ಮಿಸ್ ವಿತ್ ನೋಟಿಸ್. Without them being party, how can you? If there are only two sons, I will note that they're already on record, steps not taken. But if there are daughters, then what do you do?
then the defendant, 7 to 11 application that came to be rejected.
ನೀವು ಅವ್ರನ್ನ ಪಾರ್ಟಿ ಮಾಡಿ ಆಮೇಲೆ ಡಿಸ್ಪೋಸ್ ನೆಕ್ಸ್ಟ್ ವೀಕ್.
Appear for the respondent in this matter. My lords, here the very basis of this petition is not maintainable, my lords. It is a recall application which they have challenged before this honorable court.
Who appears for the petition?
A recall application, they have filed a CRP, my lords. By proviso of section 115, it is impermissible in eye of law.
ಇಲ್ಲ ಫಸ್ಟ್ ಅವ್ರು ಬರ್ಲಿ
ಇಲ್ಲ
ಅದೆಲ್ಲ.
ಅದು ಸರಿ ಇಲ್ಲ ಇಟ್ ಇಸ್ ಅನ್ ಲೀಗಲ್ ಪಾಯಿಂಟ್ ಅನ್ನೋದ್ರಿಂದ ಹೇಳ್ತಿದ್ದೆ ಅಷ್ಟೇ. ಇಟ್ ಇಸ್ ನಾಟ್ ಮೇಂಟೈನಬಲ್ ಅಟ್ ಆಲ್, ಮೈ ಲಾರ್ಡ್ಸ್. ಇಟ್ ಹ್ಯಾಡ್ ಟು ಹ್ಯಾವ್ ಪ್ರಿಫರ್ಡ್ a writ petition GMCPC, my lords. Perfunctory production of order sheets ಏನೇನ್ ನಡೆದಿದೆ ಅಂತ ಅಂದ್ಬಿಟ್ಟು ಹೇಳೋದಿಲ್ಲ. This is the 6th application that they are filing for recall. They want to know at the fag end of the case, they want to change the power of attorney on record.
Correction ಆಗಿದೆಯಲ್ಲ ಇದು? Operative portion of the impugn. The discrepancy in mentioning of IA number in the operative portion impugn order to be ignored. Post for admission now. Let come for admission.
Yes, my lords. There is no interim order, my lords, in this case. There is no interim order.
Not granted anything.
Yes, yes, much obliged.
A week's time is granted to the need.
My lord, regarding office objections, this is a continuation of the same writ petition. I am advocate on record.
But 24.
It is disposal matter, my lord, they are seeking for rectification.
My lord, it is a mistake. Anganwadi assistant post. This honorable court has allowed the writ petition for the post of washing the 6th respondent for the post of Anganwadi assistant, my lord.
What is a mistake that is that
It is Anganwadi worker, my lord.
ಅಂಗನವಾಡಿ
Kindly
ವರ್ಕರ್ ಅಂತ ಬಂದಿದೆ, ಅಂಗನವಾಡಿ ಅಸಿಸ್ಟೆಂಟ್ ಅಂತ ಆಗ್ಬೇಕು.
Kindly come to annexure Y at page number 20.
ನೀವು ಮಾಡಿದ ಮಿಸ್ಟೇಕ್ ನಾ ಮಾಡಿದ ಮಿಸ್ಟೇಕ್.
It's our mistake, my lord. I sincerely apologize for that.
An application is filed seeking for permission to carry out corrections in the writ petitions in relation to the use of the term Anganwadi assistant instead of Anganwadi worker. It is stated by mistake. In the writ petition, the word Anganwadi assistant was used instead of Anganwadi worker. Since the correction sought for does not prejudice any of the parties, the application is allowed. This is the correction carried out in the writ petition, and consequentially, in the order that was passed on 26th of September 2023, wherever the words Anganwadi assistant appears, it should be read as Anganwadi worker.
The office objection is that the counsel for BDA is not being served. Mr. Sunge, my lord, is no more in the panel. Lords may direct another counsel for BDA to take notice.
Since it is stated that Shri T.P. Rajendra Kumar Sunge is not in the panel of BDA, Shri P. Latif is directed to take notice for BDA.
Please.
Your lordship, in this case, yesterday executive committee meeting has happened with respect to first respondent, your lordship. In that it was decided that the fourth respondent is going to pay some money to the petitioner to lay that STP, your lordship. In this context, the date and when they are going to pay, how they are going to pay is not yet fixed, your lordship. In this context, may I beg your lordship to post after vacation, your lordship, in this post after vacation. Much obliged.
Lordships have directed me to file an estimation.
Akidra.
Telling it.
30 lakhs agata?
No, that is.
30 lakhs our ಕೊಟ್ಟಿರೋದು ಸ್ವಾಮಿ.
Lordships have orally directed me to secure a report from the BDA.
ಹಾಕಿದಾರೆ ನೀವು ಮೆಮೊ. ಎಷ್ಟು ಹೇಳಿದ್ದೀರಾ ನೀವು?
1 ಕೋಟಿ children. 1 ಕೋಟಿ 42 lakhs.
The memo filed by the BDA indicating the estimate cost for installation of the sewage treatment plant is taken on record. Copy ಕೊಟ್ಟಿದ್ದಾರೆ ಅವರು. Post notification. ನಿಮಗೆ ನೀವೇ ಕಾಪಿ ಮಾತ್ರ
Respondent number 4.
And for petition, kindly pass over the matter.
What was the order that I passed? ಕಾಪಿ ಕೊಟ್ಟಿದ್ದೀರಾ ಅವ್ರಿಗೆ?
ಕೊಟ್ಟಿದ್ದಾರೆ ಸರ್.
ನೋಡಿದ್ದೀರಾ?
ನೋಡಿದ್ದೀನಿ, ಸೀನಿಯರ್ ಬರ್ತಾರೆ, kindly pass over.
This was the respondent.
Answering
Monica
respondent is
Patil.
for Monica Patil. This matter, my lords, we are seeking for quashing of the general award, my lords. It's praying for consent award
ನೀವು ಯಾರಿಗೆ?
for the petition matter.
In the WP.
In the WP minutes, please.
RSA?
In the RSA, my lords, I am the respect.
Who appears for the appellant?
Sidmalapur.
Which should be heard first, the second appeal or the writ petition?
My lords, the RSA might require a hearing, in the sense, my lords, it may need to be heard first. Plus, the suit was dismissed, which was filed by the appellant therein. Appeal also has been dismissed. Quoting the reason that there's an RSA which is filed, lords, they are refusing to consider my request
The request for?
for quashing the general award and passing of the consent award. Suit for specific performance is rejected, lords.
What is the consent award? Who appears to be KDB?
Vasanta, my lord. Last occasion, Monica Patil ಅವರು appear ಆಗಿದ್ರು.
ಇಲ್ಲ ನೀವು ಆಫೀಸ್ ಅಬ್ಜೆಕ್ಷನ್ ಅಂತ ಬರ್ತೀರಾ, ಅದಕ್ಕೆ ಅವ್ರು ಯಾರು ಬರಲ್ಲ. Because it is post for complaints of office objections. They won't come.
Lords, I'll look into the same, lords, fix a date in that case.
Relist on so and so by which time office objection shall be complied with.
Please. Please, grateful.
Respondent number 2, my lords.
Petition.
The last date petitioner was directed to serve the copy for the BDA, but they have not yet served.
I shall serve, my lords. Today itself I shall serve, my lords. We have taken up 2 weeks, my lords. We have to file rejoinder to their objections, my lords. Hello, it may be taken after vacation, my lords, if it's possible.
Any day next week, because my construction is getting strict.
Interim order ಇದೆಯಾ?
Interim order ಏನು ಇಲ್ಲ. ಅವರು what he is asking is for a mandamus to allot a certain land as a
I said it is made clear that if any
part of, that is part of a civic community that has already been allotted to me.
like there is no interim order, why are you
Interim order.
then after vacation?
Grateful, my lords.
Who's R4?
R4 is Chief Engineer KRDCL. Vijay Kumar may be directed to take notice for
So Vijay Kumar, Section 3 to take notice for R4.
Lord, taken up next week, my lord. It's a writ of mandamus.
Get him.
Please pass out, my lord.
The petition council, the BD has to file objections. KIDB.
Until your objections, huh?
No, ಹಾಕಿಲ್ಲ.
Weeks time is granted to file objections.
Interim order में kindly. Interim order.
Interim order and earlier shall continue.
Here for the petitioner in this case, my lord. Lord, with respect to the office objection, my lord, I have already served the copy to the KADB, my lord. In the last occasion. Sir, serve ಮಾಡಿ, KADB. KADB ಗೆ sir, I have already served to the.
ಕೊಟ್ಟಿದ್ದೀರಾ? ಅವ್ರು ತೋರಿಸಿ.
ಬೋರ್ಡ್ ಅಲ್ಲಿ ಸರ್
ಅವ್ರಿಗೊಂದು ಕಾಪಿ ಕೊಡಿ. ಈ ಲಿಸ್ಟ್.
The petitioner, the last occasion, my lord, directed me to serve a copy on all the respondents. I have done that, my lord. This is the requisition, my lord, wherein the notifications under 28-1 is dated 9/12/1998. And the final notification, my lord, is 21/3/2009. There is no award that has been passed. No possession has been taken.
Copies received probably on Friday, last Friday. I could not even send to the board also because of vacations.
My lord, in one matter, this division bench of this honorable court, in regard to the same project, has already set aside the acquisition proceedings as having been delayed by 9 years. This, my lord, is much beyond that. The appeal by the board, my lord, has been dismissed by the honorable Supreme Court.
We'll give him one chance.
That's Swami, I'm saying the matter, my lord, even on the last occasion, the predicament of the petitioners may please be understood, my lord.
The copies serve ಮಾಡಿದ್ರೆ 2 days back ನಮ್ಗೆ.
ಅಲ್ಲ, last week serve ಮಾಡಿದೀವಿ ಅವ್ರಿಗೆ, 5th ಗೆ serve ಮಾಡಿದೀವಿ.
ಯಾವತ್ ಬೇಕು ಹೇಳಿ.
ಆಯ್ತು ಸುಮ್ಮನೆ 1 week ಅಥವಾ 10 days ಆದ್ಮೇಲೆ.
Interim order may be passed, my lord, let them take them time.
Cited in other connected matters also, the same may be posted on 18th of June, my lord. All 88 matters may be, as we are awaited by the state
No,
government.
but if you have not passed any award, if you have not taken possession,
Please, madam.
if you make a statement that you will maintain status quo, I will adjourn.
Please, my lord.
In other matters also, same kind of prayer. they have
40.
sought. Even
One
the
eight-
effect also your lordship has directed to
1836.
clear once for all the 5.
Is it a fact that in this case award is not passed?
Please, madam.
Madilva.
ಮಾಡಿಲ್ಲ ಸ್ವಾಮಿ.
ಮಾಡಿಲ್ಲ.
Then how can you take possession?
Position ತಗೊಂಡಿಲ್ಲ ಸ್ವಾಮಿ. ಅವರು they have already contended that they are undisturbed position, we are in position and enjoyment ಅಂತ ಅವರೇ ಹೇಳಿದ್ದಾರೆ.
Do you admit that or do you dispute that?
ನಾನು ಅಡ್ಮಿಟ್ ಅಂತಲ್ಲ, ಅದೇ ಕನೆಕ್ಟೆಡ್ ಮ್ಯಾಟರ್ಸ್ ಅಲ್ಲಿ ಆಗ್ಲಿ ಒಂದೇ ಸರ್.
ನೀವು ಹಿಂಗೋ ಅಲ್ಲ ಹಂಗೋ ಅಲ್ಲ. ಅವ್ರು ಇಂಟ್ರಿ ಆರ್ಡರ್ ಕೇಳ್ತಿದಾರೆ, ನೀವು ಅವ್ರ ಸ್ವಾಧೀನದಲ್ಲಿ ಇದಾರೆ ಅಂತ ನೀವು ಅಡ್ಮಿಟ್ ಮಾಡ್ಕೊಂಡ್ರೆ
Please, my lord, it may adverse effect on other matters also. All others will advance the matters and accordingly it may disturb the project.
ಇಲ್ಲ ನೀವು ಅವಾರ್ಡ್ ಪಾಸ್ ಮಾಡಿದ್ರೆ ಇಷ್ಟು ವರ್ಷ ಆದ್ಮೇಲೆ what is the effect of that? You can continue somebody's.
We will conclude on the 18th of as directed by the state.
My lord, may please see the order of the division bench as upheld by the honorable Supreme Court. Same project, my lord.
My lord, for respondent 7 and 8 beneficiary, my lord, seek some time, my lord. We just filed wakalat today, my lord, time to get
My lord,
instructions.
what possession? Who's in possession?
Lord, seek some time for instructions, my lord. Just today we have filed wakalat.
Page 86, my lord, are the photos. My lord, this is the order dated 8 June 2023. Respondent number 3 in this, my lord, is the project proponent. My lord, may please come to page number, internal page 3, my lord, which gives the details of the notification. Para number 4. Preliminary notification under section 28(1) of the Act was issued on 16/10/2008. Final notification under 28(4), 21(3), same final notification, my lord. My lord, may please come to para 7 and para 8. Para 9, my lord, the notifications dated so and so, and so far as the land in question here held by the landowners are hereby quashed. It's the same project, my lord. SLP, my lord, is at, I'm sorry, my lord, it's at page 7. In which, my lord, even the respondent number 7 and 8 were represented before the Honorable Supreme Court.
If it's already quashed, then what remains?
My lord may grant, Lord may grant some time, my lord, we'll
Other
take
cases
instructions.
also, this has been cited, my lord. Because of all other matters.
No,
once
even in
for
this
all-
case, division bench has already held that you have not passed an award for 11 years. The notification was required to be quashed. Supreme Court has confirmed it. If you admit that position, then what remains?
Let him furnish, we'll also go through it.
My lord, this is a matter where the appeal was filed by KADB, my lord. KADB was the, filed the SLP before the Honorable
Action
Apex
taken if you
Court.
have not passed an award.
From
From 2009.
May I make submission? The Supreme Court directed to take notice. Office ಕೂಡ Friday ಕೊಟ್ಬಿಟ್ಟು ಇವತ್ತು ನಮ್ಗೆ ಹಾಕಿ ಅಂತ ಹೇಳಿದ್ರೆ ನಾವೇನ್ ನಾನು ಕಳ್ಸಕ್ಕೆ ಆಗಲ್ಲ ಇನ್ನು ನಾವು.
Wednesday ಹಾಕೊಳ್ತೀನಿ ತೊಗೊಳ್ಳಿ ಅಷ್ಟು instruction, Wednesday.
Grateful, my lord.
Because if it's already quashed in one, I don't see I can't do anything different.
There is some question of law is kept open and something their observation.
Question of law is left open, but the facts are identified.
And same final notification.
We can take instructions on that.
If you have not passed an award, that is all that you have to find out.
Yes.
No award is passed, I'll pass the same order. You know what to do the next.
Yes.
Page 86 may please be seen why the petitioners are so.
Have it on Monday, please. We'll take instructions within the time.
Wednesday, the 15th hour.
15th.
My lord, until them at least they, because the petitioners, my lord.
They have not passed an award for 11.
Allal, enta atang, my lord, if I may just submit, the kind of fear psychosis that is there right now, my lord, on the ground. Because the respondent number 7 and 8, they issued a public notice where they said all these lands are required for us. No transaction should be done in regard to any of those lands. So any transaction also in regard to
Wait
those
for
lands,
one more week on 15th. If they don't file objections, I'll pass them on.
I'm grateful, my lord.
I pay for the petition in this case. My lord, I complied your lordship had directed me to deposit another 50%. I have deposited.
ಎಷ್ಟು ಡಿಪಾಸಿಟ್ ಮಾಡಿದ್ರೆ ಒಟ್ಟು?
75,000 something. Remaining 50% of the decretal amount.
I'll recall the order.
Please, my lords.
For the reasons stated in IA 1/2024 and IA 2/2024. The delay in filing the recalling application is condoned and the order dated 26/8/2021 is recalled. Ready na?
Next.
ತಿರ್ಗಾ ಬರಲ್ಲ ನೀವು, ತಿರ್ಗಾ ವಜಾ
ಇಲ್ಲ, ಇಲ್ಲ.
ಮಾಡ್ತೀನಿ.
I obtained a stay earlier, my lord. That may be continued.
ಆಯ್ತು 19 ಇಂದ ಸಾಕಲ್ವ 5 ವರ್ಷ CRP.
I'm sorry, my lord.
Records may be
Relist.
called.
ನೀವೇ ಕೊಡಿ ರೆಕಾರ್ಡ್ಸ್, ಅದು ತಿರ್ಗಾ ಡಿಲೇ ಆಗುತ್ತೆ.
Please.
ರಿಲಿಸ್ಟ್.
Yes, where is? The trial court. The respondent herein under order 9 rule 13 CPC have allowed the said miscellaneous petition and set aside the ex parte judgment and decree passed in OS. Yes.
Ex parte judgment decree has been set aside.
5/7 of 2013.
ಇಲ್ಲ, ex parte judgment
And,
decree set aside.
Relegated the parties to go before the trial court in Goes. And my submission is, my lords, in this case, in OS number 2557/2013, the petitioner has taken all the steps to see that the suit summons are being served on the.
What was the suit for?
Suit for specific performance of an agreement for sale.
You are the purchaser.
I am the purchaser. And suit scheduled property was agreed to be sold to me for nearly 1 crore. And I have paid a substantial amount. Substantial amount I had paid. And this respondent's wife, now Rupa Hemant, yes, she has filed this miscellaneous petition for setting aside the ex parte judgment and decree. Her husband's name is Hemant Kumar, who was defendant number 2 before the trial court in OS. Suit was specific for 4 months. And another person, that is Virubhadrappa, who is respondent number 2 herein. He is his brother, Hemant Kumar's brother. Plus, when both of them were living jointly, and Virubhadrappa being the elder and managing the property, he executed the agreements of sale.
Virabhadrappa.
Yes, agreement, even on behalf of his brother also. And subsequently, his brother also came and he executed a further that I have received the amount, so much amount, and the property in the partition has fallen to my share. And I hereby confirm the agreement of sale executed by my brother Virabhadrappa. And he took some more money from me and agreed to execute the registered sale deed, both of them. Since even after issue of notice, they did not turn up, I was constrained to file the suit 2005-57/2013. And I took summons thrice through court and as well by RPAD. They didn't come. Even this Virabhadrappa also didn't come before the court. And paper publication was taken. For that also they didn't respond.
What is
Thereafter,
what is the
evidence of the
property involved?
plaintiff was recorded. Pardon?
Property, you know?
Property is a house property consisting of ground and first floor. Therefore, my lords, when they didn't come, plaintiff was asked to lead his evidence. He has led his evidence. He has examined the witnesses to the agreement of sale, everything, and thereafter the order came to be passed.
But it is an ex parte decree. Why can't they get a chance to defend the suit?
The contention is that this Hemant Kumar and this lady, Mrs. Rupa Hemant, were residing in UK. UK or US? US, yeah, no? United Kingdom. And it appears that he met with an accident. It is subsequent to the ex parte decree, not before.
Ex parte decree, then why are you fighting so much for?
Ex parte decree antandre, the learned judge, the trial court has not taken into consideration the steps that I have taken in the OS.
All right, but the fact remains he has not been able to defend himself. So
now
get an order and merits. Why do you want to
now
fight this?
Respondent number 2, Virabhadrappa, is colluding with her, and now he is also not coming before the court. And now what happened, my lords, after getting the ex parte decree, I filed the execution for getting the sale deed executed. Sale deed was executed on behalf of this Virabhadrappa, respondent number 2, and on behalf of Hemant.
Through court?
Yes, through court. And at that time also, he was alive. Hemant Kumar, he was alive.
I think ex parte decree accepted set other merits, what is the point?
Merits mag barbako yavage, if suit summons have not been properly served.
But the trial court
every step has been taken in the trial court in the OS. They didn't come. Yeah, if it is otherwise, I do understand. After trial, it is an ex parte. Let the take trial on merits of the correct. It comes when the plaintiff has defaulted in getting the summons served properly. Then only. Otherwise, though it is on the face of it seems to be an ex parte decree, but it is a decree on merits. If such is the case, when the plaintiff has taken all the required steps, if the defendants didn't come to the court, there is nothing wrong in keeping them ex parte and getting. And as if the learned judge has not passed the orders without recording the evidence. plaintiff's evidence has been recorded, witnesses to the agreements of sale have been recorded. And
It-
thereafter, my lords, I filed.
Good summons are served by way of paper publication ultimately.
Alla, my submission is, I filed execution case wherein I got the registered sale deed.
That will go now.
And thereafterwards.
That will go now. If the decree is satisfied, that will go.
ಮುಂದೇನು ಹೇಳ್ತೇನೆ, ಇನ್ನೊಂದು ಎಕ್ಸಿಕ್ಯೂಷನ್ ಫೈಲ್ ಮಾಡಿದೆ ಫಾರ್ ಪೊಸಿಷನ್ ಫೈಲ್ ಮಾಡಿದೆ. Position I was put in possession. Thereafter, my lords, only after putting, I was put in possession of the property. This Rupa files a suit 249. 249 of
ಏನಕ್ಕೆ ರಿಜೆಕ್ಟ್ಮೆಂಟ್
yes, for declaration. She files a suit for declaration. In 249, and she withdraws it. And thereafter, she comes and files this miscellaneous petition. There is a delay of 1,119 days delay. Learned judge of the trial court, without considering that aspect and reducing the number of days delay to merely 189 days or something like that, he says he has not been properly served. Therefore, ex parte judgment and decree has been set aside. Before that, what had happened was, when I got the possession, after filing of the suit, for the first time in the suit, she says, on such and such date, my husband died, and gets in the suit, OS 249 or 20. In the suit, she says, I am in possession, and gets an order of temporary injunction. And in miscellaneous execution, already I had obtained I appeared and filed my written statement. And for the first time, I also raised subject to proof whether really husband is dead or not. ಅಲ್ಲೇ ಅದರ ನಂತರ ಇವರು ಎಕ್ಸಿಕ್ಯೂಷನ್ ಒಳಗೆ ಬಂದು, ವೇರ್ ಐ ಟುಕ್ ದ ಪೊಸೆಷನ್, ಎಕ್ಸಿಕ್ಯೂಷನ್ ಒಳಗೆ ಬಂದು ಅಲ್ಲಿ ಒಂದು ಅಪ್ಲಿಕೇಶನ್ ಹಾಕೊಂಡು ಇಂಪ್ಲೀಡಿಂಗ್ ಹಾಕೊಂಡು ರೂಪ she alleges a fraud on me, and the learned judge of the trial court passes an order for dispossessing me with the due process of law. And I challenge that order in the WB before this honorable court. This honorable court said, you inquire into properly of this aspect of matter, and he must be put in possession. That is, petitioner must be put in possession of the scheduled property, and pendency of the miscellaneous will not affect. First, you dispose of this matter within period stated by this honorable court in WP. And thereafter, they appeared, they filed in the execution, they appeared, filed an objection. That was inquired into by the court and dismissed. When the matter was posted to take steps, at that time, what they did was, they approached the principal civil judge by filing the miscellaneous petition, 2 miscellaneous petitions. There, they didn't suppress the order of this honorable court. Stay was there. They suppressed that fact. And when I came to know, I immediately approached the principal civil judge and placed the materials as to what has transpired in the High Court. Then immediately the stay granted was dissolved. And thereafter they filed the WP and took the stay. And during the pendency of the writ petition filed by the respondent herein, my lord's miscellaneous petition went ahead and this order came to be passed. This is the situation in which I am. Other day, my learned brother was alleging fraud, etc. on me. But real fraud is when the matter was being heard by the learned judge on the application filed by the respondent to the execution petition, there was open court. In the open court, the learned judge of the trial court in the execution case openly, and it is recorded in the order sheet also, openly said that
pressure is coming from the sitting judge, from the chamber of the sitting judge of the honorable, of this honorable court, to dispose of the matter in favor of this respondent. The learned judge has clearly opined and written in the order sheet itself. This is how the things took place. And the respondent tried to overreach and tried to influence the trial court judge in the name of the learned single judge, sitting single judge of this honorable court. This is the fraud that they have committed. And fraud everywhere. And it appears that her father-in-law is a police officer, retired police officer. And with that, during the pendency, when there was a stay, as it was not extended further due to the proper communication between the petitioner and his learned counsel, it was not further extended. Taking advantage of that, they dispossessed me. Now I am on the street.
I'll direct the trial court to dispose of the suit within 6 months.
My only submission is, final submission is, when the suit, if they point out any mistake in the non-service.
Simultaneously, the only thing that they have to show is sufficiency of cause for non-appearance. Trial court has accepted that it's sufficient cause, more so when the paper application was made and they were placed ex parte. Why should they not get a chance to defend themselves? Can understand if they were served personally and they chose to remain absent, there was something in what you said. It is by way of paper publication.
Now, the intent of the respondent is that she is going to deny even the signature of her husband in the agreement of sale. Because if your lordship fixes the date, you have to dispose of within this period. Then in that event, the trial court may, in the suit, since there is an order, there is an order from the Honorable High Court to dispose of within.
ನನಗೇನ್ ಇಷ್ಟ ಎಲ್ಲ ಮಾಡೋದಕ್ಕೆ ನೀವು ಅರ್ಜೆನ್ಸಿ ಇದ್ರೆ ಐ ವಿಲ್ ಪಾಸ್ ಅನ್ ಆರ್ಡರ್ ಬೇಡ ನಡೆಸಿ
ಅರ್ಜೆನ್ಸಿ ಇದೆ ನನಗೆ ಯಾಕೆ ಅಂತಂದ್ರೆ ನೋ ಐ ಆಮ್ ಆನ್ ದ ಸ್ಟ್ರೀಟ್ ಐ ಡು ನಾಟ್ ಹ್ಯಾವ್ ಮೈ ಹೌಸ್ ಇನ್ ರೆಸ್ಪೆಕ್ಟ್ ಆಫ್ ವಿಚ್ ಐ ಹ್ಯಾವ್ ಗಾಟ್ ದ ರಿಜಿಸ್ಟರ್ಡ್ ಸೇಲ್ ಡೀಡ್.
So that's a 2013 suit. I will direct the trial court to dispose of the suit within 6 months.
My lord, 5 minutes I will take your order. Yes, said.
Allow the revision.
ಅಲ್ಲೂ ಮಾಡಿ ದಯವಿಟ್ಟು ಆದ್ರೆ ಇದರಲ್ಲಿ ತಾವೇ ಒಂದು ಮಾಡಿದ್ದೀರಿ CRP ಲಿ ಹೆಂಗೆ ಫ್ರಾಡ್ ಆಗುತ್ತೆ ಅಂತ. I will just read.
I'm dismissing this revision. Why do you want to argue?
ಅಲ್ಲ ಯಾಕಂದ್ರೆ ನಾನು 2008 ಕೇಸ್ ಹಾಕ್ತೇನೆ ಇವ್ರ ಮೇಲೆ. ಹೇಮಂತ್ ಕುಮಾರ್ ಈಸ್ ಇನ್ US. ಒಂದು ನಿಮಿಷ US. ನಾನು ಪಾರ್ಟಿಷನ್ ಡೀಡ್ ಅಲ್ಲಿ ಎಕ್ಸಿಬಿಟ್ P9 ಪ್ರೊಡ್ಯೂಸ್ ಮಾಡ್ತೀನಿ. ನಾನು ಪಾರ್ಟಿಷನ್ ನನ್ನ ಎಜೆಕ್ಟ್ ಸೂಟ್ ಅಲ್ಲಿ ಇವ್ರು ಅಪಿಯರ್ ಆಯ್ತು ಅಂದ್ರೆ ಅದರಲ್ಲಿ ನನ್ನ ಅಮೆರಿಕ ಅಡ್ರೆಸ್ ಇದೆ, ನನ್ನ ಮಾವನ ಅಡ್ರೆಸ್ ಮೈಸೂರಿದೆ. ಇವ್ರಿಗೆ ಗೊತ್ತು ನಾನು ಎಲ್ಲಿ ವಾಸ ಮಾಡ್ತಾ ಇದ್ದೀನಿ ಅಂತೇಳಿ. ಆಯ್ತು ಸ್ವಾಮಿ. ಇವರು 2013 ಏನ್ ಹೇಳ್ತಾರೆ, 4 ಅಗ್ರಿಮೆಂಟ್ ಮೇಲೆ ಹಾಕಿರೋ ಕೇಸ್ ನೋ ನೋವೇಷನ್. ಆಮೇಲೆ ಏನ್ ಮಾಡ್ತಾರೆ ಇವರೇ ಕೇಸ್ ಹಾಕ್ತಾರೆ. ಇವ್ರು ಕೇಸ್ ಹಾಕಿ ಎಕ್ಸಿಬಿಟ್ P9 ಪ್ರೊಡ್ಯೂಸ್ ಮಾಡ್ತಾರೆ. ನನ್ನ ಪಾರ್ಟಿಷನ್ ಡೀಡು
ಲೆಟರ್ ಸ್ಟೇಟ್
ದಯವಿಟ್ಟು ತೋಡ್ತಾರೆ. ಎಲ್ಲಿ ತೋಟದ ಸ್ಟೆಪ್ಸ್ ನಾನು ವಾಸನೆ ಮಾಡಿಲ್ಲ. ನಾನು ಸ್ಟೂಡೆಂಟ್ ಇದ್ದಾಗ ಅಮೆರಿಕ ಹೋಗಿ ಸೆಟ್ಲ್ ಆಗಿ ಅಲ್ಲೇ ಮದುವೆ ಆಗಿ ನಾನು ಅಲ್ಲೇ OCI. ನಾನು ನನ್ನ ಹೆಂಡತಿ ಕೂಡ OCI, ನನ್ನ ಮಕ್ಕಳು OCI ಎಲ್ರು ಸ್ಟೆಪ್ಸ್ ಎಲ್ಲಿ ತೋಳ್ತಾರೆ ಇವರು. ನಾನು ವಾಸ ಮಾಡಿದ್ರು ಜಾಗಕ್ಕೆ ತಗೊಳ್ತಾರೆ. ಆಯ್ತು ಸ್ವಾಮಿ. 249 ನಾನು 17 ಕೇಸ್ ಹಾಕಿ ನಂಗೆ ಗೊತ್ತಾಗ್ಕೊಳ್ಳೆ ಅದು ಏನು 14ರಲ್ಲಿ ಎಕ್ಸ್ಪಾರ್ಟೆ ಸ್ಪೆಸಿಫಿಕ್ ಪರ್ಫಾರ್ಮೆನ್ಸ್, ಸೇಲ್ ಡೀಟ್ ಎಕ್ಸ್ಪಾರ್ಟೆ ನೋಡಿ ಸರ್ವಾಗಲ್ಲ. ಆಮೇಲೆ ಪೊಸೆಷನ್ ಹೇಳಿದ್ರು ದೇವ್ರ ಸ್ವಾಮಿ. ನಾನು ಪ್ರೂಫ್ ನನ್ಗೆ ಗೊತ್ತಾದ್ಕೊಳ್ಳಿ ಏನಾಗುತ್ತೆ, ನಾವು ನಮ್ಮ ಟೆನೆಂಟ್ಗೆ ಒಂದು ನೋಟಿಸ್ ಬರುತ್ತೆ ಇದರಿಂದ ಅಂಡರ್ ವ್ಯಾಲ್ಯೂಷನ್ 17ರಲ್ಲಿ 14ರಲ್ಲಿ ಸೇಲ್ ಡೇಟ್ ಆಗಿರೋದು ನಾವು ನೋಡ್ತೀವಿ. ಇದು ಮೈ ಕ್ಲೈಂಟ್ ಇಸ್ ಇನ್ ಅಮೆರಿಕಾ, ಹರ್ ಫಾದರ್ ಇಸ್ ನಾವು 85 year DYSP. ಅವ್ರು ಮಾಡ್ಕಲ್ಲ, ಅವ್ರ ತಮ್ಮನಿಗೆ ಹೇಳಿ ರಿಕ್ವೆಸ್ಟ್ ಮಾಡಿ GPA ತರಿಸಿ ಕಾಪಿ ತೆಗಿಸಿ ಹುಡುಕಿ ಮಾಡಿ ಆಮೇಲೆ ಏನು ಮಾಡಿ OS ಹಾಕಿ ನಾವು ಏನು ಮಾಡಿ ಸ್ಟೇ ತೊಗೊಳ್ತೀವಿ. ನಾಟ್ ಏಲಿಯನೇಟ್ ಪರವಾಗಿ ಸೇಲ್ ಡೇಟ್ ಆಗ್ಬಿಟ್ಟಿದೆ ಇವರಿಗೆ. ನಾನು ಸಾಹೇಬ್ರಿಗೆ ಕೇಳಿದೆ ಸ್ಟೇ ಕೊಡಿ ಸಮಯ ಪೊಸಿಷನ್ ಬಗ್ಗೆ ಅಂತ ಕೊಡಲಿಲ್ಲ. ಇವ್ರೇನ್ ಮಾಡ್ತಾರೆ, ಕೇಸ್ ಪೆಂಡಿಂಗ್ ಇದೆ, ರೂಪಾ ಹೇಮಂತ್ is a legal heir. We have said my husband has died, I filed suit here. He files execution in the mayor court, takes a warrant against dead Hemant Kumar and disposes me when this OS is pending. Immediately next day I file my application, I get back possession, I am in possession of property. Everywhere it is been. 4 agreements ಸ್ವಾಮಿ, 4 agreement. ನೀವು 2008 ಅಪಿಯರ್ ಆಗ್ತಿರಲ್ಲ, 3 ಅಗ್ರಿಮೆಂಟ್ ಇಟ್ಕೊಂಡಿದ್ದಾರೆ 2007. ಯಾಕೆ ಹೇಳಿಲ್ಲ ರಿಟರ್ನ್ ಸ್ಟೇಟ್ಮೆಂಟ್ ತಾವು? You don't. So therefore, Edward Coke of England 300 years ago has said what is judicial and fraud. This is reported by the Supreme Court in the judgment of 1987. And your lordship in CRP, in CRP, what is it? Your lordship in CRP have used not once what Supreme Court has used the adjective unscrupulous litigants. In CRP, what your lordship has passed an order 159/21 tabe helidiri. How this ex parte orders, how orders are got by playing not misuse of the court procedure, abuse of the court procedure. Either tabe helida. And at every stage, your lordship, he has played fraud on the court. You knew the address, you had exhibit P9, P10, my partition deed, you yourself have produced in specific performance. And after taking summons, you take a public notice where my father-in-law is in Mysore, I'm in US. How do I know? And 14th of Senate told the ex parte. Notice over. By the therefore, your honor, it appears within 6 months, 3 months, I'm ready with the trial court.
How is related?
CRP
His
dismissed.
father is related to
Judicial fraud. CRP dismissed, trial court to dispose of the suit as expeditiously as possible, at any rate, within a period of 6 months from the date of rest of the copy of the, since both the parties are present, they shall appear before the trial court on ಯಾವ date? When will you appear?
After vacation on date.
Vacation appear ಆಗ್ತೀರಾ?
Huh?
Vacation ಆದ್ಮೇಲೆ appear ಆಗಿ.
ಅಷ್ಟೇ. ಯಾಕಂದ್ರೆ
I
I will also,
heard the argument.
I will also be not after 26th of April. Therefore,
3rd June. Both of you to appear with the trial court on 3rd June.
please.
3rd June.
3rd June, both
Trial court.
Lordship, I am for the petitioner, item number 28.
My lord, can you have it passed over senior? We are ready to.
Pass out. ಏನಕ್ಕೆ pass out?
The request to be finally disposed of. Records may be necessary.
ಏನಕ್ಕೆ?
Because 3C2 proceedings. ಮಾಡಿದ್ದಾರೆ ಅಂತ ಹೇಳಿ there is no record.
Who sought for vacating?
I filed a application.
What is your ground of attack?
My lord, one is, my lord, 3C2 order is not passed. National Highways Act. ನಾವು objections ಹಾಕಿದ್ದೀವಿ. Records may be necessary.
ಆಗ್ಬೋದು sir, can call for the records.
Relist. Records to be produced
And
by
date may be fixed.
counsel appearing for the respondents.
Interim order.
Interim order to continue to the next date of hearing.
ಆಗ್ಬೋದು. 23rd, sorry, 23rd. 21st or 23rd? 23, much of it.
Think for the petitioner in this matter.
This matter requires to be heard, my lords. In fact, it was listed last week and my lords, I understand it was adjourned to a post vacations now. An early hearing IA has been filed. There's an interim order of status quo, my lords. Moreover, my lords, I have filed a memo on 21st March 23, bringing to the court's notice, my lords, that this very survey number has gone up till Supreme Court. And the entire survey number, my lords, it has been upheld. So I may only point out that Supreme Court order, my lords.
Are you ready now or you want time?
If my friend is ready, my lords, I can, I only seek court's permission to place the Supreme Court on order on record, my lords.
We are ready, my lords.
Yes.
Lords, may I take your lordship to own that Supreme Court judgment which has covered this entire survey number and the acquisition has been upheld?
Let him finish.
Yes.
Lords, as an opening statement, the Supreme Court proceedings, we are not party to the proceedings at all, my lords. Therefore, nothing is applicable
Challenging
to
a
us.
notification of the year?
Yes, sir. 1967 is the final notification, my lords, which is at Annexure C.
57 years ago.
Yes. My lords, the entire series of proceedings happens like this, my lords. One Mr. Chinnappa Reddy is the entire owner of the property in survey number 13. In the year 1935, there is a partition deed executed, my lords, which is as Annexure A, through which Chinnappa Reddy becomes the owner of the property. Subsequently, my lords, Chinnappa Reddy's son, Ramaswamy Reddy, who happens to be the propositors of these petitioners in this case, my lords, he inherits the property, and in the 1964, my lords, a partition deed came to be executed, thereby Ramaswamy Reddy became the owner of the property. In the interim, my lords, preliminary notification came to be issued on 21/5/1966 and final notification subsequently on 17/2/1967. It is the contention of this petitioner that, my lords, subsequent to the final notification, there was no award passed, no amount deposited in the court, which is evidenced by, my lords, the A register which has been maintained by the BDA and produced at Annexure E, my lords, at page number 91 is the typed copy.
No award is passed, madam?
It is passed. Compensation has been deposited, my lords, way back in 1972, my lords.
It is A registered maintained by the BDA, my lords. In which
What have you produced to show that the award is passed?
Lords, lordships may kindly take my statement of objections filed on 27 January 23, my lords.
only a office note at Annexure R1 has been produced, my lords. No details.
Where is the award, madam?
Lords, award is not on record, my lords. Lords, may I, my lords, take lordships? So what I have produced is a file noting, lords, at page 5 of my objections.
No, where do you say the award was passed? On which date the award was passed?
Lords, whereas R1, page 5, your lordships get with my statement of objections, my lords.
They don't refer anything to the award, my lords. They say that on
Lords, I will
3/3/1970.
take your lordships to final order, my lords, of this very 7/13. Entire extent is 5 acres, 9 guntas, which was subject matter of litigation before a writ petition.
Is
before
there a
the
finding in the earlier proceedings that the award is passed?
Yes, my lords, I will take it.
Defend.
Please, my lords. Your lordships may kindly take memo filed by me, my lords, on 21st March 23, my lords.
When?
Please, my lords. 21st March 23, my lords.
Yes.
Lordships get that, my lords.
Yes.
May I, my lords, take your lordships' attention to Annexure 3, page 26, my lords. Please, my lords. This was filed by one of the family members in the with the petitions, my lords. May I now take your lordships to para 11 of that order, my lords. At page 28, my lords. Para 11, my lords. May I read, my lords?
No, there they have said the appellants have received the award amount on 30/11/17. Who are the appellants there?
There are the extended family of the petitioners, my lord. Jairam Reddy and
My
the
lords.
one of the brothers of Chinnappa Reddy, under whom the petitioners claim. May I take lordships to the averment, my lords, what was before this Honorable Supreme Court? Para 6, my lords. I think your lordships read that very paragraph, my lords.
Yes.
Yes, my lords, now para 11, my lords, where the Supreme Court records.
No, had they filed the suit?
They were also, my lords, partition
not
suit
file the
was.
suit, my
No, in
lords.
fact, your
We need
lordships
to
got to see
clarify that
order of this
aspect
Honorable
before
Court dated 11/4/23, my lords. There was a direction by this Honorable Court to the petition to produce the partition suit, my lords. This Honorable Court also on 11/4/23, my lords, passed a direction to asking the petitioners to place on record partition suit details, my lords.
My lords, Jairam Reddy claiming to be
Entire thing is concluded, my lords. Entire 5 acres, 9 guntas the scheme, everything is done, my lords. Compensation is deposited, award is passed.
My lords, they have been mixing up the entire thing.
No, my lords.
Here, my lords, at Annexure D, I myself have produced a judgment of the Honorable Supreme Court in civil appeal, my lords, in which Jairam Reddy files a case against me, in which, my lords, it is held that he is not a part and parcel of this family.
Declaration, correct?
Yes, my lords.
Was your name in that revenue records?
No, the records does not contain my name, my lords.
Whose name was there?
My propositor's name has been contained in the record, my lords. Chinnappa Reddy.
When did your propositors die?
He died long back, my lords, sir. But I may have to confirm, my
And
lords.
there
but-
was no obligation for them to notify you.
They did not have any obligation to notify, but I continued in possession of the property and they did not disturb my possession of the property, my lords. They did not pass an award. And subsequently, my lords, they also did not deposit any compensation till date. Therefore, my lords, they are only producing a note sheet stating that that is all the document that they have.
If
And
you
even
come
in
to
the note
court
sheet.
after 60 years, where can they get all these
My
records?
lords, I draw the attention of this honorable court to Annexure D, my
Supreme Court
lords.
has said in a connected case of the same survey number that the award was received by the appellants therein.
I was not a party to the proceedings at all, my lords.
You may not be party. You cannot come after any time that you want to the court.
My lords, here I draw the attention of this honorable court to Annexure D, my lords. There was an internal dispute going on in our
Para
family,
18
my
of
lords.
Supreme Court says entire extent of 5 acres, 9 gutas, possession has been taken, award is passed. Para 18 of the Supreme
That
Court
was not
order.
a specific finding of that honorable court, my lords,
He's
because
bound by it, my
that
lords.
was. I draw it to Annexure D, my lords, at page number 76. There was an internal dispute going on in our family, my lords. Therefore, I could not approach before this honorable court. And that is the reason for the
Be a
delay.
ground.
My lords,
Can that be a ground?
my lords, I am in continued possession of the property, my lords. So far as my extent of property is concerned,
Supreme Court says if the land vests with them, if you continue in possession, you are a trespasser.
my lords, if I continue in possession without any question, my lords, even after 30 years, I
That is what the
gain an
Supreme Court
advance
has-
possession of the property, my lords.
That's what they've said. You're a trespasser. That is all. Nothing more.
Even assuming that, my lords, I am a trespasser, after 30 years, I gain an adverse possession of the property, they cannot evict me from the property, my lords. And this honorable court, my lords, had directed for a joint survey to be conducted.
What happened?
And as per the joint survey, my lords, I was required to be present in the BDA office and accompany them, my lords. But though my presence was there in the BDA office, nobody notifies me. They directly go on to the property. They say that we have already captured the photographs of the property. They produce a report before this honorable court stating that
It's a
the
vacant
complaints has been done.
It's
It
in,
is not
it's
a
in
vacant
BDA's
property, my
possession.
lords. Yeah, I was in possession of the property
Not
and
at all.
I have produced the photographs, my lords, stating that I am in possession of the property. But subsequently, my lords, they demolished a portion of the property that is belonging to me during the pendency of the writ petition, my lords. And they have now, my lords, produced a part of the photograph. If an appropriate survey is conducted, my lords,
Not very convinced that you have a case to challenge an acquisition of the year 67. You admit that the kata was standing in the name of your propositors.
yes, my lords.
He did not challenge the acquisition. Or even if he did, you don't know. You claim that you are in possession.
My lords,
On that basis, can I suggest an acquisition of the year 67?
my lords, but position caters to the, because there is a lapse, my lords.
Possession. If you're in possession on that ground, I can quash the notification.
The scheme itself lapsed, my lords, because they have not taken our position. They have neither passed an award and deposited the
Section
amount.
27 says scheme should be substantially executed in the entire area, not your side.
Yes, my lords. but
Layout has been formed there.
Even as per the category A register, my lords, they say that it is a built up area and they have not passed an award. And this extent of, I have not been subjected to appropriate legal recourse, my lords.
No.
It's Honorable Supreme Court, my lords, I'll read just one line, my lords. It says, notification in respect of entire 5 acres, 9 gutas had been issued and possession of the land had been taken long back. Is a finding of the Honorable Apex Court, my lords.
My lords, if the matter is taken up on the next Monday, my lords, I will produce necessary documents. I will also get
What will you
instructions.
produce to show that you had no right when the notification was issued?
My lords, when the notification was issued, I had no right, my lords.
Then that
But
there ends the matter.
Subsequently, my lords, my position over the property, for which, my lords, there are substantial citations of the Honorable Supreme Court as well as this Honorable Court, my lords. I will place it on record, my lords. It may be taken as final, my lords. As finally, a date may be fixed, my lords, on which day I will close my argument, my lords,
Monday.
making this question. That's all.
Let's let them serve a copy in advance so that I'm also prepared on 15th.
You don't have the copy of the award with you?
I will, meanwhile, try and procure it.
Commissioner. Defendant's revision petition against the order of rejection of his application for rejection of the plaint filed under Order 7 to 11 A and D.
Where is the plaint?
Let kindly peruse, you will also find it at ink page number 41.
Suit for?
Suit for mere partition without challenging. Admittedly, the alienation, she admits the alienations made way back to 2.5 decades prior to the suit.
Where does she admit?
Let she admits, kindly peruse paragraph 4. In page 43. The plaintiff submits that the third defendant is the father of the plaintiff and he has not looking the plaintiff properly and she is residing in her mother's parental home from childhood. The plaintiff recently heard that the defendants 1 to 7 have colluding with each other without knowledge of the plaintiff, sold the item number 1 property and item 4 property in favor of 8 defendants and also sold item 2 properties in favor of 9 defendants.
That she has sold the property, that they have sold the property anta?
Paragraph 4 ಅಲ್ಲಿ ಹೇಳಿದ್ದಾರೆ.
Date ಎಲ್ಲಿ ಕೊಟ್ಟಿದ್ದಾರೆ?
Date ಇಲ್ಲಿ ಹೇಳಿಲ್ಲ. She relies on the encumbrance certificate she produces. Under Order 7 Rule 14, she relies on those documents, she produces it. It's a part of the plaint. That's what the apex court has said. It needs to
Item number 1 is to
survey number 330.
Item number 1 and 4 is in favor of 8 defendant. Item number 2 is in favor of 9th.
I'll submit your assessment. Kindly peruse. Kindly bear with me for a moment.
What is the first sale lead?
6/12/2005. Kindly peruse in page 62. In page 62, the encumbrance certificate which she relies on produces it under Order 7 Rule 14, which is registered on 7/12.
She has produced this along with the
She
plaint?
produces all these along with the plaint. Kindly notice this. This is sold by
First sale lead ಎಲ್ಲಿ ಇದೆ ಅಲ್ಲಿ?
7/12/2005. The first entry will also find it in page 62. 62.
In this case, my lord, first of all, my lord, the original plaintiff is one.
Family, I'm sorry to interrupt.
One Jyoti.
The whole properties were, the family was
Year of
directed of properties
2020,
in
you have filed
2005.
a suit for partition. After that, my lord, in pendency of the suit, you have purchased of the property in the 2022. In the meantime, my lord, the original plaintiff, you have filed the memo for withdrawal, dismissal of the plaintiff. After that, my lord, the respondent number 1 and 2, this petition 2 and 3, my lord, in this petition, you have filed the application before the trial court for transposition of the plaintiff of the suit.
You filed the suit for partition.
She did not. I'm sorry to interrupt. I mean, pardon me. The original plaintiff, they are defendant 6 and 7.
Who are you?
I am the plaintiff number 2 and 3.
Gaurama and Ratna.
ಅದ್ರಲ್ಲಿ ಏನಾಗಿದೆ ಅಂತಂದ್ರೆ ಬಿಫೋರ್ ಟ್ರಯಲ್ ಕೋರ್ಟ್ after purchasing of the property, pending of the suit, a purchase of the property in the year of 2022. The suit filed by the original plaintiff on Jyoti in the year of 2020. After that, my lord, in the meantime, you purchase ಮಾಡಿದ ಮೇಲೆ ಏನಾಯ್ತು, you have filed a compromise between the original plaintiff on Jyoti. You have filed the memo for withdrawal dismissal. Immediately, the respondent number 6 and 7, you have filed the application before the trial court for transposition of the plaintiff number 2 and 3.
So even now, you are accepting the plaint governments.
I am not in accepting the
the
plaintiff. In the meantime, ಏನಾಯ್ತು ಅಂತಂದ್ರೆ ನಾವು ಹಾಕಿದ ಮೇಲೆ immediately you file an application for rejection of plaint. The rejection of plaints may not file the memo.
ಇವಾಗ what is your claim that the property is that of ಯಾರ property ಇದು?
ಇದು ancestral properties ಮೇಲೆ.
ಯಾರ್ದು?
ನನ್ನ ತಂದೆದು.
ಹೆಸರೇನು ತಂದೆ ಹೆಸರು? ದೊಡ್ಡಬಸಪ್ಪ.
ಅಲ್ಲ, ಮಾದಪ್ಪ.
ಮಾದಪ್ಪ.
ದೊಡ್ಡಬಸಪ್ಪ ದಿ ಗ್ರ್ಯಾಂಡ್ ಫಾದರ್.
ಮತ್ತೆ ಎಲ್ಲ ಕಡೆ ಎಲ್ಲ
ದೊಡ್ಡಬಸಪ್ಪ.
ದೊಡ್ಡ ಸುಬ್ಬಪ್ಪ.
ಹೌದು, ದೊಡ್ಡ ಸುಬ್ಬಪ್ಪ.
ದೊಡ್ಡ ಸುಬ್ಬಪ್ಪ. No, they are daughters of Madappa. Let me make the facts clear. Can you consider survey number 337/2, which was not the subject matter of the suit, filed in 2020.
No, they are the daughters of whom?
Daughters of Madappa.
The original plaintiff was the daughter of Madappa. That is the son of Dodsubappa, correct? Now plaintiffs 2 and 3 are the daughters of Dodsudappa. So the suit was filed by the granddaughter first.
Granddaughter.
Now the suit is now being continued by the two
daughters who are already defendants 6 and 7. In 2020, the suit in 2020 itself was expressly barred by law of limitation and even hit by section 34 of the specifically fact. None of the alienations of
ಅದ್ರಲ್ಲಿ
2005
ಏನಾಗಿದೆ ಅಂದ್ರೆ
challenged
after
till
the
date.
memo filed by the plaintiff, original plaintiff, immediately you file an application for transformation. Of transformation application is allowed before trial court. Immediately you file the application
ನಿಮ್
before.
ತಂದೆನೇ ತಾನೇ ಮಾರಿದ ಜಾಗ ಇದು.
ಇಲ್ಲ, ನಮ್ಮ ತಂದೆ
ನಿಮ್ ಬ್ರದರ್ ಮಾರಿದ್ದು.
ನನ್ನ ಬ್ರದರ್ ಮಾಡಿ, but without my signature of the property, see, ancestral property, without my signature of the property, without my knowledge of the property. It was sold on the year of 2005. This petitioners, my lord, your pendency of the suit, your purchase of the
But
property.
this is after 20th of December 2004, isn't it?
Lord, truly, my
They
lord,
don't have to challenge the sale deed then.
Lord, with due respect, no, my humble submission to lordship. They are all 60, 70 years aged, fairly well, and they are all comfortably placed elsewhere. What they do is, they don't file the suit. The suit is filed by the sole Jyoti, the daughter of one of the sons. She also files a memo later after this revision is filed. Fairly well.
Yeah, we challenge the order transposing them as plaintiffs.
No, my lord, that has not been done.
No.
They are entitled to file a suit for partition. If the sale was prior to 20th of December 2004, I would have rejected the plaint.
Lord, my humble submission to lordship.
Now there's nothing that it's on
Lord,
7th.
they can't, my lord, they, Lord, the law, as your lordships are aware, my lord, settle also on the point by the apex court. Without challenging those alienations, even
Don't have to challenge the alienation. They are agreeable for the alienation made in so far as that share is concerned. Their share they could not have sold.
my lord, it is their father, property had.
Father, not father.
But, as on that day, my lord,
Jyoti's
they-
father, yes, not Rattamma's and Gauramma's share, brother.
One minute. Still. It's still 2,000. One minute. Still copy, sir. My lord, if your lordships were to look at that, my lord, even then with the Amendment Act, section 6(3) would come into play. My lord, the father was dead long prior to the Amendment Act.
ಎಲ್ಲ ಆಯ್ತಲ್ಲ ಇನ್ನೇನ್ ಮಾಡೋದು.
My lord, with due respect, my lord, all the sons and even the widow, all of them have joined and they have sold the property.
ಅಷ್ಟೇ ಅಲ್ವಾ?
Not my humble submission to your lordships is this. I just wanted to place for your lordship's consideration that without challenging those alienations, it can't be maintained.
I've already held in one case that it's not necessary for a person who is not a party to the sale deed to challenge the alienation. They may have no objection for the sale of that particular co-parsoner.
My humble submission, I have one other respectful submission. Survey number 337/2 was not the subject matter of the suit, plainly produced originally.
ಇಲ್ಲ ಪ್ಲೇನ್ ರಿಜೆಕ್ಟ್ ಮಾಡಕ್ಕೆ ಏನ್ ಗ್ರೌಂಡ್ ಹೇಳಿ ನಂಗೆ ಸಾಕು.
The ground is that one is it's an ex facie barred by limitation, and it is also hit by section 34 of the specifically fact. These are the grounds which I am attacking.
The one Jyoti.
But she has already conceded, I'm sorry, I need to place that fact on the court.
One
She has
Jyoti.
already withdrawn the suit, it is permitted to be withdrawn. The suit is dismissed.
One Jyoti, granddaughter of Dodasubappa, instituted a suit for partition in respect of 3 agricultural properties. However, subsequently, Jyoti filed a memo seeking to withdraw the suit, and at that stage, her aunts, who were originally defendant number
6 and 7.
6 and 7, made an application to transpose themselves as plaintiffs 2 and 3, and the said application was granted.
I mean, pardon,
And consequently,
I mean, when they got transposed, I was not even a party. The petitioner was added.
not challenged it.
Lord, I was added 1.5 years after that. And even this
Consequently.
my property was included later.
Consequently, 6 and 7 defendant became the 2nd and 3rd plaintiffs. Next, the plaint governments indicate that the properties were joint family properties and the properties had been sold in favor of 8th and 9th defendant, and the 9th defendant had in turn sold the property that it had purchased in favor of the 10th defendant. And counsel for the petitioner dash 10th defendant submits that the very encumbrance certificate produced by the original plaintiff would indicate that the property had been sold on 7/12/2005, and the suit was filed in the year 2020, and it was therefore clear that the suit was hopelessly barred by time. It is to be stated here that the sixth and seventh defendant are not parties to the sale deed executed in favor of the ninth defendant, who in turn sold the property to the tenth defendant. This court in Munithayama's case has already held that if a person is not a party to an alienation / sale deed, it would not be necessary for him to challenge the same, since it is quite probable that the alienation made by a co-partner, insofar as his share is concerned, is acceptable to that person. It is therefore clear that the second and third plaintiff, that is Gaurama and Ratnamma, who were originally 6 and 7 defendant, need not challenge the alienations made by their siblings in favor of the 8th and 9th defendant, since it is contended by the original plaintiff and continued by the present plaintiffs that the suit property was joint family properties and they had a right by birth, they will be entitled to seek for partition. In this case, it is also noticed that the alienations are made after 20th of December 2004, and therefore those alienations would not be saved even as per the amended provisions of section, by the proviso to the amended provisions of section 6 of the Hindu Succession Act. It is therefore clear that there exists a cause of action for the second and third plaintiff to file a suit for partition. The trial court, in my view, has correctly come to the conclusion no case was made out for rejection of the plaint. The CRP is therefore dismissed.
I mean, pardon, these rulings may made a part of it. And though I have not about it entirely, I'm sorry. Mr. Lordship, so dictating, I did not want to interrupt. Punish it.
Gain point, Malivela.
No, one is two judgments with respect to the ex facie limitation barred by limitation. The other thing is, not lies and done, point out 7 Rule 14 when documents are relied on,
I'm accepting that.
Hence, I'm not troubling your office with those. With respect to ex facie barred by limitation, I'm relying on the judgments, which I'll point to.
ಯಾವ judgment?
One is this Swapan Sukhdev's case. The second one, 2004, second judgment.
And?
And your lordship would also find 2006, volume 5, SCC 353, third one.
Then consider the petitioner sought to place reliance on the judgments rendered by the Supreme Court in 2004, volume 3, SCC, page 137, and 2006, 5.
2 to 9.
2 to 9.
And also 11.
243, 2004, 3, SCC 137, 2006, 5, SCC 353.
Even 2007, 15 SCC 174.
2007, 15 SCC 174 to content.
And including serial number 11, except 10 and 1, where that is under order 7, rule 14. Even a judgment of this honorable court in CRP also have.
In limitation,
may I just point out? If your lordship were to be looking at the second one, I'll point. Notes. Can you produce para 11? Para 11. Because it does not make out a cause of action, is illusory. Section para 11.
To contend that a real cause of action had not been set out, and the plaint was, and the cause of action pleaded was purely illusory. Next, as already noticed above, the simple case of the present plaintiffs was that they had a right by birth in the joint family properties and that they were entitled to seek for partition of the said properties. If the plaintiffs were able to establish this particular fact, they would definitely have a cause of action. And therefore, these rulings would be of no assistance to the petitioner.
This matter. So Friday, I took time to place some documents, because I could not secure those documents. For this reason, my lord.
What is the suit for?
A partition. There was an earlier round of litigation before this honorable court in RSA. My lord, so 215, it is for admission. I have a say in the matter. I am challenging the suit based on the pleadings of the plaintiff. If that is not so.
Rejection of plaint, huh?
Yes, my lord.
Where is the plaint?
Plaint is. Page 115, annexure came.
115. Yes. You are which defendant?
I am for defendants number 213.
Suit for?
Suit for partition filed by an alleged daughter claiming to be the. She claims that she is the daughter of second marriage.
She is the daughter of?
Second marriage. That is, that she claims. She is the wife, she is the daughter of second wife.
She is a daughter.
Daughter. She alleges.
Who the second wife?
She alleges that is not.
And you are?
I am a wife and first wife and son of the defendant number 1.
First wife and son of the
defendant number 1.
Sampangi Ramaya, na?
Yes, ma'am. He is still alive. And the suitable properties are ancestral properties.
You are for D2 and D3.
Yes, Milan.
D2 is Rakesh.
D2 is son, D3 is wife.
Wife of?
Defendant number 1.
Defendant number 1, Sampangi Ramaya anta ide, illi wife of KB Ravi Kumar anta ide.
They have made it. They have made that point. It is not in dispute that the defendant number 3 is the wife of defendant number 1.
It is
First title
disputed.
indicates something.
Last title, they have put it like that, Milan.
Where do they admit that they are the first wife?
They admit in the 4th para of the state. That the father of the plaintiff, it means defendant number 1 was married with defendant number 3 on 30/5/1996. But from the date of marriage, the defendant number 1 and 3 were living together only 3 months. After 3 months, they were jointly filed MC petition under so and so for obtaining divorce before additional principal judge family court at Bangalore. But this petition was dismissed on 28/2/1998 for reasons holding in petition after file the complete of 6 months. It's a clear categorical admission by the plaintiff herself.
Next para 5.
In the meanwhile, that the defendant number 3 filed a complaint. This complaint is still pending for adjudication. Now, the matter before this honorable court is that they admit that defendant number 1 and 3 are the husband and wife. They put some name as wife of third defendant.
No, by your own plaint governments, you are admitting that there was a matrimonial case filed against
Yes, my lords.
you and that was dismissed.
My lords,
So if that is dismissed, even according to your plaint government, she is the wife.
my lord, she is the wife. Later on, my lord, she remarried Ravi Kumar. My lords, out of their wedlock, my lords, this defendant number 2 was born. My lords, there are records to show that in all the transfer certificates, school records, it is a categorical find that
If you admit in para 3,
my lords,
that D3 was married to D1,
D1.
there ends the matter.
My lords, later
As far
on,
as the marriage is concerned,
my lords, I am
if
not
you are
dis-
married subsequently, if you are born out of another marriage of something in Ramaya, then
My lords, first, my lords, I am the second wife's daughter, my lord.
you are
First
the
wife-
legitimate daughter for all purposes.
Yes, yes, my lord. That's what the defense of the defendants.
Lord,
She is an illegitimate child,
my lords,
and that
the-
too,
my lords,
their
they
marriage
are
is not
document-
even annulled before the court to prove that they have got
What
married.
is the second prayer? The decree in OS 18/2000?
My lords, they obtain a decree. My lords, the defendant number 2 files a suit against defendant number 1. My lords, in that he obtains a decree for partition. I am not
Is,
arranged a party in those proceedings.
That is a suit filed by Prabhavati against
My lords, that
Rakesh
is
against his
Rakesh
father.
against his father.
May I leave?
Sampath
May,
Ramaya.
I will make my
And there is a
submission.
compromise there.
No, my lord, it went up to Supreme Court.
There is a decree.
It went up to Supreme Court. And even in the Supreme Court, defendant number 1 has succeeded. He is entitled for partition. And this ground that he is an this ground, all the grounds which has been alleged now in this plaint has been taken up by the defendant number 1 earlier itself. And that apart, before filing this suit, kindly peruse, the appellant has filed one more RSA challenging the suit. OS number 18 filed by Sampath Ramaya. Even that has been disposed of.
Lords, there is an order by this honorable court in the.
Now, whatever it
In
may be.
RSA 2159 of 2018, page 175, my lords. Where, my lords, all these documents were canvassed before this honorable court. Where, my lords, I have been reserved liberty to work out my remedy in the present suit. My lords, kindly refer to 175.
In
Page
the same
175.
proceedings, I have
R.
also been granted with liberty to take up all the defenses in the suit. That's what I have taken up by filing the order 7 rule 11 A and D. my lord. Is that page 175? That's from page 175.
Commences from 185, my lords, para 7. Or in paragraph, my lords, 8, the controversy as it emerges from the respective pleas in the amalgam of the question of fact and the law, including the question whether the appellant could deny the patronage legitimacy of the respondent number 1 after the judgment and decree in OS 18 of 2000 and REA 67 of 2000, and whether this question could be revisited otherwise. These questions are to be part of adjudication in the pending suit in OS 65 of 2016. Any decision of these questions in this appeal would also foreclose such inquiry and tourniquet the proceedings pending in OS 65 of 2016. The appellant, who is also already initiated a suit in OS 65 of 2016, has chosen a recourse and must seek vindication of her case therein. It could be observed without much elaboration, the appropriate remedy are available to each of the parties in the event of the decision of any of the questions. These circumstances do not impel these court to examine the different questions that are canvassed by the rival parties, including the question as to maintainability of the appeal. As such, there is no reasons to follow either the application filed by the condonation of delay, application to leave the prosecute the appeal, and similar reasons. This court is also considered opinion that elaborate reason is not called for at this stage as regard the different rulings regarding so and so. Therefore, this court is of the view that the application filed by the appellant for condonation of delay, leave of prosecute is disposed of, observing that every ground of the appellant seeks to urge in this appeal are very defense that is available to the respondent number 2, including the defense that the appellant has no locus standi to re-agitate the question decided, could be decided in the pending suit in OS 65 of 2016. Accordingly, applications are appeal are disposed of. My lords, in view of this liberty, my lords, this order has reached finality.
Where is the plaintiff, you said, page?
115.
115.
115.
Yes, my lord.
Starts from one.
Because there is in paragraph 5, there is a specific pleading.
What about the fact that if she's an illegitimate child, what is her right? If
No.
she is an illegitimate child,
To be declared as illegitimate child also, they did not even honor their marriage.
we will assume that the marriage
Yes,
is now accepted
Milan.
of Sambhika
Now-
Ramaya with Prabhavati.
Now.
What is the right of,
She is entitled only for the to claim, share in the self-acquired property of her father.
judgment in the Supreme Court, there is a judgment.
Judgments.
Section
Section 16.
Latest judgment, Revan Siddhaya.
One more judgment, Kenchegoda is also.
ಅಲ್ಲ, Supreme Court ಕೊಡಿ ತಂದಿರೋ ನೀವು.
Malords, there is, Malords, one more thing, kindly refer to paragraph 5, Malords, in page 117. Malords, this very same second defendant, Malords, it is a case that, Malords.
My case in this, I have to bring the judgment, Milord, that Revana Siddhappa, I will bring it out, but the case is very simple, Milord.
If she is, let us assume that in the RSA, the first marriage, the parentage of the son is established.
In the suit filed by the plaintiff, the defendant number 1.
Rakesh filed a suit against his father.
Yes, Milord.
That suit has come to an end.
It went up to Supreme Court. In that suit,
Therefore, Rakesh's parentage and his entitlement to a share has become final.
Has been decided and become final, Milord. That is the fact.
Then if that is so, what is the fate of the illegitimate child's right?
Illegitimate child, he is entitled in a share in the father's.
Supreme Court, I don't think that is the right position.
No,
That
has been reversed, Malord.
No, Milord. I'll produce that judgment. Till today, that is that I'll produce it in the next date, or it may be passed over, I'll produce it. Passed over, no, Milord. It may be passed over, I'll produce it.
Monday.
You decide whether pass over or otherwise.
I'll
Pass over.
pass over.
ಎರಡು CRP ಯಾಕೆ?
Two applications for earlier application under order. 7/11 was dismissed.
I have to make submission.
Subsequently,
Asking two, why two CRP?
That's why it is for me to submit before the court. ಅದನ್ನು ಅವ್ರು ಹೇಳಿದ್ರೆ ನಾನು what should I do?
ಹೇಳಿ ಬಿಡಿ, ಯಾರೋ ಒಬ್ರು ಹೇಳ್ಬೇಕು ಅಷ್ಟೇ.
ಏನಾಯ್ತು ಅಂದ್ರೆ Milord, but after the filing of first CRP, first application, they have filed this RSA 2159. It was pending. Then before after the dismissal of that petition, that application filed by me before the lower court, we were involved in this RSA. Then after the disposal of the RSA, I had been granted liberty to take all necessary steps with regard to question the non-maintainability of the suit. Hence, once again, I have filed another article.
ಎರಡು application
Yes,
ಹಾಕಿದ್ದಾರೆ.
I appear for respondent number 2, my.
Yes.
In fact, your lordship, and your petition, Lord, I have engaged the service of senior advocate. And there was some proposal now which required to be decided between the parties. And,
15% with interest ಕೊಡಿ ಅಂತ ಹೇಳಿ.
ಏನ್ ಕೇಸ್ ಹೇಳಿ?
Withdrawal, my lord, in a FDP proceeding, the court has not appointed the court commissioner to auction the property. Lord, without fixing the Lord reserve price as contempt.
Reserve price ಅನ್ನು fix ಮಾಡಿಲ್ಲ ಅದ?
Section 6 of the partition act. Lord, the court has.
ಏನಾಯ್ತು? ಹೊಸಲ ಏನು ಹೇಳಿದ್ನಲ್ಲ ನಾನು? ನೀವು ತಗೊಳ್ತೀರಾ ಅಂತಾನೆ ಕೇಳಿದ್ನಲ್ಲ.
Then, Lord, in fact, my Lord, they. Interest ಕೊಟ್ರೆ interest ಅಂತ ಹೇಳಿದ್ರೆ kindly appreciate. No, 15% it works out to 30 lakhs. Lord, it is.
ಅವ್ರ ಕಾಸು ಇಟ್ ಸ್ಟಕ್ ತಾನೆ.
Your market value 45 lakhs.
Lord, talk with him, Lord. In fact, he has taken the number. We'll have a discussion, Lord, and we'll come back.
I said if you pay interest on that amount at 15%.
You will ask me kindly, and Lord, in fact, Lord, I have filed my objection to the Lord Court Commissioner report. Lord, they have pointed out serious irregularities.
ಅರ್ಗ್ಯುಮೆಂಟ್ ಮಾಡ್ತೀರಾ ಹಂಗಾರೆ ಇವಾಗ?
You have to kindly have this matter next week. You know, other possibility is that we not, I'll report settlement, otherwise,
Wednesday.
Monday.
In these cases, that your lordship said called upon.
Yes,
Deposit
I'm
the
hearing for
maintenance-
the respondent.
Deposit the maintenance that is due. Lord, what has happened, I'm filing my state memos in all the 5 cases, Miller, regarding the amounts which according to us are payable. What has happened is in 56 and 58, Miller, we have deposited the entire money that has been 100% money that has been decreed by the trial court along with interest as on the date of filing of the bill instructions. So far as the current maintenance from 1/4/2024 onwards, we have no difficulty in depositing the money in the court. But so far, what in the memos of calculations filed by them, they have claimed that the amounts which are due for the subsequent period. For the subsequent period also.
First CRP 56-58.
56-58.
What is the maintenance charges?
Millard, in 56, Millard, what has happened is this, Millard. They are claiming a maintenance, future maintenance charges of about 20,925.
Where is your memo?
I have, their memos are there.
ಯಾವಾಗ ಹಾಕಿದ್ರಿ ಮೆಮೊ?
Kindly see 56 Millard first.
2020 ಇಂದ ಕೊಡ್ಬೇಕಾ ನೀವು?
ಇದರಲ್ಲಿ ಏನಾಗಿದೆ, they are claiming amounts from 1/10/2020 to 31/3/2024 also.
What is the amount due according to you?
Millard, according to me, but so far as this particular money is concerned, that is 1/10/2020 to 31/3/2000.
ಇಲ್ಲ ಮಧುಸೂದನ್ 1/4/2019 to 39/2020.
ಅದು
For
amount
which 96,813.
ಅದು along with interest we have deposited the money.
ಅದ್ರದ್ದೇನು ಡಿಸ್ಪ್ಯೂಟ್ ಇಲ್ಲ ಇವಾಗ.
Dispute ಇಲ್ಲ.
ಇದ್ರ ಪ್ರಕಾರ ಹೋದ್ರೆ ಮೇಂಟೆನೆನ್ಸ್
1/10/2020.
ಇದ್ರ ಪ್ರಕಾರ ಹೋದ್ರೆ ಮೇಂಟೆನೆನ್ಸ್ ಎಷ್ಟಾಗುತ್ತೆ? ತಿಂಗಳಾನ, ವರ್ಷಾನ, ಇಲ್ಲ ಕ್ವಾರ್ಟರ್ಲಿನ?
ಇವರು ಕ್ವಾರ್ಟರ್ಲಿ ಕ್ಲೇಮ್ ಮಾಡ್ತಾ ಇದ್ದಾರೆ.
ಎಷ್ಟಾಗುತ್ತೆ ಕ್ವಾರ್ಟರ್ಲಿ? ಅಷ್ಟು ಅಮೌಂಟ್ ಕೊಟ್ಟು.
No, we are ready to pay them.
I have mentioned in the memo filed by me.
Each
I have mentioned, my lord.
4,185 per month according to.
Not mentioned quarterly how much?
In my memo, I have mentioned, my lord.
Kindly see in the top, Millard, filed by them.
No, it is 4,185 per month.
Per month.
So 12,555.
But yes, this money we are ready to pay. There is no dispute about it. What is happening is, kindly see in the memo.
No, but you have to pay from 1/10/2020.
See the particular amount. This is the money which is the subject matter of another suit already filed.
Correct. You deposit the money here. No, they will not take it now. At 12,555 per year from 1/10/2020.
1,84,770 which they have shown. That particular amount, Millard, kindly see. In 56, Millard, actually, the money that is payable is 1,75,770, not 1,84,550. Because what they have done is, they have included penalties also. Penalty.
You admit 12,555
That
per year.
money I am ready to pay.
So from 2020.
Yes, Millard.
You pay 12,555 per year.
No,
Not
per quarter.
That's what
Per
they are.
quarter, my lord.
By
Per
the end of
quarter.
the first
Per
every
quarter.
Per quarter.
So ಎಷ್ಟಾಗುತ್ತೆ ವರ್ಷಕ್ಕೆ ಹಂಗಾರೆ?
Around 49,500. Around approximately.
37,665.
12,555
Sorry, into 4.
into 4, my lord.
50,220.
So far as the calculation given by them, according to my client, 1,84,770 is the money paid.
ಬೇಡ 50,220 ರೂಪಾಯಿ ವರ್ಷಕ್ಕೆ ಕೊಡ್ಬೇಕು. 50,220 ರೂಪಾಯಿ. ಅದನ್ನ 2020 ಇಂದ ಕೊಡಿ ಅಷ್ಟೇ.
110, 2020 ಇಂದ ಕೊಡಬೇಕು. ಅದು 110, 2020 ಇಂದ ಅವ್ರು ಕ್ಯಾಲ್ಕುಲೇಷನ್ ಕೊಟ್ಟಿದ್ದಾರೆ. That is coming to 1,84,770. That we will deposit, subject to their withdrawing of the other suit which they have filed.
The amount will be deposited here.
Yes.
Whoever wins in the suit, the money will go accordingly. You first deposit the money. Why do you want them to withdraw the suit?
And the other aspects is they are claiming interest, they are claiming penalty, all that we cannot pay.
ನಾನು ಅದನ್ನೆಲ್ಲ ಹೇಳಿದ್ನಾನೆ. First, ನೀವು 4 ವರ್ಷ ಕೊಟ್ಟಿದ್ರ ನೀವು enjoyed that property.
What is happening is this, madam. There is no dispute about this particular plan. We'll deposit the money. What has happened is the members of the other association which has been formed by them under the Flat Act, they have also contributed monies to that association. They have spent about 10 lakhs only for the purpose.
ಅವ್ರ ಪಾರ್ಟಿ ಇರ್ತಾನೆ, ಅದಾವಲ್ ಪಾರ್ಟಿ ಇರ್ತಾನೆ.
ಹೌದು.
ಅದಾವಲ್ ಇನ್ನೊಂದಾವಲ್ಲಿ.
ಯಾವ್ದ್ರಲ್ಲಿ?
ಇನ್ನೊಂದಾವ ಹಾಕಿದಾರಲ್ಲ ಇವರು.
Adರಲ್ಲಿ ಈ dispute ಬಂದಿ. What is happening is we have already paid about 10 lakhs of rupees only for buying of the lifts. Lifts were in a very bad condition.
ಆಯ್ತು, now you deposit from 110/2020 at the rate of rupees 12,500.
This figure what they have claimed, 1,84,770 will deposit without prejudice our contentions. And similarly, in other cases also same situation.
Pending disposal of these revisions. Come on. The petitioners herein shall deposit the maintenance charges of rupees 50,220 per year, bracketly at the rate of 12,555 per quarter.
Your
From
lordship is
110/2020 to 36/2024. And they shall also continue to pay. We said some rupees 50,220.
Deposit, we'll deposit them.
Deposit at the month. Continue to deposit rupees 50,220 every year.
50,000 there.
50,220 per year.
Per year, by 12,555.
The amount so deposited before this court shall be invested in a fixed deposit by the registrar.
Lord, on humble submission, my lord. For the last 6 years, we are maintaining the complex. They are not paying the maintenance, which is casting additional burden on the other apartment owners. 7 people of one family. He is claiming to be the erstwhile builder. He is not paying the money. The other 17 people are taxed. And now lift has been repaired. We got the lift license. We have to repair it, 25 lakhs.
What is the stage of the suit? The other suit that you have filed?
Which one, my lord?
The suit that you have filed.
No, all the recovery suits, first round, we got the orders in our favor. Second round, we have filed it. On the first round orders, they have come on revision petition. The second round suits are pending. That apart, there is one declaration suit is pending where they have challenged the validity of the association. That has to be disposed of. In the meantime,
until the money is safe.
Question of safety doesn't arise. Other people are equity demands. Other people are being loaded with extra burden. Are they getting interest? They are not getting interest.
If I were to decide something in the CRP here, it will affect those suits.
Actually, the CRP itself is not maintainable, my lord. I have got facts to prove before this. Unfortunately,
if you are
I did
ready
not get an opportunity.
If you are ready to argue, I am ready to hear.
I'm ready to argue. I'm ready to argue the matter.
Your lordship may have it immediately after vacation. We'll argue.
Post after vacation.
The
He said
meantime,
amount shall be deposited within a period of 2 weeks.
This deposit order, my lord, may have to.
2 weeks.
My lord, deposit order.
2 weeks.
This has to be deposited in 2 weeks. Okay. I thought, my lord, your lordships are, because the matter itself is going to be heard. The question of deposit may not arise.
No, you should deposit.
Because what is happening?
You should deposit, that is all.
So far as the monies which are due under this case is.
You cannot, you have to pay maintenance charges. There's no escape from.
I will pay the maintenance charges provided, my lord. See, the claims which they have made in the subsequent suits. They are also they are sought to be demanded now.
You first deposit, then let us see.
ಇದು ಇನ್ನ ಈ ಕೇಸ್ ಇಲ್ಲಿ. Other cases also. There are about 5 cases are there.
ನಾಲ್ಕೇ ಲಿಸ್ಟ್ ಆಗಿದೆ.
ಬಂದಿಲ್ಲ court ಮುಂದೆ.
ಇನ್ನೊಂದು ಲಿಸ್ಟ್ ಆಗಿಲ್ಲ. That has not been combined here.
I have filed memos in all the 3 cases. 390 ಒಂದು matter ಬಂದಿಲ್ಲ court ಮುಂದೆ.
Next release next Monday. Post CRP suits along with this matter. From 110/2020 they will deposit.
In all the 5.
Not 110, in some cases, what has happened is, apart from 56 and 58, 110 to 2020, they are In other cases, what is happening is, they are the earlier CRPs. There, my lord, we have deposited 50% of the money as per the orders of this court, as on the date of the filing.
That is in CRP 391, 396.
391, 396 and 300.
So deposit the remaining 50% and continue to pay at the same rate.
For the period subsequent to that filing of this.
CRP 391, 396 earlier. The petitioners shall deposit the remaining 50% of the decretal amount. And they shall also deposit the maintenance charges at rupees 12,055 per quarter.
It will that amount differs from.
I have given,
ಅದೇ ಹೇಳಿ amount.
I have given the memo. In all the 4 cases, I have filed the memo, my lord. I have categorically stated.
In 306, my lord, kindly go to 306. 306 181.
The second page, I have given the per month maintenance and quarterly maintenance.
It was 15,660. From 1/10/2021, remain first to 50% decretal amount, and they shall also deposit the sum of rupees 15,660 per quarter from 1/1/2021.
The amount differs
till 36/2024. 15,660.
Each case, the amount will be different.
391, 396 list ಇದೆ.
391 ಅಲ್ಲಿ, they are claiming 1,760 per square feet per month. That is 5,280 per month.
ಎಲ್ಲಿ ಮಾಡಿದ್ದೀರಾ ನೀವು 391 ಅಲ್ಲಿ? Respondent.
15,840 per quarter in.
15,840 ಮಾಡಿ. 391, 396.
396 ಅಲ್ಲಿ
17,010.
396.
Same from 1/1/2021
17,010.
up to 36.
And one more case is there. 306 ಬಂದಿಲ್ಲ.
306 ಬಂದಾದ್ಮೇಲೆ ಮಾಡ್ತೀನಿ ಮಂಡೇ.
ಅದರಲ್ಲಿ one more thing is, the period would be, it will be different, from 1/1/2021.
ಪೋಸ್ಟ್ ಆಗಿಲ್ಲ, ಪೋಸ್ಟ್ ಆದ್ಮೇಲೆ ಮಾಡ್ತೀನಿ.
ಅಲ್ಲ, ಈ ಎಲ್ಲಾ ಈ ಪೆಂಡಿಂಗ್ ಕೇಸಸ್ ಅಲ್ಲಿ ಕೂಡ ಬಂದಿರೋ
1/10/2021 1/10 1/1/21
1/1/2021.
ಆ ಡೇಟ್ ಇಂದ ಮಾಡಿ ಚೇಂಜ್ ಮಾಡ್ತೀನಿ.
ಅದೊಂದು
58 the same.
Your lordship may say this is without prejudice to our contentions. The deposit is without prejudice to our contentions, which are right.
In CRP 58 it is 7,650 per quarter ತಾನೆ.
ಅದರಲ್ಲಿ ಸ್ವಾಮಿ 3 ಇದೆ, 3 ಯೂನಿಟ್ ಇದೆ, 7,650 for 1 unit. ಇನ್ನೊಂದು ಯೂನಿಟ್ ಗೆ 6,750.
ಟೋಟಲ್ ಎಷ್ಟಾಗುತ್ತೆ?
Totally 1 minute.
They are claiming 20,925 per quarter.
6,750. 6,520.
58 ಅಲ್ಲಿ. They are claiming
20,925. Melos, in CRP number 58 ನಲ್ಲಿ 20,925.
From 1/10/2021.
1/10/20.
1/10/20. Memo check ಮಾಡ್ಕೊಂಡ್ಬಿಡಿ.
Deposit is without prejudice to our contention.
ಇಲ್ಲಿ before this court.
That may kindly be made clear.
I said deposit with this court.
Allah, this is without prejudice to our contentions, that's what I want.
You are depositing, I am not doing anything here. They are not going to take that money.
Yes. Your lordship may kindly give about 3 weeks time, 2 weeks maybe too short, because ತುಂಬಾ ದೂರ.
5 ವರ್ಷದಿಂದ ನೀವು ಕೊಟ್ಟಿಲ್ಲ ಅಂತ.
ಅಲ್ಲ, ನಾವು ಬೇರೆ ಅಸೋಸಿಯೇಷನ್ ಮಾಡಿ ಅಲ್ಲಿ ಕೊಟ್ಕೊಂಡಿದ್ವಿ. According to us, this association itself is illegal.
Madam, 3 weeks.
So it is fact finding has already been done by the lower court.
No, it's all right. The matter is pending before the High Court also.
There are 4 people of family formed one company, formed one company and claiming as if they are.
Not 4 people. He is misleading.
And they have been injected by injective orders by the honorable civil court. Question of their maintaining does not arise.
According to them, 17 members have formed the association. ಅದರಲ್ಲಿ 4 ಜನ
Some matter of fact to be proved in
Department Ownership Act.
trial court.
ಇದ್ರೆ ಆರ್ಗ್ಯುಮೆಂಟ್ ತಗೊಳ್ತೀನಿ ನಾನು.
ಇಲ್ಲ, ನಾನು ಹೇಳ್ತಾ ಇರೋದು because he is claiming
ಫಸ್ಟ್ ಡಿಪಾಸಿಟ್ ಮಾಡಿ ಆಮೇಲೆ ತಗೊಳ್ತೀನಿ.
ಅವ್ರು ಮಾಡ್ತಾ ಇರೋ allegations ನಾನು ಹೇಳ್ತಾ ಇರೋದು.
ಇಲ್ಲ ಅಲಿಗೇಷನ್ ಅಲ್ಲ ಸ್ವಾಮಿ, ಫ್ಯಾಕ್ಟ್ ಹೇಳ್ತಾ ಇದ್ದೀನಿ.
ನಾನು ಫ್ಯಾಕ್ಟ್ಸ್
ಏನಿಲ್ಲ, 4 ಜನ ಸೇರಿ ಕಂಪನಿ ಫಾರ್ಮ್ ಮಾಡ್ಕೊಂಡ್ಬಿಟ್ಟು ಅದನ್ನೇ ಮೇಂಟೈನ್ ಮಾಡ್ತೀನಿ ಅಂತ ಹೇಳ್ತೀವಿ.
ನೀವು ಆರ್ಗ್ಯುಮೆಂಟ್ ಮಾಡಂಗಿದ್ರೆ ನಾನು ಮಾಡ್ತೀನಿ, ದಯವಿಟ್ಟು ಮಾಡಬೇಡಿ.
Posted on Monday. The other CRP will be posted on Monday. I'll pass an order on Monday in that CRP.
Yes, ma'am. ಅದನ್ನ ಆಲ್ಮೋಸ್ಟ್ ಸೇಮ್ ಕ್ಯಾಲ್ಕುಲೇಷನ್ ಮೆಮೊ ಹಾಕಿದ್ದೀನಿ ಆಗ್ಲೇ.
ಆಯ್ತು.
I appear for respondent number
My lords, serial number 36, my lords, I appear for the petitioner. My lord, I request for a short date in this, my lord. Senior is not keeping well. Any date of 16th or 18th, please, my lord. Obliged, my lord.
Petitioner, my lords. My lords, the tenant's petition, my lord, suit for ejectment under section 43(2) of the Rent Act. My lord, the entire right claimed by the landlord, so-called landlord, is based on the will. That is impermissible. When I have specifically objected that he is not the landlord. My lord, he, in the cross-examination, in addition to that, he admits that he is also a tenant. My lord, may I draw the attention of the court to section 43(2), my lords?
How is related to the owner?
He claims that his uncle, so-called uncle, it is not proved, my lord. No evidence to that effect.
It's a registered will.
Please, ma'am.
Where's your objection?
No, I filed application, my lord.
Straight away, no objections.
My lords, I have filed objection. In addition to that, I have filed the of course, in this, I think it is not filed, my lords.
Rent Act code.
(43)(2), my lords.
Where's your defense?
Lords, my lord, I'm sorry, I'm filing my office copy.
para 14 minutes, last.
Now, what is your right to be in this property then?
That's my right.
Denying
It
the
is-
ownership of Ramchandra also.
Yes, because this property belongs to a temple. He is not the owner. He is
Where have
not.
you said that?
No, I have not stated in my this petition, my lords. But because they don't have a right. As a owner, he is not, he claims that I Ramchandra claims that he got the property through a will. That is also incorrect. That will has not been.
It is, you don't claim ownership in this property.
My lord, I don't claim.
What is your status?
My lord, I'm not even I'm in possession of the property, not with the present landlord.
At least landlord ಅಂತ ಹೇಳ್ಬೇಕು ಇಲ್ಲ tenant ಅಂತ ಹೇಳ್ಬೇಕು.
ಅಲ್ಲ ಎರಡು ಇಲ್ಲ, ನಾನು ಪೊಸೆಸರ್ ರೈಟ್ ಮೇಲೆ ಐ ಗಾಟ್ ಎ ಪೊಸೆಸರ್ ರೈಟ್. ಅದು ಇಲ್ಲ ಇದು ಇಲ್ಲ, ಪೊಸೆಸರ್ ರೈಟ್ ಇದೆ.
What is your reply to the quit notice?
That I denied the title also.
ಇದೆಯಾ?
ಇದೆ.
ಕೊಡಿ ಒಂದು ನಿಮಿಷ.
ನೆಕ್ಸ್ಟ್ ಪೇಜ್ ಅಲ್ಲಿ ಇದೆ.
ಏನ್ ಹೇಳೋದ?
ಅಲ್ಲ ಓನರ್ ಅಲ್ಲ ಅಂತ ಹೇಳ್ತಾರೆ.
ನಿಮ್ ಸ್ಟೇಟಸ್ ಏನು?
ಅಲ್ಲ ನನ್ನ ಸ್ಟೇಟಸ್ ಬಗ್ಗೆ
Para 16A, there's an averment that there's a book maintained by Ramchandra indicating who are the tenants and the rent payments that were made.
kindly
So
come
that
to
is a matter
section
for-
43(2), my lord. Section 43(2).
That is for the court to decide. The court has
No.
come to the conclusion.
No, 43(2)(a) ಅಲ್ಲಿ
Yes.
the lease pleaded is oral. That is exactly what is the case herein. And either party denies relationship and no receipt or acknowledgement of payment of rent is referred to in subsection 1 above is produced.
That's why I said in 16A,
Please,
they refer to that book in which rent payments are made.
they claim that it is not, and the ownership is claimed to under the will, whether the small cost
Will
court.
ಯಾಕೆ ನೀವ್ ಯಾಕೆ ತಲೆ ಕೆಡಿಸ್ಕೊಳ್ತೀರಿ will ಬಗ್ಗೆ? 16A, if they prove
Please.
Ramchandra had maintained a book in which he had made an entry regarding the rents paid by you, that is sufficient. You don't have to be, they don't have to push to the civil court.
ಅಲ್ಲ ಅದು I request the court to look into subsection 1, my lords,
Yes.
where in any proceedings, may I read it, my lords?
Yes.
Where in any proceedings before the court, a contention is raised denying the existence of relationship of landlord and tenant as between the parties, it shall be lawful for the court to accept the document of lease, or where there is no document of lease, a receipt of acknowledgement of payment of rent purported to be signed by the landlord as prima facie evidence of relationship and proceed to hear the case. Here, that is not the case. There is no signed copy illa alli.
Para 16A, they refer to a book in which rent payments were.
ಅದಕ್ಕೆ signature illa. That is what I am saying.
It's a matter for trial, right? Not now, not for you to stop the proceedings. ನೀವೇನಾರು ನಿಮ್ದು ಒಂದಿದ್ರೆ ನೀವು you're born there, therefore you can live there forever ಅಂತ.
May I request, I may permit it to withdraw, to urge this, my lords, with the liberty, to urge this contention at the final hearing, my lords.
This revision. So he also seeks liberty to raise the contention of jural relationship at the final stage and during the course of the trial and during the hearing of the proceedings. Liberty sought for is granted. Revision is dismissed as withdrawn.
Grateful, my lords.
ಮೂರು ಅದೇನಾ?
ಮೂರು ಅದೇ ಸೇಮ್. ಅದ್ರಲ್ಲಿ ಒಂದರಲ್ಲಿ ಆಫೀಸ್ ಅಬ್ಜೆಕ್ಷನ್ ಇದೆ, ಅದು ಟ್ರಯಲ್ ಕೋರ್ಟ್ ಅಲ್ಲಿ ಹೆಸರು ತಪ್ಪಾಗಿದೆ, ಅದು ದಟ್ ಮೇ ಬಿ ಓವರ್ ರೂಲ್ಡ್, ಮೈ ಲಾರ್ಡ್ಸ್. ಐ ಹ್ಯಾವ್ ಗಿವನ್ ದ ಕರೆಕ್ಟ್ ನೇಮ್. Please.
Point number petitioner. 5 and 6, 7 now, I filed the wakalat minutes. Wrong mention in the caste list my last. 5, 6, 7. I filed the wakalat. 1 to 4 wrongly. Wrongly mentioned.
ಯಾರಿಗೆ ಮಾತ್ರ ಹಾಕಿರೋದು?
5, 6, 7.
Shimayanagoda NR submits that he has entered appearance only for R.
R5, 6, 7.
ಇವ್ರು ಬೇರೆಯವ್ರಿಗೆಲ್ಲರಿಗೂ?
And the last date, last occasion of hearings, R1 to 4 has undertaken to file wakalat. R1 to 4 has.
ಇಲ್ಲ ಯಾರು?
Lankesh advocate who is appearing for plaintiffs in trial court.
This.
And also I filed a copy has been served with memo.
It is stated that learned
consent have been served on.
Three. ಹೆಸರಿನವ್ರ ಹೆಸರು?
Total 9
name.
L Lankesh, R1 to 4. He is the plaintiffs in the trial court.
ಹೆಸರು?
L Lankesh.
L Lankesh is the counsel appearing for respondents 1 to 4 in the trial court, and copies of the petition have been served on him. Office to print the name of Sri so and so in the cost title as appearing for R1 to R4. ನೀವು ಯಾರಿಗೆ R5 to R7?
5 to 6, 7.
8 and 9?
8 and 9 and 9 has been filed wakalat on.
ಯಾರು ಹಾಕಿದ್ದಾರೆ?
KRJ. On 3, 4, R9 has been filed and.
ಯಾರು ಹೆಸರು ಯಾರು? ಹೆಸರು?
KRJ.
ಇಲ್ಲ ಕಣ್ರಿ. ಕಾಪಿ ಮಾಡಿದ್ದಾರೆ ಅವ್ರಿಗೆ?
ಹೌದು ಸ್ವಾಮಿ.
He also submits that copies of the petition have been served on Sri
KRJ. Jaychandra Reddy.
Yes, name.
Jaychandra.
K. Jaychandra. K. Jaychandra. Office to print his name is appearing for respondents.
9.
9, 8.
8 served models.
Counsel to serve a copy of the petition on the counsel who represents R8 in the trial court. Relist on.
Petitioner, ma'am. Last date of hearing. Your lordship has directed.
Exchange property ಮೇಲೆ liberty may be given to proceed against the exchange property. ನಾನೇನ್ ಲಿಬರ್ಟಿ ಕೊಡೋದು? ನಾನೇನ್ ಲಿಬರ್ಟಿ ಕೊಡೋದು? ನೀವು ಹಾಕ್ಲಿಲ್ಲ ಅಂದ್ರೆ ಹಾಕ್ಲಿಲ್ಲ. ಹಾಕ್ತೀನಿ ನಾನು. ಹಾಕೊಳ್ಳಿ. ಈ ಪ್ಲೇಂಟ್ ಅಂತೂ ಇಲ್ವಲ್ಲ? Plaint has been rejected, isn't it?
Plaint is not rejected. Their application is rejected.
No, now I have to reject the plaint, isn't it?
With liberty.
No, you withdraw the suit with liberty to file a fresh suit. I'll grant you that permission.
Party signature.
Wednesday.
Please.
Withdraw at trial court. They have to withdraw at trial court.
I'll record here. I will record here that they're withdrawing the suit.
For the petitioner, the suit is for recovery of money. The petitioner is the landlord and the respondent is the tenant, my lord. Initially, it is for the lease of for three years.
Okay.
40.
I am for respondent 7 to 10 in this BWSSP in this matter, madam. I'll have to file my statement of objection.
7 to 10. ಇಲ್ಲ 40 ಅಲ್ಲಿ ಒಬ್ಬರೇ ರೆಸ್ಪಾಂಡೆಂಟ್ ಇರೋದು. 40 serial number.
Small cost suit country.
I'm so sorry. I'm sorry, ma'am.
Initially 3 years ಗೆ lease agreement ಆಗತ್ತೆ. 5 ಲಕ್ಷ 5,50,000 is collected by the landlord. Later it was converted as a monthly rent for rupees 6,000 per rent, and he has returned the rupees 5 lakhs, retaining the 50,000 as security deposit. But the case of the respondent is that the amount of rupees 2 lakhs is not returned, and hence he filed an application. He filed the suit wherein the suit was decreed by the trial court. In the very agreement itself, he has made an endorsement, my lord, that remaining amount exhibit ಅಲ್ಲಿ ಬರ್ದಿದ್ದು ಒಂದು ಎಂಡೋರ್ಸ್ಮೆಂಟ್ ಆಗಿ ಭೋಗ್ಯದಾರರಿಗೆ 5 ಲಕ್ಷ ರೂಪಾಯಿ ಹಿಂತಿರುಗಿಸಿ ಉಳಿಕೆ ರೂಪಾಯಿ 50,000 ಮನೆ ಬಾಡಿಗೆ ಅಡ್ವಾನ್ಸ್ ಉಳಿಸಿಕೊಂಡು ಬಾಡಿಗೆ ತಿಂಗಳಿಗೆ 6,000 ಕೊಡುವುದಕ್ಕೆ ಪರಸ್ಪರ ಒಪ್ಪಿಕೊಂಡಿರುತ್ತೇವೆ. ದಟ್ ಈಸ್ ಅಡ್ಮಿಟೆಡ್ ಇನ್ ದ ಈವನ್ ಇನ್ ದ ಎವಿಡೆನ್ಸ್ ಆಲ್ಸೋ.
ಏನ್ ತಪ್ಪೇನಿದೆ ಆರ್ಡರ್?
ಆಕ್ಚುಲಿ ಅದೇ ರಿಟರ್ನ್ ಆಗಿದೆ ಇಲ್ಲಿ ಕ್ರಾಸ್ ಎಕ್ಸಾಮಿನೇಷನ್ ಅಲ್ಲಿ ಕ್ಲಿಯರ್ಲಿ ಅಡ್ಮಿಟ್ ಮೈ ಲಾರ್ಡ್ ಇಲ್ಲ ಆ ದಾಖಲೆ ಅಂದ್ರೆ ದಟ್ ಈಸ್ ದಿ ಇನ್ ದಿ ಎಂಡೋರ್ಸ್ಮೆಂಟ್ ಇನ್ ದಿ ಅಗ್ರಿಮೆಂಟ್. ಆ ದಾಖಲೆ ಕೊನೆಯ ಭಾಗದಲ್ಲಿ ಕೈ ಬರಹದಲ್ಲಿ ಭೋಗ್ಯದಾರರಿಗೆ 5 ಲಕ್ಷ ಹಿಂದಿರುಗಿಸಿ ಉಳಿದ 50,000 ರೂಪಾಯಿ ಮುಂಗಡ ಉಳಿಸಿಕೊಂಡು ಬಾಡಿಗೆ ತಿಂಗಳಿಗೆ 6,000 ಕೊಡುವುದಾಗಿ ಪರಸ್ಪರ ಒಪ್ಪಿಕೊಂಡಿರುತ್ತೇವೆ ಎಂದು ಕಾಣಿಸಲಾಗಿದೆ ಎಂದರೆ ಸರಿ. ಅದನ್ನು ಪ್ರತಿವಾದಿ ಬರೆದಿರುತ್ತಾರೆ. ಬರೆದ ನಂತರ ಓದಿ ತಿಳಿದು ಒಪ್ಪಿ ನಾನು ಕೆಳಗೆ ಸಹಿ ಮಾಡಿರುತ್ತೇನೆ. ಆ ರೀತಿ ಹಿಂಬರವನ್ನು ದಿನಾಂಕ 22/11/2022 ಮಾಡಲಾಗಿದೆ ಎಂದರೆ ಸರಿ. ಸೊ ಅಲ್ಲಿ ಈಗ 50,000 ನಾವು ಏನು ಸೆಕ್ಯೂರಿಟಿ ಡೆಪಾಸಿಟ್ ಅಂತ ಉಳಿಸ್ಕೊಂಡಿದೀವಿ ಅದರ ಬಗ್ಗೆ ಡಿಸ್ಪ್ಯೂಟ್ ಬಿಟ್ರೆ ರಿಮೈನಿಂಗ್ 1,50,000 ಅನ್ನ ಆಲ್ರೆಡಿ ಪೇಯ್ಡ್ ಮೈ ಲಾರ್ಡ್. ಅದನ್ನ ಅವರು ಅಲ್ಲಿ ಒಪ್ಕೊಳ್ತಾರೆ.
ಡಿಪಾಸಿಟ್ ದ ಮನಿ ಇಯರ್ ನೋ
50% ಮೈ ಲಾರ್ಡ್.
ಡಿಪಾಸಿಟ್ 1,68,000.
50% because we have already paid.
President dismiss the revision.
We have already paid my lord with it.
You deposit, they will not take the money, you deposit.
Yes, yes, ma'am.
Issue notice, there should be an interim stay of the impugned judgment and decree, subject to the petitioner depositing sum of rupees 1,68,000 before this court within a period of 2 weeks. On such thing, on such deposit being made, registry to invest the same and fix the deposit.
It will be 4 weeks, my lord.
4 weeks.
Yes.
For respondent. Yes.
The brief facts of the case is that the petitioner was working with the respondent's company. That the company was regularized the petition.
What are you challenging now?
And now, hearing.
Order passed.
Last page, where is the last page?
This code in CRP 564.
560.
Page 28.
Page 28, my lords.
Page
28, my lords.
Yes.
Your Lordship, kindly, the petitioner challenged the execution. It's not 2016. Your Lordship, kindly see the page 70. Page 70 ಅಲ್ಲಿ.
Page
70.
70.
70. ಕನ್ನಡದಲ್ಲಿ.
Yes.
ತೀರ್ಪು ಋಣಿದಾರರ ಪರ ವಕೀಲರು
Page 70 is page 21 of the order passed in CRP. 177. What is wrong with the order? What is the error in the order?
My lord, as per the decree passed by the trial court, the court specifically directed the decree JDR, judgment data, to pay three types of pensionary benefits. The benefits are that there are, first is lump sum payment with interest. Lump sum payment, my lord.
Where is the decree? That is extracted in the order at page 30.
ಇದೆ. ಇಲ್ಲಿ and also and additional pension also he is entitled. Additional pension.
Decree irodu page 30 ಗೆ ಬನ್ನಿ. Para 5 of the order that you seeking review.
Para 5 of the order.
In CRP 564/15.
Page 64 bar, 564 bar. ಎಷ್ಟು 30. ಮೂವತ್ತಾ? RPL. TRP ತಗೊಂಡ್ರಲ್ಲಿ
CRP 564.
560%.
Page number para 5. ನಿಮ್ CRP ಅಲ್ಲಿ page number 30. ನೀವು ಹಾಕಿರೋ ರಿವ್ಯೂ ಪಿಟಿಷನ್ ಅಲ್ಲಿ. ನೀವು ರಿವ್ಯೂ ಪಿಟಿಷನ್ ಹಾಕಿದಿರಲ್ಲ ಅದ್ರಲ್ಲಿ page number 30.
Not review petition. Got it. Para number 5 minutes.
Yes.
To examine as to whether the impugn order by 60, yes, order of the executing court is correct or not. It is relevant to extract the decree passed in the suit in OS number 4032/97. It reads as follows. It is further ordered and decreed that the defendant is directed to pay 54,000 to the plaintiff by way of arrears of pension payable for the period from so and so date with cost and current interest on the said amount at 6% per annum from 31/5/97 to the date of realization. It is further ordered and decreed that the defendant is also directed to determine and pay the pension to the plaintiff as per the voluntary separator scheme of the defendant.
So decree was for 54,000 with interest. One. Second is to pay pension as per the voluntary separation scheme.
ಹೌದು.
Now, next read para 6.
The matter had earlier come up before this court in CRP number 177, 139, and the court has disposed with respect to the revision petitioner on 18/1/2003, interpreting the aforesaid decree as follows. However, the question is when he is entitled to the pension, at what time, at what rate, when the judgment and decree is passed in the suit for a sum of rupees 54,000, being the pension from 3 to 1995 to 10, therefore for that period has already decreed and has been seized as 54,000. The decree holder is entitled for the pension of 7,200 from.
Your pension amount is fixed, 7,260
ಹೌದು
per month.
per month ಮಾಡಿ
This is to be paid.
Other at present
1095.
ಹೌದು ಅದು ಕೊಡ್ತಾ ಇದೆ 7,002. ಬಟ್ ಡಿಗ್ರಿಯಲ್ಲಿ ಏನ್ ಹೇಳಿದೆ ಅಂದ್ರೆ ಅವರಿಗೆ ಈಸ್ ಎಂಟೈಟಲ್ ಫಾರ್ ಆಲ್ ದ ರಿಟೈರ್ಮೆಂಟ್ ಬೆನಿಫಿಟ್ಸ್ ಅದರಲ್ಲಿ
ಎಲ್ಲಿ ಹೇಳಿದೆ ಇದು ಎಕ್ಸ್ಟ್ರಾಕ್ಟ್ ಮಾಡೋದು ಇಲ್ವಲ್ಲ ಪೇಜ್ 30 ಅಲ್ಲಿ ಇದೆಯಲ್ಲ
ಅಲ್ಲ ಇದರಲ್ಲಿ ಇಲ್ಲ ಬಟ್ ಇನ್ ದ ಡಿಗ್ರಿ ದೇ ಸ್ಪೆಸಿಫಿಕಲಿ ಸ್ಟೇಟೆಡ್.
There is a decree.
But I have produced the decree in the CRP matter, my lords, in list of documents produced on 3/3/2018 in the connected CRP. They had not produced, my lords, I have produced it.
Connected CRP. There is nothing wrong in the order, Vijay Kumar. You are not able to point out any error apparent on the face of the record.
ಅಲ್ಲ ಇಲ್ಲಿ ಏನಾಗಿದೆ ಅಂದ್ರೆ ಆಸ್ ಪರ್ ದಿ ರಿಟೈರ್ಮೆಂಟ್ ಸ್ಕೀಮ್ ಆಸ್ ಪರ್ ದರ್ ಓನ್ ಆರ್ಡರ್ಸ್ ಆಫ್ ದ ಕಂಪನಿ Milad, whoever take a wallet retirement after the age of 50, Milad, they are entitled these benefits. ಯಾವ್ಯಾವ್ದಂದ್ರೆ
I have some hearing problem. I was 82 years of age. See, voluntary retirement scheme, where voluntary retirement scheme has got a benefit, three benefits, major benefits. One is that lump sum payment. Second thing is pension. The third thing is additional pension. This is required to be paid by the company. This is as per the company's procedure. When I took the retirement at the age of 50, I took retirement with the three major benefits. One is the lump sum payment, second thing is pension, third thing is additional pension.
Where is it?
Page number 19. Page number 19, my lords. In the list of documents produced by respondents, page number 19. We have filed objection. Along with that, a separate list of documents are produced on 3/3/2018.
But the judgment debtor is not paying the money. They are paying only a very meager sum.
But RSA was so filed by the
Date.
3/3/2018, my lords.
3/3.
March 3rd, 2018. A list of documents is produced. A total of 5 documents are produced, my lords. That must be the last portion because after that, no pleadings have been filed.
ಇಲ್ಲಿದೆ ಡಿಗ್ರಿ ಅಷ್ಟೇ ಇರೋದಿಲ್ಲ ಪೇಜ್ 20 ಬನ್ನಿ ಅವ್ರ ಮೆಮೊ ಹಾಕಿದ್ದು ನೀವ್ ಹೇಳಿದ್ರೆ ಏನ್ 3 ಪೋರ್ಷನ್ ಕೊಟ್ಟಿಲ್ಲ.
ಹೌದು
ನೋಡಿ ಡಿಗ್ರಿ ತೋರಿಸಿ.
ಇದೆ ಡಿಗ್ರಿ ಇದೆ.
ಪೆನ್ಷನ್ ಕೊಡ್ಬೇಕಷ್ಟೇ ಆಸ್ ಪರ್ ದಿ ವಾಲಂಟರಿ ಸಪರೇಷನ್ ಸ್ಕೀಮ್. Pension is already.
The scheme has got major amount.
Last sentence ಅಲ್ಲಿ
This is to be
specific.
paid as per the voluntary retirement scheme.
In the decree, there is mentioned specifically mentioned, it is further ordered and decreed that the defendant is also directed to determine and to pay pension to the plaintiff as per the voluntary separation scheme of the defendant. Retirement benefit scheme ಅಲ್ಲಿ ಏನ್ ಮಾಡಿದಾರೋ is as per the decree is entitled for all the benefits.
ಬಟ್ ಅದಾದ್ಮೇಲೆ ಅನ್ಫಾರ್ಚುನೇಟ್ಲಿ ಫಾರ್ ಯು ಆ CRP ಅಲ್ಲಿ 7,200 ಅಂತ ಹೇಳ್ಬಿಟ್ರು.
That is a pension. They are paying. There is no dispute in respect of
This is the amount determined by this court. You have accepted that against Justice Javadrim's order. What did you do?
Sir, against that order,
Nothing has been done, my
They
lords.
prepared an CRP, sorry, SLP.
Then that is dismissed.
But they prepared an appeal.
So you did not challenge that finding of
We also
7,000.
prepared an appeal before the, but both the cases were, our case was
The pension now is fixed at 7,260.
7,260.
And what more can you do?
My lord, remaining benefits, my lord, they are paying the pension, monthly pension, we have no dispute in respect of, but they have to pay the additional pension as per the scheme. Scheme is very clear. They are entitled for 3 benefits. Whoever served more than, after the age of 50 years, whoever
ಅದಕ್ಕೆ
interested,
ಕೇಳಿದೆ ವಿಜಯಕುಮಾರ, 7,200 ರೂಪಾಯಿ ಅಂತ ಜಸ್ಟಿಸ್ ರಾಯಮ್ ಸಾಹೇಬ್ರು ಹೇಳ್ಬಿಟ್ರು. ಅದು ನೀವು ಚಾಲೆಂಜ್ ಮಾಡಿದ್ರಿ, ವಜಾಗೋಯ್ತು.
ಅಲ್ಲ ಅವ್ರು ಮಾಡಿದ್ದಾರೆ.
ಅದು ತಪ್ಪು ಅಂತ ಹೇಳದ?
ಅಲ್ಲ against this order, CRP, my lord, both have filed a appeal before the Supreme Court.
What is the effect of dismissal of that CRP?
My lord, they made some observations. They made some observations in that
ಏನಂತ?
order.
My lords, no observations have been made. It is a simpliciter dismissal, my lord.
Scheme is there, sir. There was to be a lump sum payment, additional payment, and a regular pension. And above 50 years of age, there is a scheme given to the High Court also. Supreme Court also, they have provided the scheme. I am 82 years of age. I did not get 33 years. I am began the litigation for the scheme. There is a scheme. As per the scheme, I took retirement at the age of 50. I have not taken retirement at the age of 40. I have taken the retirement, I am additional pension, plus there is a lump sum payment between my age and the retirement age. There is a lump sum payment, and the High Court, Supreme Court has also mentioned 6% interest to be paid. 33 years I am began the entire litigation. I also became an advocate after 50 years of age to fight the case in the litigation process. Your Honor, please hear me. 83 years, hearing problem with all the angioplasty. I am fighting the case even in the Supreme Court twice. And the High Court on 10th occasion. Please hear me, sir. What is this, sir? I expect at this age, 83.
Hearing, no problem.
Now, hearing, there is a problem for me for hearing.
They're reading the paper.
Lots of people throughout the world, they got retirement benefits, except me. The company has got lots of people throughout the world.
This is a scheme at page number 54 in his review petition. Where is that voluntary separation scheme?
Well, the scheme is not produced by the parties, my lords, but the relevant portion is extracted, my lords. That is the scheme which is referred to
Page
in the
54.
page 54, my lords.
So please read that.
Direction.
In para 4, what did you retire?
Whereas there were multiple, at multiple times, there were multiple schemes, my lords. But as on the, after he retired and a suit was
Retired.
instituted,
When did you retire?
I'll confirm, my lords.
1950, that is the age of 1995.
1995.
Say, I retired in 1995, sir. 30 years I am began.
How old were you when you retired?
How old are you?
I am 83 now.
No, no, no.
When you retired?
At the time, 50 years of age.
Above or below?
50. 33 years I am began the
Sir, how old
Above or
are you?
below?
retirement. 50 years, sir.
Was he above 50 years or
1943
below
was
50 years?
born.
My lords, I'll have to verify, my lords, what was his age, but nevertheless, the order has attained finality, my lords. They'll have to point out any errors in the order passed in CRP 564. They are unable to point out any defect in the order of order under CRP, which is under challenge.
Now the facts, I'll grant you time. Don't come out with this argument. I'm asking you a specific question. There was a scheme that was formulated.
Yes, my lords.
Under the scheme, What was the amount that he was entitled to get? What was given to him? Establish that and dismiss the review.
Yes, my lords. I have produced, along with the RP, my lords, they have produced the memo of calculation, which has been accepted by
Show me
the,
the scheme first. Forget about what has been done. Show me the scheme.
I shall place on record, my lords, because scheme has not been produced, my lords. What is applicable to him?
I need the scheme. I
Yes,
need to see what is the exact amount you paid under the scheme.
Yes, my lords.
That is all.
I shall do the needful.
Relist.
May I request for 18th, my lords?
18th.
Great.
How did, sir, how did it? 18th. Corresponding to it, 3. Lordship, this matter is covered by a judgment of the division bench of this court. That is with regard to Kempegowda layout. In the similar matter, this matter may also be disposed, Your Lordship.
Petitioner of the revenue side order, my lord, the matter is covered.
That is,
Lord, similar, my lord, there are 3 writ petition was filed.
Writ appeal 1783, na?
178.
1783 of 14.
In the same terms, huh?
Yes,
At same terms, it
and
can be
conditions.
disposed. At page 308, Your Lordship. Lordship, 307, it starts, Lordship.
305 ಅಲ್ವಾ?
307, Your Lordship.
308 ಅಲ್ಲಿ ಇದೆ sir.
ಅಲ್ಲ, Lordship, it starts from B.
From?
Shall I? Insofar as the site owners who have not made an application as contemplated in para 3A herein above, they shall register themselves for allotment under the BDA allotment of site rules 1984 within 3 months from today by paying the registration fee. However, payment of initial deposit by them is exempted. The necessary document along with the said application are also to be filed to enable the BDA to verify the same. The BDA shall treat the applicants as being entitled for priority allotment and allot each of them a site measuring 30-40 in the Nada Prabhu Kempegowda layout at the prevailing allotment price, subject to the application satisfying the dual requirement of allotment under the rules that
the petitioners have challenged the notification issued under section 17. Dated 21/5/2008 and the declaration issued under section 19 dated 18/2/2010, whereby amongst other lands, their land brings 55/2, measuring 1 acre 17.14 guntas, was declared to be needed for the purpose of Nada Prabhu Kempegowda layout. It is not in dispute that the validity of these notifications were upheld by a division bench, were upheld by this court and confirmed by the division bench of this court in writ appeal number 1783 of 2014 and connected matters on 22nd of February 2024. In that view of the matter, the acquisitions impugned are upheld. However, the division bench, while disposing of the said matter, has stated as follows regarding site owners. Since the petitioners are also site owners, they would come within the purview of these directions and consequently purview of these directions, which read as follows. Page 307, B in the abdomen. B matra, B 1, 2, 3. In the light of the above direction issued by the division bench, the case of the petitioners shall be considered in the manner stated above by the division bench. Writ petition accordingly disposed of.
Much appreciated.
Respondent.
But in this matter, not cancellation of the allotment has been questioned as per annexure A, my lords. But the facts leading to this case is not petitioner and his brothers, my lords, they were the owners of land bearing survey number 15 of Bomanali village. Lord, out of 3 acres and all,
Site is cancelled.
allotment is cancelled after a period of 20 years. Earlier, my lord, what happened? The Honorable Court, my lord, allowed the writ petition by quashing the order, against which, my lords, the authority preferred writ appeal
Writ appeal also, my lord, by recent order was, my lord, the appeal came to be dismissed. The authority approached the Supreme Court, my lord. Supreme Court said the division bench of this honorable court could not have passed the order because the learned single judge of this honorable court has not passed the order in detail. Only on that ground, my lords, the matter has been remitted back to the, in order to pass the detailed order. The lordships may kindly, Lord, I think it should be a part of the record, not the earlier orders also. Jail records ಅಲ್ಲಿ.
Please read annexure A.
Please. Lord, at page 14 minutes.
Yes.
Lord, ಬೊಮ್ಮನಹಳ್ಳಿ ಗ್ರಾಮದ ಸರ್ವೆ ನಂಬರ್ 15ರಲ್ಲಿನ 25 ಗುಂಟೆ ಜಮೀನಿಗೆ ಸಂಬಂಧಿಸಿದಂತೆ this is subject matter not ದಿನಾಂಕ 1/1/94 ಪ್ರಾಧಿಕಾರದ ಸಭೆಯ ವಿಷಯ ಸಂಖ್ಯೆ 2/94 ನಿರ್ಣಯವನ್ನು ಹಿಂತೆಗೆದುಕೊಳ್ಳಲು ದಿನಾಂಕ 14/11/2014 ಪ್ರಾಧಿಕಾರದ ಸಭೆಯ ವಿಷಯ ಸಂಖ್ಯೆ 163/14 ನಿರ್ಣಯಿಸಿರುವಂತೆ ಕ್ರಮವನ್ನು ಅನುಷ್ಠಾನಗೊಳಿಸುವ ಬಗ್ಗೆ ಉಲ್ಲೇಖ ರೆಫರೆನ್ಸ್ ಜಿ ರವಿರವರು ಬೊಮ್ಮನಹಳ್ಳಿ ಗ್ರಾಮದ ಸರ್ವೆ ನಂಬರ್ 9/1 ಮತ್ತು 10/1 ರಸ್ತೆಯಲ್ಲಿರುವ ಜಮೀನಿಗೆ ಜಾಗಕ್ಕೆ ಬದಲಿ ನಿವೇಶನಗಳನ್ನು ನೀಡುವಂತೆ ಸಲ್ಲಿಸಿರುವ ಮನವಿ. ಮಾನ್ಯ ಉಪ ಲೋಕಾಯುಕ್ತ 2ರವರು ದಿನಾಂಕ 8/1/2015 ನೀಡಿರುವ ನಿರ್ದೇಶನ. ಶ್ರೀ ಜಿ ರವಿ ಬಿನ್ ಗೋಪಾಲ್ ರೆಡ್ಡಿ ಅವರು ಮಾನ್ಯ ಉಪ ಲೋಕಾಯುಕ್ತ
50% of the land, developed land.
Not 25% has been given. Not here what has happened, my lords.
The first paragraph says BM Srinivas Reddy ಮತ್ತು ಇವರ 5 ಜನ ಸಹೋದರರಿಗೆ
25 guntas has been utilized for the formation of the road without there being any acquisition proceedings.
ನೆಕ್ಸ್ಟ್ ಜಮೀನ್ ರಸ್ತೆಗೆ ಉಪಯೋಗಿಸಿಕೊಂಡಿರುವುದಾಗಿ ತಿಳಿಸಿ ಶ್ರೀ BM ಶ್ರೀನಿವಾಸ್ ರೆಡ್ಡಿ ಮತ್ತು ಅವರ 5 ಜನ ಸಹೋದರರಿಗೆ ಇದೇ ಗ್ರಾಮದ ನಂಬರ್ 15
ಇದೇ
ಮಾಡುತ್ತೇನಲ್ಲಾದ ರಸ್ತೆಯ ಜಮೀನ ಜಾಗಕ್ಕೆ ಬದಲಿಯಾಗಿ ನಿವೇಶನಗಳನ್ನು ನೀಡಿರುವಂತೆ ತಮಗೂ ಕೂಡ ಬದಲಿಯಾಗಿ 50% ಅಭಿವೃದ್ಧಿ ಪಡಿಸಿದ ಭೂಮಿಯನ್ನು ನೀಡಲು ಬೆಂಗಳೂರು ಪ್ರದೇಶ ನಿರ್ದೇಶನ ನೀಡುವಂತೆ. So you sought for 50% of the 29 guntas of land.
That is sought by the Ravi.
Ultimately,
That was the request.
That is not the petition. Some other person, they are seeking the similar relief.
My lord, yes, sought for, my lord, one Ravi, who happens to be the owner of land bearing survey number 9/1 and 10/1 of the same village. Not he has approached the authority. Not he has also sought for, my lord, 50% of the land on the ground that his land also has been utilized for the.
What is your land?
My lord, mine, survey number 15, my lords. In the first para itself, in the preamble itself, it clear, my lords, the land belonging to the petitioner has been utilized for the formation.
You are claiming on parity with Ravi.
No, I am not claiming. He was claiming, he has approached the Upalokayukta since, my lord, the BDA has issued an endorsement to Ravi. But he approached Upalokayukta. Upalokayukta, my lord, orally, my lord, observes that if you can't allot site to Mr. Ravi, you cancel the allotment made to the petitioners herein, my lord. Based on that, my lord, the show cause notice has been issued and the cancellation of allotment has been done.
My lord, may I make submission. The petitioner and the 5 brothers made the application to the BDA stating that their land was utilized by the BDA for formation of the road from Bommanahalli, my lord, from some place, my lord, the Bommanahalli, Bommanahalli to Bangamanapalle. My lord, they made the representation, the BDA, my lord, BDA first time in the refer to the engineer to verification. The engineer submitted that we have not formed the road, we have no document, and we have not formed the sites in the any adjacent of that area, my lord. And the area belongs to the CMC till 2007, and thereafter it was transferred to the BBMP. Then, my lord, the surveyor, my lord, they submitted a report stating that the road was passed between the 2 survey numbers, survey number 15 and 19. And he submitted that the road is passed, but he is not submitted who has filed formed the road. Another engineer made given report stating that the road is formed in the survey number 19. On that basis, my lord, that a matter was placed before the authority. Authority decided to allot 30 sites of 2 sites to each of the brothers. My lord, later it came to the residents made the complaint to the BDA stating that the petitioner's land was not utilized the BDA. They are fabricating some document and obtaining these sites from the BDA. On the basis of, my lord, the one Ravi, he made the application stating that
my land, the road is passed my land also, and give the benefit of two sides as it was given to the petitioners. He approached the Honorable Lokayukta, my lord. Lokayukta said, my lord, that we have filed the reply that said we have not farmed the road. Then the Lokayukta said, my lord, since you have given the benefit to the petitioner, you give either you cancel the benefit given to the petitioner or to give the Ravi also similar this.
You cancelled your.
No, then we have, it was placed before the authority, my lord. The authority, considering, madam, they have recalled the earlier resolution where the authority passed the resolution to grant two sides. That resolution was recalled. On the basis of the recall, my lord, we have issued the show cause notice to the petitioner.
When you allotted the lands, you were sure that the road had been.
No, on the basis of the, my lord, the surveyor and the second engineer's report, the decision was taken. Yes.
You had no doubt about it then. It's only when somebody else asked for parity, then you realized that this allotment was wrong.
Then
therefore you decide to cancel.
Yes, sir. Then we have made the inquiry and then it was.
The order,
decided.
my lord.
And that resolution, my lord, the recalling the earlier order resolution was not challenged by the petitioner. The authority has decided, the earlier authority has decided to allot the site. That resolution was recalled by the subsequent.
That is what is challenged here, isn't it?
No,
Annexure A.
Annexure A is the cancellation order by the BDA. Based on that resolution, then we have issued a show cause notice and.
Read the second paragraph.
Yeah, cancellation order. Notes, before cancellation order, if your lordship permits to read the resolution passed, my lords, I'll just read the relevant portions in the resolution as per annexure B, my lords. At page 16, your lordships, my lords. May I read, my lords?
Yes.
Not para 2, my lords. ರಾಷ್ಟ್ರೀಯ ಹೆದ್ದಾರಿ 7 ಕಡೆಯಿಂದ ಸೆಕ್ಟರ್ 7ಕ್ಕೆ ಪ್ರವೇಶಿಸಲು ಒದಗಿಸಲು ಬೇಕಾದ 80 ಅಡಿ ರಸ್ತೆಯನ್ನು ಈಗಾಗಲೇ ನಿರ್ಮಿಸಲಾಗಿದೆ. ಇದಕ್ಕಾಗಿ BM ಶ್ರೀನಿವಾಸ್ ರೆಡ್ಡಿ ಮತ್ತು ಇವರ 5 ಜನ ಸೋದರಿಗೆ ಸೇರಿದ ಮತ್ತು ಬೊಮ್ಮನಹಳ್ಳಿ ಸರ್ವೆ
withdraw ಮಾಡಿಬಿಟ್ಟಿದ್ದಾರೆ ತಾನೇ ಈಗ.
ಯಾವುದು ಸರ್?
This resolution is now withdrawn.
They have withdrawn. And now even the cancel, either the show cause notice or the cancellation order does not speak of non-utilization of the land for the formation of the road.
Read the second paragraph.
Please, ಅರ್ಜಿದಾರರ ಕೋರಿಕೆಯ ಮೇರೆಗೆ ಮತ್ತು ಮಾನ್ಯ ಉಪಲೋಕಾಯುಕ್ತ 2ರವರ ನಿರ್ದೇಶನದಂತೆ ಪರಿಶೀಲಿಸಲಾಗಿ ಶ್ರೀ BM ಶ್ರೀನಿವಾಸ್ ರೆಡ್ಡಿ ಮತ್ತು ಅವರ 5 ಜನ ಸೋದರರ ಜಮೀನಿಗೆ ಸಂಬಂಧಿಸಿದಂತೆ ದಿನಾಂಕ 1/1/94 ಪ್ರಾಧಿಕಾರದ ಸಭೆಯ ವಿಷಯ ಸಂಖ್ಯೆ 2/94ರಲ್ಲಿ ರಾಷ್ಟ್ರೀಯ ಹೆದ್ದಾರಿ 7ರಿಂದ HSR 7ನೇ ಸೆಕ್ಟರ್ ಪ್ರವೇಶ ಕಲ್ಪಿಸಲು 1987ರಲ್ಲಿ ನಿರ್ಮಿಸುವ 80 ಅಡಿ ರಸ್ತೆಗಾಗಿ ಉಪಯೋಗಿಸಿಕೊಂಡಿದ್ದೆನ್ನಲಾದ ಮತ್ತು ಶ್ರೀ BM ಶ್ರೀನಿವಾಸ್ ರೆಡ್ಡಿ ಮತ್ತು ಅವರ 5 ಜನ ಸಹೋದರರು ಸ್ವಇಚ್ಛೆಯಿಂದ ಬಿಟ್ಟುಕೊಟ್ಟಿದ್ದಾರೆನ್ನಲಾದ ಬೊಮ್ಮನಹಳ್ಳಿ ಗ್ರಾಮದ ಸರ್ವೆ ನಂಬರ್ 15ರಲ್ಲಿನ 25 ಗುಂಟೆ ಜಾಗಕ್ಕೆ ಜಮೀನಿನ ಬದಲಿ ಜಮೀನು ಆಧಾರದ ಮೇಲೆ 1:4 ಭಾಗ ವಿಸ್ತೀರ್ಣದಷ್ಟು ಅಭಿವೃದ್ಧಿಪಡಿಸಿದ ಜಮೀನನ್ನು ಅಂದರೆ ಪ್ರತಿಯೊಬ್ಬರಿಗೂ 20-30 ಅಳತೆಯ ನಿವೇಶನಗಳನ್ನು ಹಂಚಿಕೆ ಮಾಡಲು ತೀರ್ಮಾನಿಸಲಾಗಿದ್ದು, ಸದರಿ ತೀರ್ಮಾನದಂತೆ ಶ್ರೀ BM ಶ್ರೀನಿವಾಸ್ ರೆಡ್ಡಿ ಮತ್ತು ಅವರ 5 ಜನ ಸಹೋದರರಿಗೆ HSR 7ನೇ ಸೆಕ್ಟರ್ನಲ್ಲಿ ಪ್ರತಿ 20-30 ಅಳತೆ ವಿಸ್ತೀರ್ಣದ ನಿವೇಶನ ಸಂಖ್ಯೆ ಗಳನ್ನು ಹಂಚಿಕೆ ಮಾಡಿ ಶುದ್ಧ ಕ್ರಯ ಪತ್ರಗಳನ್ನು ನೋಂದಾಯಿಸಿ ಸ್ವಾಧೀನ ಪತ್ರಗಳನ್ನು ನೀಡಲಾಗಿರುತ್ತದೆ. ಮುಂದುವರೆದು ಅರ್ಜಿದಾರ ಶ್ರೀ G. ರವಿರವರು ಸಲ್ಲಿಸಿದ ದೂರು ಅರ್ಜಿಯಲ್ಲಿನ ಕೋರಿಕೆಯ ಮೇರೆಗೆ ಪರಿಶೀಲನೆ ನಡೆಸಿದ ಪ್ರಾಧಿಕಾರದ ಅಭ್ಯಂತರ ಸದಸ್ಯರು 20 ಅಡಿ ಅಗಲದ ಟ್ರ್ಯಾಕ್ ರಸ್ತೆಯು ಬಿ ಕರಾಬು ಬೊಮ್ಮನಹಳ್ಳಿ ಗ್ರಾಮದ ಸರ್ವೆ ನಂಬರ್ 9/1 ಮತ್ತು 10/1ರಲ್ಲಿ ಹಾದು ಹೋಗುತ್ತಿದ್ದು, ಹಾಲಿ ಇರುವ ರಸ್ತೆ ಇಕ್ಕೆಲೆಗಳಲ್ಲಿ ಪ್ರಾಧಿಕಾರದ ಯಾವುದೇ ನಿವೇಶನಗಳು ಇರುವುದಿಲ್ಲವೆಂದು, ಪ್ರಸ್ತುತ ರಸ್ತೆಯು 2007ರವರೆಗೆ ಬೊಮ್ಮನಹಳ್ಳಿ CMC ಆಡಳಿತ ವ್ಯಾಪ್ತಿಯಲ್ಲಿದ್ದು 2007ರಿಂದ BBMP ಆಡಳಿತದಲ್ಲಿರುತ್ತದೆಂದು, ಪ್ರಾಧಿಕಾರದಿಂದ ಈ ರಸ್ತೆ ನಿರ್ಮಿಸಿರುವುದಕ್ಕೆ ಯಾವುದೇ ದಾಖಲೆಗಳಿಲ್ಲ ಮತ್ತು ಪ್ರಾಧಿಕಾರವು ಈ ರಸ್ತೆ ನಿರ್ಮಿಸಲವೆಂದು ಅಭಿಪ್ರಾಯ ನೀಡಿರುವ ಹಿನ್ನೆಲೆಯಲ್ಲಿ ಅರ್ಜಿದಾರರ ಕೋರಿಕೆಯನ್ನು ತಿರಸ್ಕರಿಸಿ ದಿನಾಂಕ 12/3/2014ರಂದು ಹಿಂಬರಹ ನೀಡಲಾಗಿತ್ತು. ಅರ್ಜಿದಾರರ ಕೋರಿಕೆಯಂತೆ ಪ್ರಾಧಿಕಾರವು ತಿರಸ್ಕರಿಸುವುದನ್ನು ಪ್ರಶ್ನಿಸಿ ಅರ್ಜಿದಾರರು ಸಲ್ಲಿಸಿದ ದೂರಿನ ವಿಚಾರಣೆ ನಡೆಸಿದ ಮಾನ್ಯ ಉಪಲೋಕಾಯುಕ್ತ 2ರವರು 1994ರಲ್ಲಿ ಪ್ರಾಧಿಕಾರದ ಅನುಮೋದನೆಯಂತೆ ಸರ್ವೆ ನಂಬರ್ 15ರವರೆಗೆ ನೀಡಿರುವ ಪರಿಹಾರದಂತೆ ಪಕ್ಕದ ಜಮೀನಿಗೂ ಸಹ ಪ್ರಾಧಿಕಾರದ ಅನುಮೋದನೆ ಪಡೆದು ಬದಲಿ ಜಮೀನು ನೀಡುವ ಬಗ್ಗೆ ಪರಿಶೀಲಿಸುವಂತೆ ಮೌಖಿಕ ನಿರ್ದೇಶನ ನೀಡಿದ್ದ ಮೇರೆಗೆ ದಿನಾಂಕ 5/7/2014ರಲ್ಲಿ ಪ್ರಾಧಿಕಾರದ ಸಭೆಯ ವಿಷಯ ಸಂಖ್ಯೆ 102/14ರಲ್ಲಿ ಇದೊಂದು ಹಳೆಯ ಪ್ರಕರಣವಾಗಿದ್ದು 20 ಅಡಿ ಅಗಲದ ಟ್ರ್ಯಾಕ್ ರಸ್ತೆಯು ಬಿ ಕರಾಬು ಬೊಮ್ಮನಹಳ್ಳಿ ಗ್ರಾಮದ ಸರ್ವೆ ನಂಬರ್ 9/1 ಮತ್ತು 10/1ರಲ್ಲಿ ಹಾದು ಹೋಗುತ್ತಿದ್ದು, ಹಾಲಿ ಇರುವ ರಸ್ತೆಯ ಇಕ್ಕಲುಗಳಲ್ಲಿ ಪ್ರಾಧಿಕಾರದ ಯಾವುದೇ ನಿವೇಶನಗಳು ಇರುವುದಿಲ್ಲವೆಂದು, ಪ್ರಸ್ತುತ ರಸ್ತೆಯು 2007ರವರೆಗೆ ಬೊಮ್ಮನಹಳ್ಳಿ CMC ಆಡಳಿತ ವ್ಯಾಪ್ತಿಯಲ್ಲಿದ್ದು 2007ರಿಂದ BBMP ಆಡಳಿತದಲ್ಲಿರುವುದೆಂದು ಪ್ರಾಧಿಕಾರದಿಂದ ಈ ರಸ್ತೆ ನಿರ್ಮಿಸಿರುವುದಕ್ಕೆ
In respect of the sites allotted to them, sale it's been executed.
Yes, 95.
Then how can you cancel this now?
95, construction has been done, we have borrowed loan, we have mortgaged the
First, no-
property.
after issuing the show cause notice, my lord, it
How
was-
can you cancel a sale deed?
that is, they have to approach the civil court, my lord, that is.
On that ground, I'll quash it, sir. By cancelling the allotment, you can't cancel the sale deed.
Sale deed was cancelled. Only for the cancellation, my lord, they have to approach. the
You
sale
cannot
deed
cancel the allotment after the sale deed is executed. I'll give you liberty to go against the sale deed if you so desire. It is not in dispute that on the request of the petitioners that their land measuring 25 guntas was utilized for the formation of a road. The BDA proceeded to allot ಎಷ್ಟು site?
My lord,
Two sides.
ಅಲ್ಲ ಎರಡು ನಾಲ್ಕು.
9 sites.
No,
That is
this
for the
petition
other,
is-
my lord, there are, let me, my lord, let
Separate
me-
petitions are there.
There are another 4
There are two-
petitions pending, my lords, connected, my lords. This is in respect of two sites.
ಒಟ್ಟು ಎಷ್ಟು sites ಕೊಟ್ಟಿದೆ? 6?
So, 2 site ನಮಗೆ ಕೊಟ್ಟಿರೋದು ಈ petitionerಗೆ. ಒಟ್ಟು ಬಂದು 10 site.
How many petitions are pending?
4 more petitions are pending.
Number ಕೊಡಿ.
Please.
14 ಸೈಟ್ ಕೊಟ್ಟಿದೆ total.
There are 14 sale deeds.
Yes.
Give me the numbers.
My lord, WP number,
Post. So and so along with these matters. List ಕೊಡಿ.
what is?
List.
My lords.
Next week, relist.
Kindly pass on. Senior is in the portal.
Next week, I'm taking up in the hearing matters in the afternoon.
My lord,
16th,
item number 28, item number 28 was passed over.
Yes,
So,
that we called afterwards.
please, Mr.
Relist.
Your lords have indicated that we will heard the last one.
Take it up at afternoon.
The petitioner's land, they were allotted for the purpose of slum, my lord, they were dispossessed and they were allotted the sites in question. Then thereafter, my lord, the same sites which are utilized by the slum board. Now, my lord, there is an alternative site has been allotted. They are not giving delivery of possession.
Pay for the slum board. While my objection, the mayor is seeking direction from the BDA to allot alternative sites. Supreme order was passed in the, by this honorable court that where they have identified certain properties from the BDA.
No, I said you will pay the costs for their construction. You and BDA together will pay the costs.
But I had paid that amount also, my lord, initially.
The request is that we have alternative construction which is going on. If your lordship may kindly, if they are willing to take that property, then they can take it. So that because paying cost will be difficult. There is alternative construction at Lagere. Engineer is also present. Within another 10 months, that buildings will be constructed.
ಬೇಡ ಕಾಸು ಕೊಟ್ಬಿಡಿ ನಿಮ್ಗೆ ಯಾಕೆ ಅವ್ರು ಬೇರೆಯವ್ರು ಕೊಟ್ಕೊಳ್ಳಿ. You have constructed for somebody else's purpose, isn't it?
We are constructed for basic service to urban poor. It is all these constructions are taken place for only.
They are not urban poor, they're economically weak, that is all. Don't make them poor, they are only economically weak.
Respectful submission is that lordship, BDA had already allotted, there was a, your
Site
lordship.
ಕೊಟ್ಟಿದಾರ ರವಿ ನಿಮ್ಗೆ? Site
My
ಕೊಟ್ಟಿದಾರ?
lord, Lordship, kindly see, they have identified as per annexure J series.
Where is BDS council? I'll pass it over. I'll pass it over. 2:30 continue.
Sorry, the one submission, my lord. Afternoon, there is one matter where I have short time to take. First quarter matter, serial number 6. First quarter
ಬನ್ನಿ ಪಾಸ್ವರ್ಡ್ ಮಾಡ್ತೀನಿ ಬನ್ನಿ.
Please, Lord, sir. I'm ready, my lord. Although the industry close ಮಾಡಿದ matter.
But serial number 25, my lord has listed it on 15. Could it please be added on 16th, my lord?
Date ಬೇಕಂದ್ರೆ ಮೇಡಮ್ 16th.
Serial number 25.
Lordship,
I'm appearing for the petition.
Serial number 5 in list number 2, please, my lord. Request for a short date, please, my lord.
2:30, mention it 2:30.
Please, my lord. Right.
Serial number 58. So only for direction to conduct JMC.
Who's opposing you?
State, my lord, state and as well as care.
Number 4 and 5 present.
58 ನೋಡಿದಿರಾ?
Number 58, my lord, so respond number 4 and 5.
It is only for conducting joint measurement certificate, that's all.
Whom do you appear for?
Like for the respond number.
Notices were issued by ADLR.
Are you opposing him or
Opposing him.
next week?
Serial number
Serial-
57 could be passed over.
Madam, my lord, in that matter, endorsement came to be issued and it reaches, my lord, I may be permitted to produce the endorsement,
Realist.
57.
Serial number 56, I have it.
ಯಾವ್ದು?
52, short accommodation.
Date ಕೊಡ್ತಾರೆ. We'll give you dates.
ಹದಿನೈದನೇ ತಾರೀಕು ಬಿಟ್ಟು ಬೇರೆ ಡೇಟ್.
Serial number 31.
Serial number 50.
ಕೊಡ್ತಾರೆ.
15th ಬೇಡ ಅಂದೆ, ಅದು ಬಿಟ್ಟು.
Madam, second list.
ಹೋದಾಗತ್ತೆ,
First list.
already ಎರಡು.
Sir, 15.
58 on date ಕೊಡಿ.
Serial number 56.
ಅದೇ ಯಾವ ಡೇಟ್ ಬೇಕು ನೋಡಿ. ಸರ್ ಯಾವ್ದು ಬೇಕು?
Serial number 56. ಆಲ್ರೆಡಿ ಕೇಳ್ಬಿಟ್ಟಿದ್ದಾರೆ.
One by ಕರೀತಾರ. Sir, 59, 60, 61, 62. One by one ಕರೆದ್ಬಿಡಿ sir.
Monday, next Monday.
Sir, 57.
51, 19.
Even 19, sir.
53, 230 ತಗೊಳ್ತೀನಿ ಸರ್, ರೆಡಿ. ಟೆಂತ್ ತಗೊಳ್ಳಿ ಸರ್, ಹಾಗಾದ್ರೆ ನೆಕ್ಸ್ಟ್ 10ನೇ ತಾರೀಕು. 10th ತಗೊಳ್ಳಿ ಸರ್.
Sir, 52 ಯಾವಾಗ ಹೋಯ್ತು sir?
ಒಬ್ಬರೇ?
Sir, 52.
ಸರ್ 53 10th. ಇದು 10th ಮಂಡೇ ಕೊಟ್ಟು. 15. ಮುಖ್ಯ ಆಗ್ರಹ 5ನೇ ದಿವಸಕ್ಕೆ ಬರ್ತಾರೆ.
16th half day sir.
ಹಾಫ್ ಡೇನೇ ಅಲ್ಲ ಇದು.
Sir, 57.
53 10th ತಗೊಳ್ಳಿ ಸರ್, 10ನೇ ತಾರೀಕು. 53 10th. 10th.
57 ಹೇಳಿಲ್ಲ ಸರ್.
Sir, 57. 57 ಯಾವಾಗ?
22nd. ಮಂಡೇ.
59, 60, 61, 62 ಅಷ್ಟೇ.
4ಕ್ಕೆ ಸರ್.
Sir, 57.
ಅದು ಯಾವಾಗ ಇನ್ನೊಂದು
ಹಾ. 15.
Sir, 19 ಕೊಟ್ಬಿಡಿ ಸರ್, ಸೀನಿಯರ್.
ಇವರು ನಮ್ದು ಆಯ್ತು.
Sir, 46 ಯಾವಾಗ ಕೊಟ್ಟಿದ್ದೀರಿ?
58 sir. 58.
So 63. 63 ಕೊಡಿ ಸರ್, ಯಾವುದು? 63.
65 ಯಾವತ್ತು? Sir, 58 ಯಾವಾಗ ಕೊಟ್ರಿ ಸರ್? 58. ಹದಿನೈದಾ?
63, sir. Ten working day. Sir, 10 working day. Madam, 10 working day na. Sir, 63. Sir, serial number 2 ಅಲ್ಲಿ 13 ಏನಾದ್ರು ಅರ್ಜನ್ ಆಗಿದೆಯಾ?
ಯಾವಾಗ ಸರ್?
ಸರ್, ಲಿಸ್ಟ್ 2 ಅಲ್ಲಿ 13 ಏನಾದ್ರು ಅರ್ಜನ್ ಆಗಿದೆಯಾ?
52 ಸರ್. 52 ಸರ್.
ಸರ್, 63 ಏನ್ ಡೇಟ್ ಹೋಗಿಲ್ಲ ಅಲ್ವಾ? ಆಕ್ಚುಲಿ ಆ ಕಡೆ ಅವ್ರು ಏನು ಇಲ್ಲ, ನಾವು ರೆಸ್ಪಾಂಡೆಂಟ್ ಹಾಕಬೇಕು. ಇದು ಲಿಸ್ಟ್ ನಂಬರ್ 2 ಅಲ್ಲಿ ಸೀರಿಯಲ್ ನಂಬರ್ 13 ಏನಾದ್ರು ಅರ್ಜೆಂಟ್ ಆಗಿದೆಯಾ? ಯಾವ್ದು ಆಗಿಲ್ವಾ? ಓಕೆ.
Sir, 47 serial number. 16. Thank you. Dismiss, sir. 16. Okay, sir.
Dharwad bench matters, serial number 1. Nandish Patil.
Matter, my lord, that the Supreme Court in earlier round of litigation filed by one of the petitioner has said that you have to produce the proof of ownership and the proof of legality. Without that, my lord, they are not entitled for relief. The judgment which they're referring, my lord, is now status challenge that in before Supreme Court. Therefore, my lord, that's not applicable. Then third, my lord, that due to various transfers of these cases from Forest Department to COD and then to CBI and then to SIT. And they are trying to figure out who actually investigated and filed a charge sheet. So need some more time, my lord, to clarify who is investigated this matter.
It's been going on for the past 3-4 months.
Lords, I am only concerned with
came-
1.1. In 1.1, it is their application before the
And that's what I
JMFC
told
court and my lords
No, it is-
Sessions Court seeking permission to auction the ore. That will not survive so far as we are concerned, because there is an order to release ore in our favor. That, my lords, because the Supreme Court itself said it's the CBI court which is the competent court of jurisdiction. They go to Ankola court.
No, but the iron was seized. He's in the Ankola court pending. The CBI, my lord, it's below 50,000 metric tons. So that's, my lord, CBI is not investigating this matter. I spoke to CBI people also today morning. They said that they have sent it back to the COD. Now the issue is that it's pending before COD or SIT, my lord. I asked for clarification today morning. I met the SIT people also and asked for some clarification. Let me have a look at those things, my lord, where it is pending and who is investigating. And then I'll place
Wednesday, my lord.
not Wednesday.
My
Monday.
lord, from
Those
Dharwad,
are
your
the-
lordships have heard it, my lord, and
Sorry, Lord.
categorically the government advocate had submitted that
I understand.
charge sheet
this.
is not
You wanted
filed.
You wanted the iron ore to be auctioned.
No, I wanted to be auctioned.
So therefore, by the iron ore being there, you get no benefit.
No, we are not getting any. The only thing, your lordship may see the Supreme Court direction, my lord, in the earlier round petition filed by them.
That's in 1.1. where
It was
time
allowed and state challenged it and state took the matter to Supreme Court. Kindly see the order last para 27, my lord.
That's in Vedanta, my lord. subject
in
to
Vedanta.
correct. That's where the Honorable Supreme Court said the competent court is the special court at Bangalore.
He is the seizure of iron ore by establishing its existence and its ownership. Now that's mandatory by virtue of Supreme Court order. Let me have.
Lord, insofar as ownership is
Was seized
concerned.
at the port.
Yes, my lord. It's initially seized by Forest Department in FOC number 70.
Whomever it was seized.
Yes, my lord.
It will have to go back to them.
No, but if it belongs to them, yes, my lord. That is what the Supreme Court said, that you have to.
When you seized it, you said it belonged to them, isn't it?
No, it was various item, my lord, it was stolen. Stolen article need not be given back to them.
How can they prove that it is not stolen?
No, they'll have to.
You can prove it is stolen, correct?
That is the charge sheet has been, I believe, my lord, charge sheet has been filed. Let me verify those content.
Lords, I'll tell
14
you, your
years have
lordships are
lapsed.
holding that Vedanta's matter. Lords, what happened? This court directed release since there was no charge sheet, or my lords, insofar as SIT is concerned, B report was filed. This court said release it. State went to the Honorable Supreme Court. Supreme Court said the entire matter was transferred from Ankola court to, that's where COD was investigating. It was transferred to CBI, and the special court at Bangalore, my lords, which was the competent court, they said you have to file an application under 451, 457, seeking release from that court, which is the jurisdictional court. So Vedanta and one more person went and filed application in terms of this order. Then, my lord, the Sessions Court in Bangalore said, I am not the competent court of jurisdiction, and rejected our applications. Then we filed a criminal petition before this honorable court. This honorable court, after considering the arguments, went into the issue. CBI categorically said there is no charge sheet against us. State said there is no case against us. This honorable court said release the ore in their favor. Now that same ore, apart from others, they want to auction in 1.1. So we are saying, so far as this issue is concerned, at least so far as Vedanta and one more person is concerned, it has to go. They can't seek.
That CBI order is not challenged by them.
No.
Directly
CBI,
over
lords,
to
this is the order which I placed last occasion. A coordinate bench.
This order, my lord, the SLP has been drafted, man.
Drafted.
This order.
Drafted.
Yes.
This order is of
Drafted.
September 2023.
Now, my lord,
QoS passed, and in fact, today, I've received the GO, my lord. SLP has been dictated now. They will file.
That doesn't matter. Then 1.1 has to go. They can't keep 1.1 here and say, I will auction the ore.
No, I'll auction and I'll keep the money because the port has to be cleared. If it is stolen, my lord, that stolen goods cannot be released to the person who has stolen it. That's the whole purpose. Therefore, let me verify, my lord, where exactly is this, because it's a 14, not 14.
On Monday.
Monday.
Please.
Seal number 2.
Yes,
for
sir.
consideration.
Second matter, my lords, I appear for respondent.
Yes.
Plus, I was unable to secure the records, my lords. A short accommodation I'm requesting, my lords.
I've served,
Lordship would have it on 18, so that I'll make my submissions
I
on that.
served a copy in the morning. Very same
Yeah.
thing what the court has asked him to produce.
That is incomplete, my lords. I'll just, my lords, secure from
This is
my
the
end
order of,
with my
order of
authorities.
local.
It's only till 18th, your
Just
lordship would
pass it on.
accommodate me. I'll secure the records and make my submissions.
Last paragraph 6 is a direction. Essentially, my lords, it shows that the report should come back to the Lokaयुcta office by the ACP.
When do you want it?
On 18th, your lordship, may kindly have, I'll just secure the records. Please.
Producing the copy of the proceedings of the Lokaयुcta is taken on record. Relist on.
Great.
Please, great.
This one pass over matters.
With your lordships, kindly, my lord. List number 2, serial number 5, please, my lord. A request for short accommodation, my lord. Senior is not keeping well today. 16th or 18th, please, my lord. Date may be given. Obliged, my lord.
This one passed over matter, seal number 19.
Number 2, serial number 4, my lord, await records ಅಂತಿದೆ. ಇದಕ್ಕೆ ಅಕೌಂಟ್ ಸ್ಟೇಟ್ಮೆಂಟ್ ಬರಬೇಕು. Lordship, may kindly take it on 18th or 19th, madam.
18th.
Come on this side.
Number 19. Office to issue a reminder to the HDFC Bank at Konankonda branch. Office to issue a reminder to the HDFC Bank.
My lord, list 2, serial number 18, my lord. Appear for the
19th, madam.
petitioner, my lord. List 2, serial number 18, my lord. Any date next week, my lord. The council not keeping well, the council on record.
18. 18.
List 2, serial number 18.
Did you inform Prabhakar?
No, my lord. I'll wait. I haven't informed him, my lord.
Then please wait.
Please, my lord.
Serial number 19.
Petitioner, my lord. They have filed an application and also sketch also. Now, my specific question put to them is whether 16/48, P48, whether that land has been acquired or not. For that, there is no answer. Village map they produce and the other things which are not relevant, they have stated.
Portion of your serial number 16 according to the sketch that they have produced. Which portion of serial number 16?
My lord, I am just,
My lord.
now,
No.
My lords, I will assist my lords in finding the alleged survey number 16 if my lords were to permit. In the map, my lords, at page number 5 is annexure R4. Page number 5 is annexure R4, my lords have.
1 minute.
Please. It's an affidavit filed on 5th of April 2024. My lords could have my copy. 5th of April 2024.
Yes.
If my lords were to have annexure R4, page number 5,
Yes.
on the right hand side top corner, my lords would find survey number 3 and 4 earmarked. Where it is written, my lords, Dimoji Kere Nayakana Halli, where Li comes, my lords, on the top. Next to the Li is survey number 4. Along the map, along the line, if my lords were to notice, there is a name of a village written in a lateral form with one alphabet after the other. It reads Dimokana
Maji Kakinayakana Halliya.
Halliya. Next to Halli is survey number 4 on this side of the map.
Yes.
Below that, my lords, is 6.
Ah.
Below that, my lords could find a forest or a tree-like shape on the map. That is 16 minutes. Admittedly, these are all government lands, my lords.
Sixteen is the one next to that road. 16 is the one next to the road.
That is 19 my lords, as I have been informed.
No. 11, 12, 13.
11, 12, 13.
On top is 14.
14, 15 on top of that. Next is 16 on the right. And below is 17, then comes 18, and then comes 19. It goes like this, my lords. 11, 12, 13, 14 on top, 15 on top of that, 16 to the right of that, 17 below that, 18 below that, and 19 on to the right.
So 16 is below the 6.
Please, my lords. That's exactly what I pointed out. Actually, I called in the caseworker and took an instruction because as my lords are struggling, even I could not find 16 when the map was sent to me. I said the caseworker has to come and point it out to me specifically, and he pointed it out. Now, my lords, I want to bring to the notice of this court certain facets.
What is R4?
Lord, I am the beneficiary.
R4 is the one 2028 one map, my lords, and R5 is the 28
R4 was?
28 one map.
In this, that there's no 16 mentioned, but there is some kind of a dotted indication in the place that you showed as 16. In R4. That is the portion which is not marked in yellow color. It is plain. There's some kind of a dotted circular figure shown in 15. Next to 15, to the right of 15.
Survey number 15, my lords are pointing out?
Yes, next to survey number 14, next to survey number 15. Again below 6 in annexure R4.
Please, my lords.
There is some portion marked as some dotted line.
Yeah, that's what we pointed out. There's like a tree like a structure below survey number 6 is what we are showing as survey number 16.
What does it indicate?
Government land, my lords, Gomal land, a tree. A tree. If we see on top of it, it looks like a tree, my lords. There's a tree like a shape.
How do you say it's government land if it's?
By petition averment also it is admitted that it is government land.
No, factually incorrect.
I'll read out from the petition averment.
Factually
I'll
incorrect
read out from
statement.
the petition averment.
Management is making factually incorrect
I will
statement.
read out from the
Please.
petition averment.
Annexure R5.
Petition averment may kindly be taken.
R5 at R6.
My lords, may please have page number
Incorrect.
4. Page
Misleading.
number 4. I'll complete, my lords. I don't know why the learned council does
No,
this.
it's factually incorrect.
Let me complete, then he can say whatever he wants to
mislead,
say.
please.
Where is the notification?
My lords, notification I have provided in terms of my original statement of objection.
Next year?
R1.
R1.
It starts at page number 7. At 28, my lords could see Gomala. Page number 9, serial number 28. The original statement of objection is filed on 22nd March 2024. Page number 9.
Serial number?
28. Gomala has 120 acres. This is for the entire stretch of 16. And where there has been bifurcation in the very 16, there are there, my lords.
No, in this annexure R4, which was the map which according to you is a part of the notification.
Please, my lords.
16 is not really stated. It is not indicated in the
In
notification.
the map as such, but here in the notification, it comes as 16 here, my
No,
lords.
but in the map annexed to the notification, 16 is not demarcated in specific terms.
It is only shown as I have pointed out. This,
Not
that is
shown.
all. That is all it is.
Karadu Bande,
ಕರಡು ಬಂಡೆ ಹೊಸಹಳ್ಳಿ
ಪೂರ್ವಕ್ಕೆ, ಪಶ್ಚಿಮಕ್ಕೆ, ಹೊರಹಟ್ಟಿ ಗಡಿ. The boundaries also won't tally.
ಬಂಡೆ 2, 3, 11, 15.
ಎಲ್ಲೂ ಯಾವ್ದು ಇಲ್ಲ 2, 3, 11.
ದಕ್ಷಿಣಕ್ಕೆ my lords.
ಇಲ್ಲಿ 2, 3 ಯಾವ್ದು?
ಮೇಲೆ ಇದೆ 2, 3.
No, top should have been survey number 6. The north it should have been survey number 6. Here it is shown as
Lords, I would only request one submission that I would make, my lords. This notification comes out in 2012. The petitioner has approached this court in 2022. By that time, my lords, I have given the land to someone else, sir. They were sleeping over their rights. It is a delay and latches that they are approaching this court on.
you're not able to identify the land that you acquired from the boundaries that you have mentioned in conjunction with the map that you have
My
produced.
lords, that's an 120 acres entire stretch.
But it should, this is the notification that you produce along with the notification.
This is a map we produce along with the notification.
This has a different set of boundaries than the one that is shown in the notification. How do you
Lords, I would say
reconcile that
Dakshinadalli 2, 3, 11 and 15 are given.
ದಕ್ಷಿಣಕ್ಕೆ ಬರೋದೇ ಇಲ್ಲ 2, 3, 11 ನೋಡಿ ನೀವೇ ದಯವಿಟ್ಟು. Nothing to the south is only survey number 16, sorry 15 and 14.
In R5, my lord.
That is the survey number is my instruction, my lords. It dehodes all of that, my lords. I would only respectfully submit
In R5.
that there are 2 already petitions which are filed, wherein similar set of facts that's been reserved for orders. I'm only bringing it for the notice of this court, where again, my lords, in this 120 acres itself, after the issuance of the notification, people have got their rights. At least allegedly, they claim that Sagwali chittis have been issued. Some kind of crystallization of right has happened as such. Petition averment itself concedes, my lords, that they don't have the original Sagwali certificate. From a mutation certificate, they're trying to infer a certain set of right.
What is the date of the Sagwali chit?
They claim the mutation entry. My lords may please have the petition. I'll only read the petition averment. The petitioners are children of late, this is the first paragraph. Ramanna Bovi, residents of so and so and so. The agriculture land originally is government land, which was under cultivation by farmers as unauthorized cultivators. It is a Darkast land. One late so and so was cultivating survey number 16 to an extent of 3 acres. It is a dry land wherein only rain-fed crops, ragi, horse gram were grown in the land. During the life of Ramanna Bovi, that is allegedly father of the present petitioner, application was made by revenue authorities for grant under the Karnataka land.
They claim a grant was made in the year 84.
Please, my lords. They claim, but in the mutation register which they are providing, the survey number is given as 17. And they say further on, if my lords were to continue to read, since Ramanna is illiterate and economically poor, family had no dwelling house, the original grant certificate is not traced out. Next paragraph.
Government.
My lord,
I'll complete, my lord. I'll complete. I'll only
Don't know the correct details about the records. He does not.
No, my lord, I have placed it as the original.
Ignore all that. Let me find out what exactly is the.
Please, my lord, I have no qualms about it.
My lord,
My only stand would be, my lords, my only stand would be if the petitioner is approached after 10 years of the issuance of the notification and crystallization,
What-
I have,
What if you have not notified him at all? What if you have not included him in his notification at all, despite there being a grant? Would the notification be valid?
Lords, if he is not notified, then
Then-
it is not his, the land is somewhere else. There is an issue as regards identification. He himself doesn't know where the land is.
You also don't know where your land is.
My lords, I am only,
Better position.
no, my lords, what I am saying with the deepest of the respect is, I have, that is why he is arrayed me as a respondent, my lords, and saying that in my land it comes.
My lord, the factual thing totally incorrect, my lord. My lord friend is making statement here. Now annexure R5, what he has stated, what he has filed before the Sambal court, my lord can easily find out that in annexure R5.
Grant yaar name prakara?
Our father, petitioner father,
Ramanna Bovi.
petitioner's father,
Esrena?
Venkateshappa's father, Ramanna Bovi.
Ramanna Bovi.
The ಯಾವ district ಇದು?
Malur,
Kolar, Narsapur.
Kolar.
AC DC to produce.
Deputy Commissioner.
The
My lord,
Deputy
one
Commissioner,
more thing which I want to make my statement.
AG is directed.
My lord, one more point, because when assistant second from the deputy commissioner now, an extent of 120 acres reserved for Gomar. Now these persons, they claim that this is the Gomar land where they claim about 64 acres of land granted to this private logistic company of Delhi. Now, by taking the help of local police and politicians, they have occupied more than 89 acres. That should be resolved.
It's not a PAL, I'm only concerned.
No,
with
it's
land.
not PL. And the way in which we are all five villages, we are dependent on this Gomal and grassland. More than 89 acres, they have occupied one aspect.
What is the extent granted to this Ramana Bovi?
Ramana Bovi is 3 acres. 3 acres.
The Deputy Commissioner, AG is directed to ensure an affidavit of the Deputy Commissioner is filed regarding the grant made in regarding as to whether any grant was made in favor of Ramana Bovi in survey number 16. Yavalli ada?
Jakkasandra
village.
Malur
Measuring
Taluk.
3
Malur
acres
Taluk.
wide. C number by LND 16 bar
LND 16.
24-184 as indicated in annexure A to the writ petition. The Deputy Commissioner shall also state what is annexure A?
Actually, is the grant settlement.
Allah, then extract.
The mutation extract. In the year 1984-85, immediately mutation has been
Number
effected in my
16
name.
was subjected to any POD by the authorities, and if so, produce a sketch relating to the POD done in the survey number 16.
16 bar P48 ಮರ 16 bar P48.
ನಾನು ಪೂರ್ತಿ 16 ಬೇಕು ನಂಗೆ 16 ಏನ್
ಹೌದು, ಯಾಕಂದ್ರೆ ಬೇರೆವೆಲ್ಲಾನು ಅವ್ರ ಲೀಸ್ ಡೀಡ್ ನಲ್ಲಿ Alati
ಮಾಡ್ತೀರಾ?
has produced the sale deed and the lease deed wherein they have mentioned
10 days, my lord. 10 days, my lord, because the elections.
The additional objections filed by the KDB is taken on record.
22nd, my lords, if my lords were to enter. 22nd. Deeply obliged. Deeply obliged.
ನೀವು ಪಾಸ್ ಮಾಡಿಸಿದ್ರೆ
Please, Lord, writ of mandamus. My lord, on the earlier occasion, my lord, this honorable court had issued direction to consider my representation. The property was acquired and there was a direction to release the amount.
We consider in account.
Pursuant to the order, only 70
in this
lakhs.
petition,
Representation.
a direction to respondents 2 to 4 to pay the remaining balance award amount to the petitioner along with interest at the rate of 12% per annum from the date of the award till the date of the payment. By considering the representations dated 10/5/2023 and 4/8/2023. In my view, since a representation has been made requesting the respondents to pay the remaining balance award amount along with interest, it would be appropriate to direct ಯಾರು
2 to 4. 2 to 4.
ಯಾರೋ ಒಬ್ರು ಹೇಳ್ರಿ ಎಲ್ಲರಿಗೂ ಬೇಡ.
Respond number 2, my lords.
SLAO ಏನಾಗಿದೆ ಅಂದ್ರೆ ಲಾಸ್ಟ್ ಟೈಮ್
ಮೇಲೆ ಕಂಟೆಂಪ್ಟ್ ಯಾರ ಮೇಲೆ ಅಂತ ಹಾಕಲ್ಲ, ಯಾರ ಮೇಲೆ?
ರೆಸ್ಪಾಂಡೆಂಟ್ ನಂಬರ್ 2. 2
2
2.
Respond number 2 to consider the representation and pass appropriate orders in accordance with a period of 2 months The date of rest of the copy of this order.
And for the respondent election.
Yes. He was arguing that you have not specified the value at all. And you have specified the value at 1,000 rupees.
Yes, Lord.
Lord,
So
sir.
the commercial court will have no jurisdiction.
Yes. No, the point over here is, they filed an application under Order 7, Rule 11, which is for rejection of the plaint. So that being a very drastic step which they have sought for from the court, they should also satisfy the honorable court that an application under 7 Rule 11, first of all, is maintainable.
Is now the question of jurisdiction. Does the commercial court have jurisdiction to entertain a suit for injunction where you value the suit for 1,000 rupees?
Yes, Your Lordship.
How?
I only valued the suit because my prayer is only for injunction.
See the commercial court act, you have to have a specified value.
Yes, Your Lordships.
If you have to specify the value to be 3 lakhs or 2 lakhs, whatever, that is a value for the purpose of the commercial courts act.
Yes, sir.
If you value 1,000 rupees and the court won't have
No,
jurisdiction.
I filed it before the civil court at Bangalore and not before the commercial court. So it's not the case that I have not mentioned the specified value. So when I filed it before the civil court, there is no need for mentioning a specified.
Now the matter is with the commercial court.
No, it's before the civil court. It's before quota number 10.
Where is it
Lordship, the
posted?
matter is posted before the civil court, Lordship. They, under the Commercial Court Act, they are required to mention the specified value. Only after that it can be decided whether this is a civil suit or a commercial suit. If the specified value is less than 3 lakh rupees, then the jurisdiction will lie with the civil court. If it is more than 3 lakh rupees, the jurisdiction will go to the commercial court.
Can the defendant force the plaintiff to determine the state the valuation in the manner that you want?
That's the law, Your Lordship, and on that point, I have submitted the judgment of Ganga Dharappa, on which it was clearly mentioned that even if the subject matter has to be valued, not the prayer, Your Lordship. What my learned friend is saying is that this is injunction simpliciter, therefore the specified value need not to be mentioned, which is not the correct position of the law, Your Lordship. If Your Lordship can read out the one paragraph of the paragraph 12 of the Ganga Dharappa judgment, which is filed in a memo format.
Last time you gave an impression that is before the commercial courts. It is not before the
No, Your
commercial
Lord.
court now. It is
No,
before the
not
regular
at all,
civil
Your
court.
Yes, Your Lordship. It is before
Then
the
what is
civil
wrong?
court. The valuation has not been specified, Your Lordship. If you see the scheme of the Commercial
Yes,
Court
specified
Act,
to be 1,000 rupees.
the specified value is not mentioned, Your Lordship. You kindly see the petition itself. That is at page number. I can show you, Your Lordship. They have not mentioned the specified value at all. What they say, Your Lordship, if you can go to page number, I would have challenged the specified value in that case, but they haven't mentioned. If Your Lordship can kindly go to page number 44 in the bottom.
Can that be a ground under Order 7, Rule 11?
It says, Your Lordship, it's, yeah, Lordship, please.
Which page?
Page number 44 and 45.
Yes.
Of my petition. If you go to page number 44 in the bottom, Your Lordship, point number 28. This is the plaint filed by the plaintiff. He say that the plaintiff submits that for the purpose of court fees and jurisdiction, the suit is valued as per Karnataka Court Fees and Suit Valuation Act. It doesn't mention at all the specified value as required under the Commercial Courts Act.
Why does he have to specify? Why does he have to mention the specified value? If he has to file with the
Your
commercial court, he has to do it. Not if a
No, Your
regular
Lordship.
suit.
I beg to differ, my lord, on this. I have filed a judgment before Your Lordship that the Ganga Dharappa. There is a separate memo, Your
It's an
Lordship.
earlier judgment of Justice Krishna Dixit of the honorable court.
Yes.
So in that, the paragraph 12, if you read, Your Lordship, that say that the valuation for the purpose of the Court Fee Valuation Act and the value, specified value for the Commercial Court Acts are both different things. The Commercial Courts Act specified value is necessary to determine whether the suit would be tried before the commercial court or not. Otherwise, all the suits of intellectual property will become a commercial suit.
No, in Gangadharappa's case, was it
Yes, Your
before the commercial court or before the regular civil court?
It was before the civil court, Your Lordship. And paragraph number 12 answers all the questions related to this. That also examines the valuation under the Court Fees Act. So if I have to, should I read, Your Lordship, one paragraph only, Your Lordship? Para number 12. This
Yes.
say, as per section 2(1) of the Act is a commercial courts act. The specified value in relation to a commercial dispute shall mean the value of the subject matter in respect of a suit as determined in accordance with section 12 of the Act. And if that value is more than 3 lakh rupees, the commercial courts will have the jurisdiction. How a specified value has to be determined in respect of intellectual property has been answered in section 12(1)(d) of the Act. And according to it, when the relief sought in the suit relates to an intangible right, the market value of the said rights, as estimated by the plaintiff, shall be taken into account. Plaintiff has not mentioned the market value for determining the specified value. Thus, irrespective of the nature of prayer, whether be it for declaratory or recovery of the money or bare injunction, this is most important because they say that their petition is only for injunction, or any other prayer for the specified value depends upon the market value of the IP rights. Now, your lordship, if you come down little lower, it says thus under the facts and circumstances of the case, the prayer sought pertains to intangible right, and it is a suit for bare injunction, and the suit is valued at 1,000 rupees for purpose of paying the court fees in accordance with the Karnataka Court Fees and Suits Valuation Act. However, however, for the purpose of jurisdiction, the specified value as contemplated under section 12 of the Act is not mentioned in the plaintiff. Same is our case, your lordship. Now it goes on, your lordship. It says that section 12 of the Act is not mentioned in the plaintiff, and the jurisdiction of the court depends on the value upon the specified value of the IP rights. So sought to be enforced by the plaintiff, which is to be determined by the plaintiff. The specified value is to be determined based on the market value of the right and not on the nature of prayer itself. Now it keeps on going, your lordship, in the paragraph 13 that say the trial court has erred in not appreciating the aforementioned fact and has passed the impugned order by holding that the valuation as per Karnataka Court Fees and Suit Valuation Act is less than 3 lakh rupees, and thus the jurisdiction to try the same is before the civil court. So what I am submitting, your lordship, that the jurisdiction would be determined based on the specified value. There is a notification of 2018, 2008.
We only want you to specify the value. Why don't you specify the value and be done with
only a specified value?
Actually, the courts, this thing in the matter reported by our own High Court, they've said that if you value it as per the thing, they were actually said.
No, it's a commercial dispute as defined under the Act.
Commercial dispute only because he is saying only because it relates to trademark. As far as the specified value, because lordship very well aware, only the twin conditions are satisfied, it should go with the commercial conditions.
As per the definition, it's a commercial dispute.
Yes.
You have not
Yes,
specified the value.
No, I'm not specified.
You haven't
Specify the value. If you wanted to below 3 lakhs, it will remain the civil court or else it will go to the commercial court. Why can't you mention the specified value?
Your lord, turnover is 29,000 lakh rupees in
Turnover
1
got
year.
nothing to do with my specified value.
You do whatever you think because under section 12, you will have to
Market
estimate the
value.
value. But the plane can't be rejected on that ground.
Plane can't be rejected. I am only on the ground that
Your
the plane
lordship,
can't be rejected.
The Gangadharapa itself has given a way out, your lordship. It says that the plaint may not be rejected, but the court can pass a direction saying that you have specified the specified value and let the civil court decide where the
you are before me challenging an order, refusing to reject the plaint. The plaint can't be
Your
rejected on the
lordship.
ground that did not mention the specified value. In the suit, in the decision that you rely upon, a memo was filed asking the court to dismiss the suit because you have not
Your
specified
lordship,
the value. The plaint can't be rejected.
The civil court didn't have the jurisdiction to try this suit, your lordship. This is what we have been arguing before that
I will
court.
record your statement that you will file a specified value. The court will then decide. This revision is filed challenging the order by which the trial court has refused to reject the plaint. Next para. It is a case of the petitioner that the subject matter of the suit being a commercial dispute as defined under the Commercial Courts Act, it was necessary that the specified value as contemplated under section 12 of the Commercial Act be stated in the plaint. And since the plaint did not contain the averment, did not satisfy the said requirement, the plaint was liable to be rejected. Then at counsel for the respondent submits that the plaintiff will file a memo indicating the specified value as required under section 12 of the Act, and the civil court can thereafter determine whether it has jurisdiction or the matter would have to be referred to the Commercial Courts Act. In view of the said statement, there would be no need to entertain this revision, and the revision is therefore rejected. The respondent shall file a memo as contemplated under section 12 and declare the specified value of the suit.
Your Lordship.
In view of the disposal of merits, no need to delay condemn of 4 days.
Your Lordship.
Yes.
Not about around 2 acres plot, nearly 2 acres have been acquired. The preliminary notification is dated 25/11/2002. The final notification is dated 23.
What is the date of the preliminary notification?
25/11/2002. The final notification is dated 23/2/2004. Total extent.
Yes.
ಎಷ್ಟಾಗುತ್ತೆ?
Award pass
Now,
ಮಾಡಿಲ್ಲ.
after that plot, the area remained vacant, no award also has been passed till date. Therefore, my lord, under the view of the in similar cases, this court has taken the view. Land is not developed, award is not passed nearly about 20 years. Then the proceedings are deemed to have been abandoned by the authorities. Court of, sir.
But you don't want to press the first prayer then?
No, first prayer, if they want to give, Lord, I have no objection if they give it the present value, because 2002 value, Lord, they cannot give it to me today. Because of the delay caused by them, let them give the present value under the new act. For that, Lord, I am agreeable, but they are not willing to give it, so therefore.
Yes, Krishna. KDB, ನೀವನ್ನ? Award pass ಮಾಡಿಲ್ಲ.
Petitioners filed writ petitions and others also filed writ petitions. They're up to reach Supreme Court. Some of them are writ petitions are filed, dismissed. After that, madam, we start the proceedings, and in the meanwhile, again, they filed petitions. Now, they are their earlier writ petitions filed by them are dismissed.
No, no,
ಇವ್ರು
not
ಹಾಕಿದ್ರು.
ಇವರು ಹಾಕಿದ್ರು, ಅವ್ರು ಒಪ್ಕೊಂಡಿದ್ದಾರೆ.
ಯಾವಾಗ ಹಾಕಿದ್ರು?
That is dismissed in 2010.
ಯಾವಾಗ ಹಾಕಿದ್ದೀರಿ ನೀವು?
2005.
Para 9
Filed in 2005, 2010 it is dismissed. No interim order there also.
By the petitioners.
Yeah, only one of the petitioner had filed.
1 and 2
That is,
ಹೇಳ್ತಾರೆ ನೋಡಿ ಸರ್.
only
Petition ಎಲ್ಲ ಹೇಳ್ತಾರೆ ಸರ್.
ಎಲ್ಲಿದೆ?
WP ನಂಬರ್ ಎಷ್ಟು?
That is the writ petition.
One 17141.
Huh? That is WP para 9. Para 9 last two. The one petitioners 1 and 2 had challenged it. That came to be dismissed on 1/7/2010. No interim order restraining them from passing proceeding in the matter.
ಇಲ್ಲ ಅವಾರ್ಡ್ ಪಾಸ್ ಮಾಡಿಲ್ಲ ಚಂದ್ರಶೇಖರ್.
There are about 10 to 15 writ petition, writ appeals are there was a print.
ಇಲ್ಲ ಆಯ್ತು, ಈ WP ಅಂದ್ಮೇಲೆ ಅವ್ರು ರಿಟ್ ಅಪೀಲ್ ಹಾಕಿಲ್ಲ ಅಲ್ವಾ?
ಅಲ್ಲ ಬೇರೆಯವರೆಲ್ಲ ಹಾಕಿದ್ರು,
ಬೇರೆಯವ್ರದ್ದು ಬೇಡ, ಇವ್ರದ್ದು ಹೇಳಿ.
ಇವರು ಆಗ್ತಾಗಿಲ್ಲ.
ಹಂಗಾರೆ ಅವಾರ್ಡ್ ಪಾಸ್ ಮಾಡಿಲ್ಲ ಅಂದ್ರೆ then the acquisitions go.
ಬೇಡ, acquisition not go because lordship may see the prior is.
ಅಷ್ಟು 9-10 years ಆದ್ಮೇಲೆ ಮಾಡಿದ್ರೆ ಫೇಟಲ್ ಅಂತ.
ನಾಗರತ್ನ ಅವರ ಜಡ್ಜ್ಮೆಂಟ್ ಇದೆ. Page 17 of my compilation.
Page?
Page 17 of my compilation. Relevant page 34, para 17. In print page 34, para 17.
Yeah.
ಇಲ್ಲಿದೆಯಲ್ಲ ಆಯ್ತು ಬಿಡು ಸೆಕೆಂಡ್ ಕೂಡ ಅದು ಇಂಟರ್ನಲ್ ಪೇಜ್ 18 of the judgment. 18.
Even in the morning, there was one case, just Alokara there sitting in a bench and said,
ಅವ್ರದ್ದು ಇದೆ.
more than 9 years adre, you know, award is passed. It's fatal and
ಅದು that is that page.
ಅಪೀಲ್ ಏನ ಪೆಂಡಿಂಗ್ ಇರಬೇಕು.
SLP, that question of law was left open, but the order was confirmed.
Here, Malada, they sought for compensation. Now, once they sought for compensation.
No, if you are prepared to pay in the 2013 Act, they are prepared to accept compensation.
2013 Act, Malada, according to me, it's
Na ಬೇಡ ಅಂದ್ರೆ ಅವ್ರು ಪಾಸ್ ಮಾಡ್ತೀನಿ ಅಷ್ಟೇನು. There is no compulsion for you to pass an award on 2013. They only press for the notification because you have not passed an award, even though 14 years have elapsed from the date of dismissal of the writ petition.
we are prevented from other petitions, including the.
ಇದಕ್ಕೂ ಏನ್ ಸಂಬಂಧ? ಬೇರೆ ಅವ್ರು stay ತಗೊಂಡಿದ್ರೆ
Last extent, still writ appeals are, some of writ appeals are still pending, Malada.
ಇತ್ಕೊಳ್ಳಿ, but there is nothing preventing from passing an award here. Why should they be deprived of the money for 14 years? ಬೇರೆ ಯಾರ ವ್ಯಾಜ್ಯ ಮಾಡ್ತಿದ್ರೆ ಅವ್ರಿಗೆ ಹೆಂಗ್ ನೀವು?
ಇವರು ಹಾಕಿದ್ರಲ್ಲ, ಇವ್ರು ಹಾಕಿ
ಇವ್ರು ವಜ್ಜಾಗ 14 ವರ್ಷ ಆಯ್ತಲ್ಲ.
ಅದ್ರ ಮೇಲೆ ಅಪೀಲ್ ಹಾಕಿದಾರೆ, ರಿಟ್ ಅಪೀಲ್ಸ್ ಹಾಕಿದ್ರು ಬೇರೆ ಬೇರೆಯವರೆಲ್ಲ.
ಬೇರೆಯವ್ರು ಬೇಡಿ, ಇವ್ರ ಮೇಲೆ ಮಾತಾಡಿ ಹೇಳಿ.
ಇಟ್ಸ್ ಇವ್ರು ಹಾಕಿದ್ರೆ ನೋಡು.
ಇಶ್ಯೂ ಫ್ರೆಶ್ ನೋಟಿಫಿಕೇಶನ್ ಅಷ್ಟೇ, ಇನ್ನೇನ್ ಮಾಡೋದು?
Is concerned.
ನೀವ್ ಯಾರಿಗೆ?
BMRCL is concerned. In the land in question, we have.
Are you prepared to give them that package?
No, we have deposited
The package we also offered.
Metro,
Package we also offered. The last date of hearing, last date of
we have no objection. For Metro.
Last date of
They
hearing,
have given deposited with the KDB, our land.
the last
They
date
pay
of,
the compensation to that extent of land to us, we will not question that.
last date of after hearing, will lordship was asked him whether the compensation payable now 12 crores and act will be more or less when compared to the new act. They taken time, then according to me, it's become less. That's what they made. That's the reason why they taken adjournment today, my lord.
ಇವಾಗ ಅವ್ರೇನ್ ತಗೊಳ್ತಿಲ್ವಲ್ಲ, ಅವಾರ್ಡ್ ಏನ್ ಬೇಡ ಅಂತಾರಲ್ಲ, ಬಿಡಿ ಇನ್ನೇನು.
Lord, the Metro is concerned, in the land in question, my lord, 1169.98 square meters to area, my lord. That after acquiring the land by the KDB, my lord, we have requested to hand over that area, my lord. And we have deposited the compensation before the KDB in the.
ಬಟ್ ಮಾಡಿಲ್ವಲ್ಲ ಬಿಡಿ, ಅದು ಸಪರೇಟ್ ನೋಟಿಫಿಕೇಶನ್ ಅಲ್ಲ ತಾನೇ ಅದು.
ಅಲ್ಲ ಇದರಲ್ಲಿ, but the court has also.
If you are prepared to pay that, they are prepared to give up for BMRCL. The others will quash. If you are prepared to give for that BMRCL extent.
To ascertain, that's correct.
ಆಗಲ್ವಾ ಅದು?
ಗೊತ್ತಿಲ್ಲ, ಕೇಳಬೇಕಾಗ್ತದೆ that extent ಏನು.
ನಿಮ್ಮಿಷ್ಟ, ಕ್ವಾಶ್ ಮಾಡಿದ್ರೆ ಕ್ವಾಶ್ ಮಾಡ್ತೀನಿ ಅಷ್ಟೇ.
ಅಲ್ಲ, no, my submission is, my lord, there, of course, my lord, even for the, there is a delay also in the other parts also. Position is also taken. Now, at the time of passing,
If the declaration is quashed, then what is the effect?
even for that, my lord, they are not entered for this. My submission is this, my lord. Acquisition is already upheld by the Dishonorable Court up to division bench. my lord.
Nobody is saying acquisition is not upheld.
Yes, my lord.
Non-passing of the award is vitiated the acquisition.
Under the, they are seeking declaration under which provision they are not enabled to say, because 24(2) is not
I
applicable.
said, without reference section 24, if you have not passed an award, it is deemed to have been abandoned.
Even Dishonorable Court, my lord, has held that in division bench, my lord, in such a case, the petition is not available, there, such a relief is not maintained, grantable.
So you can issue a declaration and then for 40 years.
Yeah, because this is the last year currently, if suppose they are not filed a writ petition, others are not, they have prevented us. They sit over it, then they allowed, after when they are ready to pay the council, then they come up with this claim, Allah.
29 to offer ಕೊಟ್ಟಿದ್ರು ಅವ್ರಿಗೆ.
ಕೊಟ್ಟಿದ್ದೀವಿ ಅದನ್ನ, ಅಲ್ಲ ಅದನ್ನ
ಅವ್ರು ಬರ್ಲಿಲ್ವಲ್ಲ ನೆಕ್ಸ್ಟ್ ಏನ್ ಮಾಡ್ಬೇಕಿತ್ತು ನೀವು
ಆಮೇಲೆ ಏನಾಯ್ತು, then there was again they filed a writ petition. Now again we initiated proceedings for new act, this one also.
I'll record your statement that for the KDB, for BMRCL acquisition, you have no objection if they have paid the compensation.
Provided they pay it to us. Because that notification is in the year 2020.
No, no.
2020, but we have no objection for them if they pay.
ಅದನ್ನ ಚಾಲೆಂಜ್ ಮಾಡಿಲ್ವ ನೀವು?
We are not challenged. Because ಅದು KDB land ಅಂತ ಅವರು ಕೊಟ್ಬಿಟ್ಟಿದ್ದಾರೆ. We have not challenged, and I am making a statement before the court, if that amount is.
I am only concerned with the 2002 and 2004.
ಅದರಲ್ಲಿ ಏನಾಗಿದೆ ಅಂದ್ರೆ, after that, KDB issued a notification on 3/2/2020, portion of a land which is involved in this notification, deposited before the KDB. I have no objection to hand over that land to them, provided they pay the compensation.
I will record the statement. You not challenge the acquisition either way.
No.
The petitioners here are challenging.
But in that notification, one portion of the land is given to the metro, 2002 notification.
The notifications have.
And I am a permit to pass on division bench.
Seeking for a direction to pass an award in respect to the petitioners acquired lands, is good.
Sir.
As per the provisions of 2013 Act, or in the alternative, for quashing of the notification issued under section 28(1) on 25/11/2002 and under section 28(4) on 11/5/2004. BD Act ಅಂತಂದಿದ್ರ KDB Act ಅಲ್ಲ? Rare BD Act ಅಂತಂದ್ರೆ. In respect of the petition schedule premises. On the challenge to the notifications in the alternative is on the ground that the acquisition proceedings have been abandoned in as much as because the awards have not been passed despite the lapse of nearly 2 decades. It is not in dispute that a notification under section 28(1) was issued on 25/11/2002. And this was followed by a declaration under section 28(4) on 28/2/2004. But it is also not in dispute that the petitioners preferred WP 1741/2005 in the year 2005, and the same was dismissed on 1/7/2010. Next, it is also not in dispute that though more than 14 years have elapsed since the date of dismissal of the writ petition, the learned senior counsel appearing for the petitioner submits that since no award has been passed for the past 14 years from the date of dismissal of writ petition, it is deemed that the acquisition proceedings have been abandoned. Reliance is placed on a division bench ruling of this court in writ appeal number 100219/2018, disposed of on 5th of December 2018.
And also division bench at page 37.
And also
Just
another ruling of the division bench passed in writ appeal 4583/2011 on 1st of February 2023. That paragraph?
Para 13 at page 57.
Learned counsel appearing for the KDB submits that it would be impermissible for the awards to be passed under the 2013 Act, having regard to the fact that the acquisition is of the year 2004. So as far as non-passing of the award, learned counsel submits that the awards could not be passed in view of the pendency of several writ petitions, from writ appeals,
SLPs
and
and
SLPs
RPs.
in respect of the said notifications
by others,
Including petitioners.
It is not in dispute that the petitioners only challenged the acquisition in the year 2005, which ended in a dismissal in 2010. It is not in dispute that thereafter the petitioners have not preferred any appeal and have accepted the acquisition. Despite this fact, no awards have been passed, though more than 14 years have elapsed. Next, the argument of the learned counsel for the KDB that the awards could not be passed in view of the pendency of several other litigation filed by other landowners cannot be accepted. Full stop. It is to be stated here that the awards are passed in respect of the individual in respect of the lands separately, and merely because the litigation is pending in respect of some other lands, the passing of an award cannot be withheld. Next, the division bench of this court in writ appeal number 100219/2018 as held as follows, para 4, para 17, and in writ appeal number 4583/2011 as stated as follows. Next, in this, in the light of the judgment of the division bench, having granted the fact that the awards have not been passed for nearly 14 years from dismissal of writ petition, the acquisition proceedings cannot be sustained. Consequently, the notifications dated 25/11/2002 and 28/2/2004 issued under section 28(1) and 28(4) of the KDB Act, insofar as the land of the petitioner concerned, is quashed. Next, Learned Senior Counsel submits that in respect of a portion of the petition lands.
Portion of land belonging to petitioners 1 and 2.
Belonging to petitioners 1 and 2. The KDB had issued another notification dated.
Notification
3
issue
to
ಮಾಡಿಲ್ಲ sir.
Notification.
3 to 20.
He is saying I am recording his statement.
ಆಯ್ತು ಮಾಡು.
ಅಲ್ಲ ಅವ್ರು ಮೆಟ್ರೋದವ್ರು ಹೇಳು.
ಪ್ರೊಸೀಡಿಂಗ್ಸ್ ಹೇಳ್ತಾರೆ, ನೋಟಿಫಿಕೇಶನ್ ಇಲ್ಲ ಅಂತ.
ಹಾ?
ಎಲ್ಲಿದೆ ತೋರಿಸಿ ಸರ್.
ಅಲ್ಲ ಆಗ್ಲಿ, ನೋಟಿಫಿಕೇಶನ್ ಇಲ್ಲ ಅಂದ್ರೂ we are ready to.
Learned Senior Counsel submits that a portion of the petition schedule plans belonging to petitioners 1 and 2 have been earmarked for use by BMRCL. He submits that the petitioners are ready to hand over this land, provided the package compensation is as offered by BMRCL is put forth to them.
Petitioner
This
2
statement
is
is on
present in
record.
the court. Petitioner number 2 is present in court also. Because ಆಮೇಲೆ ನಾಳೆ.
Learned Senior Counsel on instructions from the second petitioner who is present in the court submits on it.
My lord, that
And the
compensation is
second-
have already deposited in the KDB.
No, he is prepared, I have, all that I've said is he is prepared to hand over, provided that package amount is paid. If both of you pay, he will give up the land.
And
We have
second-
already deposited the package, my lord, with the KDB. My lord, this
Learned
one,
Counsel for
my lord, this.
BMRCL submits that the compensation amount in respect of the lands needed for BMRCL has been deposited with the KDB. So if the KDB is prepared to pay the said package amount to the petitioners, the statement of the petitioners that they would hand over possession of the land, which is earmarked for the use of BMRCL, is placed on record.
This one
Yes.
court already
Second
permitted the
petition, my
BMRCL
lord.
to.
Second petition, one of the family member, they given a consent for acquisition.
Second matter,
Second matter, I filed affidavit of that.
ಇನ್ನೊಬ್ರದ್ದು
ಫಸ್ಟ್ ಕೇಸ್ ಅಲ್ಲಿ ಇಲ್ಲ, ಅದೇ ಕನೆಕ್ಟೆಡ್ ಮ್ಯಾಟರ್ ಅಲ್ಲೇ ಅವ್ರು ಕೊಟ್ಟಿದ್ದಾರೆ ದೇವರ.
ಇನ್ನೊಬ್ರದ್ದು ಏನ್ ಮಾಡ್ಬೇಕು ಹೇಳಿ?
Same connected minutes.
ಕರೆಕ್ಟ್, ಒಬ್ಬರು ಮನೆಯವ್ರು ನಾನು ದುಡ್ಡು ಕೊಡಿ ಅಂತ ಕೊಡ್ತಾರೆ.
ಪೂರ್ತಿ ಕಾಸು ಕೊಟ್ಟಿದ್ದಾರೆ ಅವ್ರಿಗೆ.
ಈ petitioner given any, not given any consent.
ಇಲ್ಲ, ಈ cannot, unless and determine, numericate how many extent. One of the family member comes and says, I have no objection.
ಇಲ್ಲ, ಸರ್ ನಂಬರ್ 109/3 13 ಗುಂಟೆ.
ಹಾ.
ಅಲ್ವಾ?
ಹೌದು.
ಯಾರು ಕೊಟ್ಟಿರೋದು ಕನ್ಸೆಂಟ್?
ರಾಮಚಂದ್ರ.
ದೇವರಾಜ್ is the petitioner.
Devraj is not given any consent.
Where is the consent award?
Affidavit I produced.
Any objection? Our objection.
ರಾಮಚಂದ್ರ, yes.
ಇವ್ರ ಹೆಸರು ಇದರಲ್ಲಿ ಖಾತೆದಾರ ಆಗಿದ್ದೀರಾ?
ಅವರ ಇದೆಲ್ಲ ಫ್ಯಾಮಿಲಿದು, ಅವ್ರ ಫಾದರ್ದು, ಪಿಳ್ಳಪ್ಪ ಖಾತದ, ಈಸ್ ನಾಟ್ ಖಾತದ. Petitioner is not alone the ಖಾತದ. ಪಿಳ್ಳಪ್ಪ ಖಾತದ.
ಖಾತೆದಾರ is ಪಿಳ್ಳಪ್ಪ.
His father, one brother gives and says, I have no objection.
So you act upon one brother's.
I have not acted, I am placing that record, my lord, the affidavit, because amount is not dispersed.
6 sons, Pillappa having 6 sons.
One son is given.
ಅದೇ ಅವ್ರದ್ದು ಎಷ್ಟಿದೆಯೋ ನೀವು ಬೇಕಾದ್ರೆ ಭಾಗ ತಗೊಂಡು.
That may be observed, my lord, because in all fairness, they could have said, they never said, and one person cannot maintain also.
ಅವ್ನ ಶೇರ್ ಏನಿದೆಯೋ ಅಷ್ಟು ಮಾಡ್ಲಿ.
ಅವ್ರು ಹೆಂಗ್ ಡಿಮಾರ್ಕೆಟ್ ಮಾಡ್ತೀರಾ?
That's a problem, my lord. That's what I am saying. Even he cannot maintain for entire extent also.
Same principle.
I leave it to.
My lord,
I given two side judgments, my lord, that may be referred.
in judgment, sir.
Now, one is division bench, is also cannot be quite another Supreme Court, my lord. And even for that earlier also, they are not entitled for compensation.
Give to the.
Because of previous litigations.
ಯಾವ ಜಡ್ಜ್ಮೆಂಟ್ ಹೇಳ್ಬೇಕು ಕನ್ಸಿಡರ್ ಮಾಡೋದು?
ಅಲ್ಲ ನಾನು ಎರಡರಲ್ಲೂ ಹೇಳ್ತೇನೆ, ನಾನು ಡಿವಿಷನ್ ಬೆಂಚ್ ಅಲ್ಲೂ ಕಾಸ್ಟ್ ಡಿಕ್ಲರೇಷನ್ ಕೊಡಕ್ ಬರಲ್ಲ ಅಂತ ಹೇಳಿದ್ದಾರೆ.
ಡಿಕ್ಲರೇಷನ್ ಕೇಳ್ತಿಲ್ವಲ್ಲ, ಕ್ವಾಶ್ ಮಾಡ್ತಾ ಇದ್ದಾನೆ ಅಷ್ಟೇ.
This is 2020.
This is different.
ಇದು 24 to,
Before to.
ಇದು ಅಪ್ಲೈ ಆಗಲ್ಲ 24.
Not one submission, the lordship passed the, in so far as the petitioners are concerned, because my lord,
What I said.
because the, my lord, the, in the, that notification we have.
That is why I said in so far as the petitioner's lands are concerned.
Except a portion of the metro ಅಂತ ಬರೀತಾರೆ. Otherwise.
No, I said the acquisition is quashed. But I have taken a statement on record that in this, that portion earmarked for BMRCL use.
That has
You
to
are
be,
prepared
that has
to
to be
pay.
saved, madam. To that extent, it has to be
I have
saved.
not saved it. If you are,
Otherwise, we can't, they can't get a title, we can't transfer to them.
you're not prepared to pay that amount even now. If you're prepared to pay that, to that extent, I'll uphold that acquisition of that portion, if you demarcate that right now.
That acquisition cannot be upheld, my lord, because that is.
Now, if you want the money,
No,
if you
I
want
have
the money, they will, they'll.
As on that day, whatever they are giving consent award, metro, whatever they give, I have no
No,
objection.
but to that extent, I have to uphold that.
Not necessary, my lord, because the KDB.
If I quash it, title will be with you. How can they pay money to your?
KDB notification, they have initiated proceedings in 2020.
They are not agreeing that, that's why I said I'll make a clarification. He said, there's no such.
But the original acquisition proceedings cannot be saved because that is issued in 2000, 2002 value ಕೊಡ್ತಾರೆ ಅವರು.
2020, if it's consent about no question of valuation as on the date of the preliminary
Correct.
notification.
No, 2020 valuation ಮಾಡಿದ್ದಾರೆ.
ಅದೇ ನೀವು ಅದನ್ನ ಒಪ್ಕೊಳಂಗಿದ್ರೆ ನೀವು acquisition so far as that portion is concerned, I'll uphold. I can't quash the
Acquisition can
notification.
be upheld, but 2002 notification uphold ಆದ್ರೆ ಅವ್ರು ಅದನ್ನು ಕೊಡೋದಿಲ್ಲ ನಮ್ಗೆ.
ಅದೇ ನೋಟಿಫಿಕೇಶನ್ ಅಲ್ಲಿ ನಮ್ಗೆ ಲ್ಯಾಂಡ್ ಕೊಟ್ಟದ್ದು.
ಅದನ್ನು ಕೊಡೋದಿಲ್ಲ ಅವರು, ಬಿಕಾಸ್ 2002 ವ್ಯಾಲ್ಯೂಯೇಷನ್ ಮಾಡ್ತಾರೆ. ಈಗ ಕೊಟ್ಟಿರೋದು 2020 ವ್ಯಾಲ್ಯೂಯೇಷನ್.
Both of you file a joint memo for that 2000, that.
ಅಲ್ಲ, we have deposited as per the 2000.
ಎಲ್ಲರ ಡಿಪಾಸಿಟ್ ಮಾಡ್ಕೊಳ್ಳಿ 3.5 ಗುಂಟಾಸ್.
Order 2020 valuation, whatever the value.
No, if I have direct them to pay you compensation, I have to uphold the acquisition. I cannot quash the acquisition and thereafter still ask them to pay.
Correct, my lord. Now let them determine their rights independently, because I am agreeable, let them, it can be sorted out otherwise.
ನೀವೇ ಮಾಡ್ಕೊಳ್ಳೋದಕ್ಕೆ ನಾ
But we have no objection.
My lord, BMRCL is concerned, this honorable court already permitted to proceed with the project, my lord. This honorable pass the order, my lord. The order copy in the.
ಈಗ ಹೋಗುತ್ತಲ್ಲ, if I'm allowing the writ petition ಹೋಯ್ತಲ್ಲ.
Allah, we have deposited, my lord, the work is already, project was more than 75% completed.
That's why I kept asking him, you demarcate and he is agreeable, you, both of you are not agreeable.
Well, agreeing my question, my lord, I have already the consent award deposited in the KDB, my lord.
So far as.
Per acre, 12.1.
ಅವ್ರ ಕನ್ಸೆಂಟ್ ಅಮೌಂಟ್ ಒಪ್ಕೊಳಂಗಿದ್ರೆ ಅಕ್ವಿಷನ್ ಅಪೇಲ್ ಆಗ ಕನ್ಸೆಂಟ್ ಅಮೌಂಟ್ ಆಫರ್ ಮಾಡಿದಾರೆ ಅವ್ರು ಎಲ್ಲರೂ ಕೊಟ್ಬಿಟ್ಟಿದ್ದಾರೆ.
ಅದೇ ನೀವು ಇವತ್ತು ಇಷ್ಟು ಪೋರ್ಷನ್ ಕೊಡ್ತಾ ಇದೀವಿ ಅಂತ ಅಂದ್ರೆ.
ಅಲ್ಲ, ಇವನ್ ಎಂಟೈರ್ ಎಕ್ಸ್ಟೆಂಡ್ ಗೆ ಕನ್ಸೆಂಟ್ ಅಮೌಂಟ್ ಆಫರ್ ಮಾಡಿದಾರೆ ಅವ್ರಿಗೆ.
ಎಂಟೈರ್ ಅಲ್ಲ, ಇವಾಗ ಅವ್ರು ಹೇಳೋದು BMRCL ಜಾಗಕ್ಕೆ ಮಾತ್ರ ಅವರು ರೆಡಿ ಇದಾರೆ ಆ ರೇಟ್ ಕೊಟ್ರೆ. ನೀವು ಮೆಮೋ ಹಾಕ್ರೆ ಐ ಅಕ್ಸೆಪ್ಟ್ ಇಟ್ ಅಂಡ್ ಅಪೋಲ್ಡ್ ದಿ ಅಕ್ವಿಷನ್ ಇನ್ ಸೋ ಫಾರ್ as that extent is concerned.
ಎಷ್ಟು ಎಕ್ಸ್ಟೆಂಡ್ ಬರುತ್ತೆ? In view of their statement, they are willing to receive the complaint to that extent, my lord. They may time, your lordship may say they have given up to that extent, your lordship may record this and dispose of it.
ನೀವು ಕೊಟ್ಟಿಲ್ವಲ್ಲ ಕಾಸು.
ಅಲ್ಲ, ಅವ್ರಿಗೆ ಅಕ್ವಿಷನ್ ಗಿವನ್ ಅಪ್ ಮಾಡ್ಕೊಂಡ್ರೆ ಡೆಫಿನೆಟ್ ಕೊಡ್ತಾರೆ ಅವ್ರಿಗೆ.
ನೀವು
ಅಲ್ಲ, because they cannot say, once it is quashed, my lord, they can say no objection to that extent also.
You file a joint memo that you will pay them this compensation for this particular extent, then I'll modify the order accordingly. ನಾನು ಆರ್ಡರ್ ಮಾಡಿರ್ತೀನಿ, ನೀವು ಯಾವತ್ ಮೆಮೋ ಕೊಡ್ತೀರೋ ಐ modify it accordingly.
Yes.
ಮಾಡ್ಕೊಡಿ, we will, no objection.
29.1 ನಲ್ಲಿ same order. Learned counsel for the KDB over submits that one of the sons of Pillappa, the notified Khatedar, has filed an affidavit stating that he is agreeable for accepting the compensation
Yes.
of rupees compensation at the rate of 12.1 crore.
12 crores,
per
10
acre.
lakhs.
And the notarized affidavit, copy of the notarized affidavit is also filed. Next paragraph. Having regard to the fact that the notified Khatedar was Pillappa, and it is admitted by the parties that Pillappa had 6 sons, merely on the basis of a statement of one of the sons, the acquisition cannot be upheld. Consequently, the acquisition of the lands in respect of 13 guntas of land is quashed. Its liberty is however reserved to the KDB to secure the share of Ramchandraya, son of late Pillappa, who has executed an affidavit stating that he is prepared to receive the compensation. So if Ramchandraya is able to secure his particular share and hand over the same to that extent, notwithstanding the quashing of the notifications, the KDB would be entitled to those lands. Yeah, implementing yaar?
Including beneficiary. Lakeview.
IF implementing allowed. Cost rate amendment ಮಾಡಿ.
Impleading not by the metro miller. Second petition ಅಲ್ಲಿ
Who filed the impleading? ನೀವ್ ಯಾರಿಗೆ? ಯಾರಿಗೆ?
Beneficiary of the KDB acquisition, but the earlier the KDB was acquired land for the benefit of the.
There were parties in earlier petitions also, my lord. Earlier proceedings, there were parties.
Lakeview Tourism Corporation. Uranic property, why are they interested?
The land was earlier acquired on.
They were the parties in earlier proceedings also, first round also. my
They are not parties.
Sorry.
They are not parties in our reputation.
I'll allow the application. What difference does it make?
Yes.
The application for amendment is allowed, cost rate to be amended. How to should not.
This is a judgment.
Judgment is in favor of the appellants, my lord. The judgment, what it was referred to be seen.
Then I can't reject the plaint.
No, it is in favor of appellants, my favor, my lord. It is very clear. ಇದ್ರಲ್ಲಿ ಏನಾಗಿದೆ ಅಂದ್ರೆ, my lord, the section 16 subclass 3 has only accorded legitimacy, not co-partnership. Based on that point, the Supreme Court has
Para 78.
kindly peruse page.
From 81 is.
Page 39, my lord, of the judgment. From there, it clearly clarifies. Part H. Page 39, it starts property of the parents. May I read out?
78, my lords. It says, my lords, they are also entitled in the property of the father. My lords, what the father acquires in the.
Come to page 80, per 81.10.
Yes, my lords. Yes, my lords, the provisions of Hindu Section Act of 1950 has to be harmonious with the mandate of section 16(3), which indicates that a child who is conferred with the legitimacy under subsection 1 and 2 will not be entitled to rights or the property of a person other than the parents.
Amen.
The property of the parents where the parent had an interest in the property of a joint family governed under the Mitakshara law has to be ascertained in terms of the explanation to subsection 3 of interpreted the above. Lords, in view of this, Lords, he has acquired a property, certain property. Lords, father has acquired a property. My lords, in that property, my lords, the father's share.
Therefore, the plaint can't be rejected.
My lords, I am.
Even if it's in.
Yes, my lords, plaint cannot
Millard,
be rejected.
Millard.
He is the defendant, my lords, who has filed an application.
My submission maybe heard. Now, as per this judgment, it is very clear that the section 16 subclass 3 accords legitimacy to the illegitimate children, but does not accords co-personary, right of co-personary in the co-personary property. Now, what happened? Kindly permit me to read the explanation given in this judgment. Now, here I have filed a suit for partition.
Please read the conclusion and tell me what is the which part of the conclusion applies to you. The conclusion is at para 81.
Millard, kindly go to para 42, Millard. Parental property. It starts from there.
The conclusion. Show me the conclusion.
81. (81.1, 2 and 3). My lords, everything is answered.
ನೀವು ಓದಿಲ್ಲ ಅಂದ್ರೆ ಇನ್ನೊಂದ್ ಸ್ವಲ್ಪ ಬೇಕಾದ್ರೆ ಓದ್ಕೊಂಡ್ ಬನ್ನಿ.
ಇಲ್ಲ ಸ್ವಾಮಿ, I am very much sure. (81) subclass 3 is in favor of.
ಪೂರ್ತಿ ಓದ್ಬಿಡಿ ಯಾಕೆ.
While conferring legitimacy in terms of subsection 1 on a child born from void marriage and under subsection 2 to a child born from a voidable marriage, which has been annulled, the legislature has stipulated in subsection 3 of section 16 that such a child will have rights to or in the property of parents and not in the property of any other person. Now, I am the other person.
Now come to 81.10. He is entitled to a share in his parents' property.
Here it is not he.
Sampagiramaya's property.
It is she. Now here the suit for partition, what is filed by her is not in respect of the property allotted to Sampangiramaya. It is entire property.
She is entitled to a share in Sampangiramaya's interest.
Millard, my submission before the Honorable Court is that, Millard. Now kindly peruse the prayer of the plaintiff. Her suit is not in respect of the share allotted to Sampangiramaya. See, only when she gets property.
81.10 ಓದ್ಬಿಟ್ಟು ಆಮೇಲೆ ಹೇಳಿ. That has to be ascertained ಅಂತಂತಾರೆ. I don't want to hurry you. If you want to go through the judgment, go through the judgment.
I have gone through, my lord. If I may be permitted to make my submission, or else a date may be fixed.
If you are sure.
I am very much sure, my lord.
Argue.
May I take this Honorable Court to para 42, my lord. That is my.
Para 42 is not the conclusion.
No. It's not about conclusion. It's the finding of the Honorable Court with regard to the definition property of the parent. There is.
That has to be ascertained. 18.10. .
1 42 is the reasoning. Please come to the conclusion. Show me from the conclusion. Ashta.
.10 is also in my favor only. The provisions of Hindu Succession Act 1956 have to be harmonized with the mandate in section 16 subclass 3 of the HMA Act, HMA 1955, which indicates that a child who is confirmed with the legitimacy under subsection 1 and 2 will not be entitled to rights in or to the property of any person other than the parents. The property of parent where the parent had an interest in the property of a joint Hindu family governed under the Mitaksara law has to be ascertained in terms of explanation to subsection 3 as interpreted above. Subsection 3 clearly categorically says that it is in respect of the co-partnership rights, that is legitimate child who will be a co-partner by birth, but not in case of illegitimate child who has not been accorded with the right of co-partner. Just is it's the child's illegitimacy has been legitimized. Then the other's property will come when in our case, in the case on hand, only myself and my father are the surviving co-partners. A partition suit was filed by me. A partition was accorded. A decree has been passed in my favor. Now I have a separate share as per the judgment. Now the suit is filed in respect of entire property.
She can go against the share of.
That's now the prayer is not as such, my lord. Hence, the plaint has to be rejected.
Ask for a larger prayer, but the court can grant her a lesser prayer.
My lord, now
She can reject the plaint on that ground.
For rejection of the plaint, my ground is she cannot claim my property. Now the plaint government is read out.
That is your defense.
It's not defense. Our plaint itself is as such, my lord.
Your defense is that there is a decree in your favor,
Yes,
which is
my lord.
concluded. Therefore, your share can't be diluted. She can nevertheless go against her father.
That is
who is a
there. She has to file a fresh suit for partition against her father in respect of the property. Now, still our father's property is not yet divided. Still execution petition is pending, my lord.
I can't reject the plaint.
No, I will convince this honorable court because now her father's share is also not been divided by mutation bounds.
Subject matter of trial. I cannot, on the basis of your statement, reject the plaint.
My date may be fixed. I will try to convince this honorable court once again, my lord, because execution petition is pending. This judgment once again I will read it out and I will try to convince this honorable.
The list.
Okay.
Much of.
So I prepared a brief note of submission to cut short my submissions. It's the acquisition preliminary notification is of 28/5/1984. The final notification is 23/10/1986 by the BD under the BDA Act. It was abandoned apparently because the land was, my lords, non-agricultural. It was a industrial area where factory was operating. And my lords, no steps were taken for over 30 years, 37 years. So I filed a writ petition in the first instance before this one, where I prayed for declaring that it has lapsed under 27, also seeking, my lords, in the alternate for payment of a compensation in terms of the new act, because I've been deprived of, my lords, my property for such a long time. This honorable court, my lords, without going into the merits of the case, merely directed the authority to consider my representation. The authorities did not consider, but the LAO has passed an award thereafter in 2021, awarding, my lords, the compensation on the value as it existed in 1981, challenging both that award as well as, my lords, taking a contention that it has lapsed, my lords, the present writ petition has been filed. On factual aspect, my lords, may I seek my lords' indulgence to permit me to read from page 2. The two notifications are challenged and an award passed after 37 years, my lords, pursuant to the order of this honorable court. Now, my lords, the scheduled property was initially converted for non-agricultural industrial purpose by the order dated 23/11/1964 in favor of the predecessor of the petitioner's father, and a conversion sanction certificate was issued by the Tahsildar in 1965, which I have placed on record the document substantiating that. Thereafter, by a sale deed of 1972, petitioner's father had purchased the scheduled property and had set up and started a cable factory on the land in question by name Odia Insulated Cable.
Conversion was before the acquisition?
Yes, my lord, much before the acquisition. Upon purchase of the scheduled property, CITB, erstwhile BDA, via its board resolution bearing number so and so, had sanctioned a development plan for the purpose of construction of a cable manufacturing company, insulated cable company, which my lords have placed on record as Annexure D. The factory of this petitioner is running till date, consisting of several RCC structures, and is being assessed to property tax by BBMP as non-agricultural industrial land with electricity connection, etc. After demise of Krishnappa, my lords, the lands have fallen to the shares of the children. The scheduled property amongst large extent of other lands, that is about 523 acres, 5 guntas, was notified by the BDA, erstwhile CITB, by notification dated 28/5/1984 for the purpose of formation of east of NGF layout. Thereafter, a final notification was issued on 23/10/1986 without application of mind as to the need to acquire this industrial land. It is also relevant to point out the declaration notification issued by the state government does not disclose that the impugned scheme has been sanctioned by the state government under section 18(3) of the Act. Petitioners had filed their objections and had addressed representations to the BDA.
You gave them the idea to pass an award, therefore they passed the award.
My
Like
lords,
thinking for that prayer.
it was
you
only
gave
an
them-
alternate prayer. Thinking, my lords, in that proceedings, since amendment had taken place, they must make that prayer. Lords, if they give me the compensation in terms of the new act as on today, it could be considered as, my lords, proceedings not
What is the
warranted
reason for not passing an award?
My lord,
for 37 years, only after I filed. Lords, just one more sentence,
award-
just one more sentence. The writ issued by this honorable court earlier was to the
Consider.
BDA to consider. Nobody has considered. They make a report to the contempt court that they have passed an award. While, my lords, award is passed by the LAO without reference to, my lords, any one of these issues that I have raised or consideration of, my lords, my grievance, which the court had directed to consider. My grievance is that it has lapsed, that there is a factory running. In the light of
Date of
this,
the award?
the date of the award, my lords, is
29/5/21, my lord.
Okay,
29
35 years.
May 2021.
35 years.
25.
37 years. My lord.
My lord,
Let's placed on record judgments.
Let us see what he will say.
Yes,
my lord, kindly say the page 139, man. Earlier expedition.
No, forget about the repetition. What is your ground for 37 years?
My lord, my lord, kindly see this, I make the submission on this point also.
But iದ್ರ ಆಮೇಲೆ ಬರೋಣ ಫಸ್ಟ್
ಅಲ್ಲ.
ಕಾರಣ ಕೊಟ್ಬಿಡಿ ಏನು what is the reason? There was no stay.
There was no stay.
acquisition.
There was no stay. But the, my lord, in the earlier writ petition also, the petition sought for the compensation, one of the ground. Once, my lord, this full bench of this honorable court also held.
Even now they're ready if you're going to give them under
No,
2013 Act.
BDA
You
is
will not-
concerned, my lord, the Supreme Court itself held, my lord, the 1894 Act is because in way of, there is no amendment to the BDA Act. Only the 1894 Act is the applicable.
ಅಷ್ಟೇ ಅಲ್ವಾ?
My lord, kindly see the page 139 and 140, my lord.
Yes.
Make my submission. My lord, in page 140, my lord, earlier the writ petition filed by the petitioner seeking, my lord, they themselves, they are seeking the, my lord, first prayer, issue mandamus directing the respondent one and to complete the acquisition process. The, of the petitioner land measuring 1 acre 11 guntas in survey number so and so. And pass the award under right. Therefore, my lord, the petitioner themselves made the prayer seeking for continuation of the acquisition and seeking for a prayer. My lord,
That was their mistake, their mistake. They shouldn't have filed the writ petition. ಸುಮ್ನೆ ಇದ್ರೆ ನೀವು ಸುಮ್ನೆ ಇರ್ತಿದ್ರಿ.
No, no, my lords, after that, I went before the court, same court in
My lord,
a review petition, only on facts, review petition. Court had said, I have not gone into anything, everything is left open to be decided by the authorities and
Because you filed the writ petition, you gave them that idea.
they have, no, the BDA has not passed an order. BDA has not considered my representation. Kindly see the writ cost
They
item.
would have asked the land acquisition officer to pass an award. ಕಾಸು ಕೇಳಿದ್ರಲ್ಲ ಕಾಸು ಕೊಟ್ಬಿಡೋಣ ಅಂತ ಹೇಳಿದ್ರು ಅಷ್ಟೇ ಅವರು. That is all that has happened.
My lord, their prayer in the writ petition to continue the acquisition and pass the award, my lord,
Now their prayer, the writ petition to cost.
no, that prayer, my lord, already they have left that prayer was, my lord, they have forgone in the earlier writ petition because they, in their prayer, my lord, they are only seeking that consider their representation. They restricted their prayer only to the representations. Thereafter, my lord, that order, my lord, is also dealt with in the contempt case by the division bench. My lord,
Review order ಎಲ್ಲಿದೆ?
review order, my lord, for that I make one submission, my lord.
I'm just asking, I want to see the review order.
Lords, IA 1 of 2023 for production of additional documents. At page 5, my lord finds the review order. At page 7. Let's kindly see para 2, my lords, before I read the operative portion. Para 2, it is contended by the learned counsel for the petitioner that in the present petition, pursuant to the impugned order dated 30/11 passed by this court, respondents have passed an award dated 29/5, which has been assailed by the petitioner in WP. It is the grievance of the petitioner that in view of the objections filed by the respondents in the said writ petition, the impugned order deserves to be clarified by directing that the same shall not affect the rights and contentions of the parties. In particular, the petitioner in the aforesaid writ petition pending adjudication before this court. Therefore, my lords, the order was made, impugned order dated so and so is by clarified, directing that the impugned order will not affect the cause, prejudice the right of the contentions of the petitioner and the respondents pending before this court, and all the rival contentions on aspects are kept open and no opinion is expressed by the same. So therefore, my lords, after I realized that the order, the stand which is being taken of res judicata, my lords, I had made a submission that I wanted to go into the merit. Court did not go into the merit. It merely said you address their grievance. And my lords, wrong submission was made before the contempt court saying that they have passed an order. The order of the contempt court is that they have passed an order giving me liberty to challenge that order. There is no order by the BDA. It is the award passed by the land acquisition officer, which was represented as compliance of the order of this honorable court. Therefore, my lords, I am before this honorable court again urging the same contentions because this honorable court has also taken a view that these are all continuing grievances which can be agitated, my lords, before this honorable court. They are continuous cause of actions which, my lords, the court has dealt with, which the BDA has accepted. This order was made after hearing the BDA. So therefore, they can now take a contempt.
My lord, I will rely upon two judgment, my lord.
Yes, please.
That you can pass an award after 37 years.
Pardon me.
You can pass an award after 37 years ಅಂತ ಹೇಳಿದಾರ?
My lord, themselves, my lord, before the court, my lord, seeking for continuation of the acquisition. And my lord, they have second prayer is for the compensation. Kindly, my lord, page in the citation, my lord, page 13, last paragraph in the full bench judgment of this honorable court, my lord, in the.
No, that was a case wherein they had challenged the acquisition And at the same time, it sought for compensation.
Yes, here
They are
also,
now before this court saying that you could not have passed an award 37 years afterwards.
no,
They had requested for passing an award under the 2013 Act. If you are ready to pay, they are ready to take.
no,
You are not ready to pay under the 2013 Act, there ends the matter.
no,
Their prayer comes to an only regarding that.
no, my lord, the first writ petition itself, there is no liberty was given to the petitioner in the first.
No
writ
liberty was given to you to pass an award.
There is a representation is for the passing of the award. That was complied. Therefore, in the contempt, my lord, the last paragraph 14, my lord, the first page 13, my lord, because the division which this are held that once if they sought for the compensation, they cannot challenge the acquisition. My lord, the last paragraph 14.
A case in which the award was not passed for 37 years. Was that a case?
No, that was.
That case was an award passed after 37 years.
My lord, that the delay is, my lord, they have not, they themselves, my lord, sought for the continuation of the acquisition. Therefore, the delay will not come in the way, my lord, because they.
Another adjudicator, na?
Next adjudicator. Third one is, my lord, there the contention, that, my lord, they have made the application for the state government for deletion of the land in view of the neighboring land was deleted by the state government. That they have sought for the discrimination of on the ground, my lord.
Land bearing survey number
It's only for the
49
purpose.
of Beniganahallli village, measuring 1 acre 11 guntas, was permitted to be used for an industrial purpose way back in the year 1964. This property was purchased by the father of the petitioners on 18/5/1972. Thereafter, the father of the petitioners obtained a sanction of the development plan from the erstwhile CATV under resolution number 473 on 2/8/1972. The father of the petitioners thereafter started a cable manufacturing factory in land bearing survey number 49. Next paragraph. On 28/5/1984, a notification under section 17 of the BD Act was issued for the purposes of ಯಾವ layout ಅದು?
Residential layout,
Layout to the east.
NGF layout.
For the purposes of
Page 7. my lord.
forming a layout called east of NGF layout. In this notification, the land bearing survey number 49 was also included. Next paragraph. On 23/10/1986, a declaration under section 19 of the BD Act was issued, in which also the land bearing survey number 49 was included. Next paragraph. However, no award was passed in respect of this land, nor was possession taken. It appears thereafter, the petitioners filed a suit for partition amongst themselves in OS 6712/2016, and this ended in a compromise whereby the petitioners were allotted the land in question.
BDA is not party in that.
And very fact ಹೇಳ್ತಿದ್ದೇನೆ.
ಅಲ್ಲ BDA party ಇಲ್ಲ ಅನ್ಸುತ್ತೆ.
Next paragraph. The petitioners thereafter filed WP 1188 of 2020, seeking for a direction to the state to denotify the land or to grant compensation as per the provisions of the 2013 Act. This court, by an order dated 30/11/2020, disposed of the writ petition directing the BDA to consider the representation and pass appropriate orders. Since this order was not complied with, the petitioners initiated contempt proceedings in CCC 238/2021. On the basis of a statement made in CCC 238/2021 that the representative of the petitioners was considered, the division bench dropped the proceedings. Next paragraph. Thereafter, on 29/5/2021, an award has been passed in respect of this particular land bearing survey number 49. And the petitioner is therefore aggrieved by the passing of the award and has hence filed the present petition. Learned Senior Counsel Shri M.R. Naik submitted that if the BDA had not passed an award, even after from the date of issuance of the declaration, it is obvious that the acquisition proceedings were abandoned and the BDA could not pass an award nearly 35 years after the declaration and seek for taking over possession. He submitted that the petitioners have been running an industrial unit right from the year 1974. And merely because the petitioners came before this court and sought for a direction to either denotify the land or to seek for compensation under the 2013 Act, that would not entitle the BDA to pass an award under the 1894 Act, and that too taking the market value as of the year 1984. He also submits that you said the adjoining land is denotified or something, you said.
Yes, let's have.
Survey number 50,
It also submitted that the BDA has in fact denotified the adjoining land bearing survey number
50/2.
The state
Bar two.
state has denoted.
50/2. State government has withdrawn from acquisition by issuance of a notification 13/5/2010. And this by itself indicates that the land of the petitioner was obviously not required by the BDA. It's for Learned Counsel appearing for the BDA on the other hand contends that the petition filed by the petitioner challenging the acquisition cannot be maintainable, since in the earlier round of litigation, the petitioners did seek for compensation. He submitted that once a claim for compensation is made, the right to challenge the acquisition is completely lost. He submitted that the petitioner cannot also seek for a direction to denotify the lands merely on the ground that the adjoining lands have been denotified. He placed reliance on a division bench ruling of this court passed in ILR 1991 Karnataka 1183, a decision of the in relation to the claim for compensation and the challenge to acquisition, and also a decision of the Supreme Court in 2018 13 SEC in relation to the plea of res judicata, and a judgment of the Supreme Court in the year 1995 Supreme Court 705 in relation to issuance of a writ by which an authority cannot be compelled to repeat an illegality over and over again. Learned Senior Counsel in reply contended that the filing of the earlier petition can never be construed as res judicata, since though the petitioner did seek for denotification and in the alternative for compensation, this court, without adjudicating upon the said issue, merely directed the BDA to consider the grievances of the petitioner, and therefore it cannot be assumed that the petitioner did claim for compensation. He also pointed out that the claim for compensation was for passing an award under the 2013 Act and not for payment of compensation under the 1894 Act. Learned Senior Counsel also submitted that in view of the stand taken by the BDA, a review petition was filed in RP number 138/2023. And in this review petition, the learned single judge who passed the order in WP 11/888/2020 has clarified that the order passed in the said petition would not affect or cause prejudice to the right of both the petitioners and the respondents in this writ petition, and all aspects of the matter were kept open. In the light of the above, the only question that would arise for consideration in this case is as to whether the BDA can proceed to pass an award nearly 35 years after the declaration has been issued. It is not in dispute that the notification under section 17 and 19 were issued in the year 1984 and 1986. It is also not in dispute that the petitioners did not challenge the acquisition and did not secure any interim order from any forum restraining the BDA from taking further steps in the matter. It is to be stated here that even though section 11A of the Land Acquisition Act would be inapplicable to an acquisition under the provisions of the BDA Act, nevertheless, the BDA cannot proceed to keep quiet for nearly 3.5 decades and then pass an award and try to secure possession. It is to be noticed here that in the present case, the only probable reason for the BDA to have passed an award in the year 2021 is because the petitioner had filed WP 11/888/2020, seeking for a direction to either denotify or to pass an award under the 2013 Act. In my view, this prayer of the writ petitioner in WP 11/888/2020 cannot confer a right on the BDA to pass an award. It is to be stated here that the BDA is expected to pass an award within a reasonable time. In a case such as this, when there was absolutely no impediment for passing an award for nearly 3.5 decades, the BDA cannot take advantage of the filing of a writ petition by the petitioner to pass an award and then claim it has acquired the lands. The award that is passed with the BDA cannot therefore be sustained. Over as far as the reliance placed on by the learned counsel of the BDA of the judgment in ILR 1991 Karnataka 1183, it is to be noticed here in that particular case, the division bench was not considering a case where an award had not been passed for 37 years. In that case, the division bench was considering the challenge to an acquisition made within time, but the right to challenge the acquisition was negative because a claim for compensation had been made. The ratio of that judgment cannot therefore be applicable. As far as the reliance placed on the decision of the Supreme Court in 2018, volume 13 SCC 675 regarding constructive res judicata is concerned, it is to be stated here that the petitioner did seek for a direction to denotify or to pass an award. So if this court had passed an order holding that the government was required to denotify or that an award was to be passed, then a subsequent writ petition seeking for the same relief would be barred by the principles of constructive res judicata. In the earlier round of litigation, this court did not consider the claim of the petitioner on merits and merely directed the BDA to consider the grievances put forth by the petitioner. Such a direction issued on the basis of the writ petition by the petitioners for denotification cannot be construed as constructive res judicata, and therefore of the view that the contingents advanced by the BDA cannot be accepted. The impugn notifications are therefore quashed. Impugn notifications and the award are quashed.
My lord,
LPP is allowed.
notification so far as the petition.
ಅವರೊಬ್ಬರದೇ ತಾನೇ ಬೇರೆ ಯಾರ್ದು ಮಾಡಿಲ್ಲ.
ಅಲ್ಲ ಅದು ತಾವು notification ಅಂದ್ರೆ entry sorry, it will.
The award in so far as the lands of the petitioner is concerned are quashed.
Lords have said so, but then let's, since it is the BDA, I was wondering whether your lordships could just make a mention of the judgments which have taken a view that if they don't pass an order, award or
ಬಡಿ ಸಾಕು. Sites identify ಮಾಡಿದ್ರ?
ಇಲ್ಲ ಸ್ವಾಮಿ, ಗವರ್ಮೆಂಟ್ ಅವರು has directed us to hand over all the slum areas to the slum board by way of a 2021 circular, my lords.
No, did you identify the sites to be given to them?
Allotment letters had already been issued to them. ಅದನ್ನ allotment letters are produced along with the petition itself. It is their case that the slum board has evicted them and put up the construction of a building.
As an alternative, now that the slum board has taken over possession of those particular sites that you had allotted,
Please.
I had asked you to give them alternative sites in Kempegowda layout.
ಇಲ್ಲ, you obtain instructions ಅಂತ ಹೇಳಿದ್ರಿ. I have obtained instructions, my lord. My instructions, my lord, are that the Karnataka government under 2021 circular produces along with the objection statement under section 27(3) of the Slum Board Act has directed us to hand over all the slum areas to the slum board for considering the allotment of sites to all the allottees, necessary allottees. This honorable court, my lord, in a similar case has directed us to do the same. I pass on the judgment, my lord.
Now, what should happen to the allotment that you have made now, according to you then?
Lord, of the allotments made, my lord, there are 9 petitioners. Petition number 1, 2 and 9, we had issued a sale deed to them. So they are entitled to allotment from the slum board. petition number 3 to 8, my lord, the allotment notice was, process was stopped for the reason that they had given incorrect information, wrong
You're
information.
not prepared to give them an alternative side.
Mayor, for a moment, may I can,
Yes or no? I look at it afterwards.
we are not in a position to do it, my lord, by virtue of the circular issued by the government, my lord.
You can't give them alternative side after executing a sale deed in their favor?
This, no, my lord, the reason, my lord, is that, I'm sorry, my lord, I'm saying this, the reason, my lord, is that this slum board has proceeded to take forcible possession of the property from the petitioners without our consent, my lord. We had handed over the possession to them, sale deed has been executed, they were put in possession of the property, or rather, my lord, if I may say this, they were in possession of the property, they sought for regularization, my lord. Pursuant to the same decision was taken to regularize this possession, sale deeds were given, my lord. And sale deeds of 1, 2, and 9 have been produced along with my objection statement. So it is they who are dispossessed by the slum board without either our intelligence or our consent being given, or the petitioner's consent is what we are saying. Now, as with respect to allottees, sorry, my lord, petitioners 3 to 9, my lords, 3 to 8, their sale deeds itself was not given, my lord, because the allotment process was not complete because they had given wrong information as far as the original files are concerned. Now, after all this, my lord, in 2021, the government has passed a circular under section
There's no
27(3).
objection if I were to direct the BDO to demolish slum board, to demolish the buildings and hand over the sales to them.
Demolish the, my lord?
The building that they have constructed there.
Please, my lord, we have no
You
objection.
have no objection.
Yeah.
Please put it on affidavit.
Lordship, may kindly direct me, my lord, so that I can accordingly.
Not directly. You are making the statement, file an affidavit.
No, I have not made that statement, my lord. I'm sorry. What I'm trying to say, my lord, is that slum board, my lord, when they took possession of those properties, my lord, there is no consent given by the BDM, my lord. Now, the slum board, slum board in their objection statement, my lord, says, under section 13, they have declared it as a slum area, my lord, survey number 10 of the Gangondali village. Now, after section 3 process, if they want to take up acquisition or development, they have to do a process under section 17, as my lords on the other day also pointed out. They don't undertake a process under section 17, my lord. The petitioners are forcibly evicted, my lord. Then what, my lord, they say is that we have given consent is what the petitioner says. When I looked into the original file, my lord,
Where's your objection?
I filed it on 6/4, my lords.
Where's your objection?
6/4, I filed it, my lords, in the office.
6/4. Memo is there.
Served a copy on the other side.
You don't have it. Can you pass in your?
My. Sorry, my lords, I filed it only on 6/4.
What is your response to this annexure R12 that you have produced? This was addressed to you.
This is prior to the, this is prior to the 21 circular, I'm sorry, my lord, I'll just go.
R12.
This is pursuant to, my lord, once they started.
This was
taking
addressed to you.
This is addressed to me subsequent to, my lord, after I sought a request from them asking as to how is it that they are dispossessing. Then, my lord, they say
What is
that
your
you,
response to this?
we are not in a position to give alternate. The reason, my lord, is this.
Where have you stated that to them? They stated that the housing minister had asked you to submit a proposal for grant of alternative sites.
We have not given any NOC, my lord. They requested for a NOC.
But
We have
you
not
can't
given
give
NOC. We have not given.
Minister had directed that a proposal be submitted for grant of alternative sites to these petitioners. What has been the response of the commissioner?
After subsequent to this, my lord, I did not see any reply. We have not given any NOC, my lord, as far as that is
I'm
concerned.
not concerned with the NOC. What was the reply of the commissioner to the slum board for this direction of the housing minister?
This is,
Because
my
your
lord,
counter is silent on that.
this, my lord, my lord, in the objection, I said that we have not given any NOC, my lord. The reason, my lord, is this, if I may submit this, my lord, in this manner.
I read your counter.
Correct.
I want to know what is the response of the BDA to the letter of the slum board commissioner.
This letter, my lord, is in response to what I have written is what my understanding, my lord, is. ನಾನ್ ಪತ್ರ ಬರೆದಾಗ ಈ ತರ ನೀವು ಯಾವ ತರ ಯಾಕೆ ಅಂದ್ರೆ ನನಗ್ ಬಂದು ಕಂಪ್ಲೇಂಟ್ ಕೊಟ್ರೆ.
Page number 40.
At page 40. Vishaya, page 40, madam. This is a letter written by BDA to slum board. ವಿಷಯ ಅರುಂಧತಿ ನಗರ ಸ್ಲಮ್ ಸರ್ವೆ ನಂಬರ್ 8 ಮತ್ತು 10 ಗಂಗೋಡಹಳ್ಳಿ ಚಂದ್ರ ಬಡಾವಣೆ ಸಂಬಂಧಿಸಿದಂತ ವಸತಿ ಸಮುಚ್ಚಯದ ಹಂಚಿಕೆ ಬಗ್ಗೆ ಮಾಹಿತಿ ನೀಡುವಂತೆ ಕೋರಿ ಸನ್ಮಾನ್ಯ ಮುಖ್ಯಮಂತ್ರಿಯವರ ಸಚಿವಾಲಯದ ಪತ್ರ ಸಂಖ್ಯೆ 2 ಸನ್ಮಾನ ಉಪಮುಖ್ಯ 2 ಮೇಲ್ಕಂಡ ವಿಷಯಕ್ಕೆ ಸಂಬಂಧಿಸಿದಂತೆ ಉಲ್ಲೇಖಿತ ಪತ್ರದಲ್ಲಿ ಅರುಂಧತಿ ನಗರ ಸ್ಲಮ್ ಸರ್ವೆ ನಂಬರ್ 8 ಮತ್ತು 10 ಗಂಗೋಡಹಳ್ಳಿ ಬಡಾವಣೆಯಲ್ಲಿ ಪ್ರಾಧಿಕಾರದಿಂದ ಹಂಚಿಕೆ ಮಾಡಿ ಶುದ್ಧ ಕ್ರಯ ಪತ್ರವನ್ನು ನೋಂದಣಿ ಮಾಡಲಾಗಿದ್ದ ಫಲಾನುಭವಿಗಳಿಗೆ ಸಂಬಂಧಿಸಿದ ನಿವೇಶನಗಳನ್ನು ಮಂಡಳಿಯವರು ವಸತಿ ಸಮುಚ್ಚಯವನ್ನು ನಿರ್ಮಿಸಿದ್ದು ಹಂಚಿಕೆದಾರರು ಬದಲಿ ನಿವೇಶನ ಕೋರಿದ್ದು ಸದರಿ ಹಂಚಿಕೆದಾರರಿಗೆ ನಿಯಮಾನುಸಾರ ಕ್ರಮ ವಹಿಸುವಂತೆ ಸೂಚಿಸುತ್ತಾರೆ. ಆದ್ದರಿಂದ ಮಾನ್ಯ ಮುಖ್ಯಮಂತ್ರಿಗಳು ಹಾಗೂ ಉಪಮುಖ್ಯಮಂತ್ರಿಗಳ ನಿರ್ದೇಶನದಂತೆ ಕ್ರಮ ವಹಿಸಬೇಕಾಗಿರುವುದರಿಂದ ಹಂಚಿಕೆದಾರರ ವಿವರಗಳನ್ನು ಈ ಕೆಳಕಂಡಂತೆ ನೀಡಿದ್ದು ಸದರಿಯವರಿಗೆ ತಮ್ಮ ಮಂಡಳಿಯಿಂದ ಬಡಾವಣೆಯಲ್ಲಿ ವಸತಿ ಸಮುದಾಯದ ಹಂಚಿಕೆ ಮಾಡಲಾಗಿದೆಯೇ ಅಥವಾ ಇಲ್ಲವೇ ಎಂಬ ಬಗ್ಗೆ ಪರಿಶೀಲಿಸಿ ವರದಿ ನೀಡಲು ತಮಗೆ ಕೋರಲಾಗಿದೆ. Then, my lord, this is the reply by Annexure F. There is no allotment to these persons. Annexure F, page 41.
Where is the letter of this chief minister and the deputy chief minister? Have you produced that here?
It must be with them, my lord.
What is your
get it, my lord. I'll
response to Annexure E and F?
I'll source it. I'll get it from the original file, my lord. I'll get these directions issued by the.
What counter did you file if you don't look at the
The
petition?
reason, my lord, I'm relying on the 21 circular, my lord, of the state.
You can decide on what you file in the count without reference to the petition.
Subsequently, my lord, in 21, my difficulty, my lord, is this. Kindly appreciate it, my lord. In the year 21, my lord, a notification circular is issued under section 27(3) of the act, my lord, saying that hand over all the slum areas to the slum board. No, my lord, notwithstanding this letter, my lord, I'm required to follow that circular, my lord. On section 65, I'm required to follow the circular. I produced it along with my objection statement. Lordship may kindly for a moment come to Annexure R 13, my lord, dated 23/2/2021. my lord. It applies to the entire state of Karnataka, my lord. I'm sorry, that is, ಅದು ಇವರು highlight ಮಾಡಿರ್ಬೇಕು. May I just read it, my lord, the last portion of it, on page 74.
ನಮ್ಗೆ ಅಲಾಟ್ಮೆಂಟ್ 2007, not 21.
ಏನು ಓದ್ಬೇಕು?
Page 72 ನಲ್ಲಿ Annexure R 13 ನಲ್ಲಿ
ಹ್ಮ್.
ವಿಷಯ ರಾಜ್ಯಾದ್ಯಂತ ಇರುವ ನಗರಸಭೆ, ಪುರಸಭೆ, ಪಟ್ಟಣ ಪಂಚಾಯಿತಿ, ಮಹಾನಗರ ಪಾಲಿಕೆಗಳು, ಬೃಹತ್ ಬೆಂಗಳೂರು ಮಹಾನಗರ ಪಾಲಿಕೆ ಮತ್ತು ಅಭಿವೃದ್ಧಿ ಪ್ರಾಧಿಕಾರದ ಮಾಲೀಕತ್ವದಲ್ಲಿರುವ ಜಮೀನುಗಳನ್ನು ಕರ್ನಾಟಕ ಕೊಳಗೇರಿ ಅಭಿವೃದ್ಧಿ ಮಂಡಳಿಗೆ ಹಸ್ತಾಂತರ ವರ್ಗಾವಣೆ ಮಾಡುವ ಬಗ್ಗೆ. Lordship may kindly come to page 74, my lord.
Please read from the beginning, let us see.
ಪ್ಲೀಸ್ ಮೇಡಮ್, ವಸತಿ ಇಲಾಖೆಯು ಆದೇಶ ಸಂಖ್ಯೆ ಸೋನ್ಸೋ ದಿನಾಂಕ ಸೋನ್ಸೋ ಸರ್ಕಾರದ ಆದೇಶ ಸಂಖ್ಯೆ ಸೋನ್ಸೋ ದಿನಾಂಕ 24/1/2011 ಆದೇಶವನ್ನು ಹಿಂಪಡೆದು ಕೆಳಕಂಡ ತಕ್ತೆಯಲ್ಲಿ ನಮೂದಿಸಿರುವಂತೆ ಸಾಂಕೇತಿಕ ದರವನ್ನು ನಿಗದಿಪಡಿಸಿ ಕರ್ನಾಟಕ ರಾಜ್ಯಾದ್ಯಂತ ಸರ್ಕಾರ, ಬೃಹತ್ ಬೆಂಗಳೂರು ಮಹಾನಗರ ಪಾಲಿಕೆ ಹಾಗೂ ಮಹಾನಗರ ಪಾಲಿಕೆಗಳ ಮಾಲೀಕತ್ವದಲ್ಲಿ ಇರುವ 596 ಘೋಷಿತ ಕೊಳಚೆ ಪ್ರದೇಶಗಳು ಹಾಗೂ ಸ್ಥಳೀಯ ಸಂಸ್ಥೆಗಳ ಮಾಲೀಕತ್ವದಲ್ಲಿರುವ 1277 ಘೋಷಿತ ಕೊಳಚೆ ಪ್ರದೇಶಗಳಲ್ಲಿ ವಾಸವಾಗಿರುವ ಕೊಳಚೆ ನಿವಾಸಿಗಳಿಗೆ ಹಕ್ಕುಪತ್ರವನ್ನು ಕೆಳಕಂಡಂತೆ ವಿತರಿಸಲು ಅನುಮತಿ ನೀಡಲಾಗಿದೆ.
So this is instead of declared slum areas.
This is also a declared slum area, my lord. Slum board has filed its objections under section 3, my lord. They have declared it as a slum area, my lord.
Where is the notification?
The section 3, our objection statement jothe haki.
This is of the year 2021.
Yes. This notification
You have not handed over pursuant to this notification. You had made the allotment
No, my
and
lord.
deeds prior to this.
2007, my lord.
How can you place reliance on this?
I'm sorry, my lord.
You had executed sale deeds prior to this.
2007, my lord.
So how can you place reliance on this 2021 circular?
It applies to all slums, my lord, under section 27(3), my lord.
So even if you have conveyed the property, you will hand it over to the slum board?
If they have already stands conveyed, my lord, I no longer have title, so I cannot convey it, my lord.
And what
Other
is the
than,
basis for you to place reliance on 2021?
no, my lord, if further allotments are ordered by your lordships, they are to be considered to be ordered by my lords. I'll allot them from the slum areas as declared in section 3. Now, my lord, the state government has directed me to hand over the slum areas to them. This exactly what, my lord, this honorable court also done in the judgment in the, which I passed to my lord, wherein it, my lord, then saw rather, my lord, that it has already been handed over to the slum board. Therefore, directed the slum board take action on this and immediately consider the allotment to the petitioners.
Still unable to understand.
Please,
You place reliance on a circular of the year 2021.
please, my lord.
What does 2021 circular say? That all those lands in the possession of the BDA, which are declared to be slum areas, are to be handed over.
Please.
Does it also state that all lands which you have already disposed of?
Disposed of ಪ್ರಶ್ನೆ ಬರೋದೇ ಇಲ್ಲ. As my lord is rightly saying, disposed of ಪ್ರಶ್ನೆ ಬರೋದಿಲ್ಲ. Conveyance ಆಗೋಯ್ತು ಅಂದ್ಮೇಲೆ I don't read.
But then why are you placing reliance on annexation R13?
Other than slum base, ಒಂದೇ ಅಂತ ಒಂದ್ಸತಿ ನಾವು ತಾವು ನೋಟಿಫಿಕೇಶನ್ ನೋಡಿ ಸ್ವಾಮಿ, ಅಬ್ಜೆಕ್ಷನ್ಸ್ ಹಾಕಿದರೆ ಅವ್ರು ಏನ್ ಹೇಳ್ತಾರೆ ಅಂತಂದ್ರೆ, so many survey numbers in so many areas are declared as a slum under section 3 ಅಂತ ಮಾಡ್ತಾರೆ. So what happens is, the moment an entire survey number of a particular area is declared as a slum, even assuming for my lord that I have gone ahead and notified some areas in that particular survey number, they are for all practical purposes considered as a slum under the Slum Board Act. So these slums which have been classified as slums under the Slum Boards Act, hand it over, whether they are in my position or some other BBMP or any other position, hand it over to the slum board so they can consider allotment in accordance with law. Now your lordships is considering whether the petitioners have to be given an alternate site or not. My lord, these alternate sites also have to come from the slum areas. Now these slum areas have been handed over.
No. These allotment of alternate sites will come from you, because you are the ones who you are the one who allotted those sites to them.
My lord may kindly then
The
consider.
declaration of the slum area is of no consequence to you.
My lord may kindly then consider.
Decided
my
to
lord.
allot
Correct
the
me.
sites.
I'm sorry, I'm sorry. Lordship was saying something.
You decided to allot sites. If those sites you could not have allotted because it was declared as slum area, it becomes your obligation to allot them an alternative site. That is what the chief minister and the deputy chief minister directed.
My lord, may I then say this? As far as petition number 1, 2, and 9 is concerned, my lord, my lord, I'll go through those two letters, my lord, I'll make my submission. But however, if I'm asked to make the submission, petitioner 1, 2, and 9, my lord, I have already executed the sale and I had put them in possession of the property, my lord. Under rule 11A, my lord, giving of an alternate site would arise, my lord, where I am not in a position to put the allottee in possession of the property subsequent to the execution of sale deed. Here, that is not the case, my lord. I was able to put them in possession, rather, my lord. The petitioners 1, 2, and 9 were in possession of the property. That's how it was considered for allotment to them, my lord. So under
You're
rule
saying that-
11A, my lord.
You're saying that you will disregard the order of the chief minister and
No, my
deputy
lord.
chief minister.
Subject to what, my lord, those directions have been given to me. I'll place those two letters for consideration of
Not
your
to
lordship.
give any direction. There is already a
I'll
direction
place it
as
on my
per-
own accord, my lord. I'll place it on my own accord.
You don't have to, you've already placed it on record. I'll proceed on the footing that you are going to disobey the order of the chief minister and the deputy chief minister.
May I then request your lordships to consider this, my lordship may kindly consider this. 1, 2, and 9, I've already made my submissions. As far as 3 to 8 is concerned, my lord, once subsequent to the allotment, issuance of the allotment letters, complaints were received by the BDS saying that the information provided by the petitioners 3 to 8, my lord, were incorrect. They were not residing in the said areas. The details given in the Aadhaar card and their other details were incorrect. And therefore, the entire process is being misused, my lord. Subsequent to that, my lord, I wrote letters to petitioners 3 to 8 requesting them to come onto the BDA and give the information, my lord. They have not come before the BDA to give the information. The process stood there, my lords. 3 to 8 have not been. Please, my lord.
Have you cancelled the allotment?
We have not cancelled the allotment, my lord. We have held the process. Now, as far as this petition, my lord, is concerned, lordship may kindly see the prayer. It's for a prayer seeking mandamus of the representation given to the petitioners to consider for allotment, my lord. Even for us to, my lord, if I may respectfully submit, for us to consider the allotment, my lord, I understand the humanitarian grounds that is being urged by the petitioner and may it also come to the consideration of your lordships. I'm conscious of it, my lord. But I would like to place for your lordships the consideration that may have to be given to the 2021 circular, my lord, because it's issued under 27(3) of the circular. Even if your lordships for a moment were to say that's a circular which I cannot rely upon because the sale leads were executed prior to that. Lordship may kindly consider that Rule 11A, my lord, for me to issue an alternate site would only arise, my lord, if I have not put them in possession of the property. As far as 3 to 8 is concerned, my lord, the allotment process is not complete for the reason of
If the allotment made by you was contrary to the slum clearance, the notification, did you not commit an illegality?
Sorry, my lord.
If you had allotted those sites,
Please.
notwithstanding there being a declaration of it being a slum area, was it not a violation on your part?
But the reason, my lord, is that the slum, once they
Was it a
declare,
violation or not?
it may not be a violation for this reason, my lord. A declaration of a slum under section 3 is to extend them some benefits under the Slum Boards Act, my lord. What then, as your lordships rightly pointed out last time to the slum board, is that under section 17, my lord, if they had issued a notification seeking to acquire the said land, my lord, then I would not have been able to do anything. Here, they don't go under section 17, my lord. After section 3, they directly come to take possession of the property, my lords, and put up a construction. There are
Don't have
160
to worry
houses.
about them. I will take care of them.
I understand that, my lord.
Are you prepared to give them an order to say it or not? Will you
my-
make a statement correctly or not?
I will.
Because there's a direction of the chief minister and deputy chief minister. Will you give them an order to say it or not? That is all that I adjourn the matter for.
My lord, I may be permitted, my lord, to seek the specific instructions in light of those 2 letters issued by the Honorable Chief Minister and the Honorable DCM, my lord. I would like to seek specific instructions on that, see if they want to make any further statement.
Yes.
So my only submission is, lordship, that the petitioners were allotted PDA site already by the PDA. And further, the petition is also only seeking the alternative allotment from the PDA. And as far as the slum board is concerned, they have an alternative arrangement, which lordship I explained in the morning, saying that they are constructing alternative apartments in Lagere, which will be
No,
completed.
you give them the cost of construction or you construct a house for them in the alternative state that they will furnish.
My instructions were actually that to submit that the alternative arrangement is there as far as Lagere is concerned, wherein if the petitioners are willing to take that, then we can provide the details of those apartments.
What is the cost of construction in that 20 by 30 nadu?
20 by 30 ಇಲ್ಲ, ಬೇರೆ ಚೇಂಜ್ ಆಗ್ತಾ ಹೋಗುತ್ತೆ, ಮೆಜರ್ಮೆಂಟ್ ಚೇಂಜ್ ಆಗ್ತಾ.
ನಿಮ್ಗೆ ಅಲಾಟ್ಮೆಂಟ್ ಇದೆ ಎಷ್ಟು?
20 by 30, all 20 by 30.
20 by 30. ಎಲ್ಲಾದ್ರೂ 20 by 30.
At whatever rates you construct in your multi-story complexes, permissible FAR in the 20 by 30, you will pay them that cost.
I'll seek the instruction on that.
Wednesday. Whatever is the permissible FAR for 2030, the cost you will pay. And I will direct them to give an alternative set. And I'll monitor this till it is done.
Yes.
Wednesday.
As a case now, there is a suit pending before the civil court, your lordship, between the parties. Suppressing the material fact, there is an injunction order also not to disperse the amount. So lordship looks at, my lord, the order. Page annexure E, my lord. Relevant sheet of the order.
Have you served a copy on anybody?
No, no.
Chandrasekhar?
Sir, I will serve. In fact, the notice was issued to fixing the date on 9/5/2024 because of the election and quoting this original suit to petition everything. For
I'll have on Wednesday. Find out what is happening.
by that time, my lord, they will release the amount to your lordship. Kindly see the notice itself, your lordship. Notice itself, page 31. There is an injunction order not to disperse the amount. Page 73.
Page
73, my lord. Where the respondent number 4 is also a party to the proceeding. 73.
ಎಲ್ಲಿದೆ ನೋಟಿಸ್ ಎಲ್ಲಿದೆ ಅವ್ರು ಕೊಡ್ತೀನಿ.
Our notice to page 96, your lord, 90, page 90. My lord, may kindly see. For extraneous consideration, he got advanced the case, your lordship. This is
ರಾಮಯ್ಯ 96 your lordship. ರಾಮಪ್ಪ ಬಿನ್ ಗರುಡಯ್ಯ ಅವರಿಗೆ ತಿಳಿಸುವುದೇನೆಂದರೆ ಭೂಸ್ವಾಧೀನವಾಗಿರುವ ನೆಲಮಂಗಲ ತಾಲೂಕು ತ್ಯಾಮಗೊಂಡು ಹೋಬಳಿ ಸೋನ್ಸೋ 2 ಎಕರೆ ಜಮೀನು ಪರಿಹಾರ ಪಾವತಿಸುವ ಬಗ್ಗೆ ಮಾನ್ಯ ಸಿವಿಲ್ ನ್ಯಾಯಾಲಯದಲ್ಲಿ ದಾಖಲಾಗಿರುವ ಪ್ರಕರಣಗಳು ಬಾಕಿ ಇರುತ್ತವೆ ಹಾಗೂ ಮಾನ್ಯ ಉಚ್ಚ ನ್ಯಾಯಾಲಯದ ಬೆಂಗಳೂರು ರಿಟರ್ಜಿ ಸಂಖ್ಯೆ 4878 24ರಲ್ಲಿ 21/2/24 ಆದೇಶ ಹೊರಡಿಸಿ ಕಾನೂನು ರೀತ್ಯ ಕ್ರಮ ಸೂಚಿಸಲು ನೀಡಿದ್ದು ಈಗಾಗಲೇ 1/4/24ರಿಂದ ಚುನಾವಣಾ ಕರ್ತವ್ಯದ ನಿಮಿತ್ತ 9/5/24ಕ್ಕೆ ವಿಚಾರಣೆಯನ್ನು ಮುಂದೂಡಲಾಗಿತ್ತು. ಹ್ಯಾವಿಂಗ್ ಅರ್ಜೆಂಟ್ ದಿ ಮ್ಯಾಟರ್, ಆದ್ರೆ ಈಗ ಅಡ್ವಾನ್ಸ್ ಮಾಡಿದ್ರು ಅಂತ ಹೇಳಿ ಟೇಕನ್ ಇಟ್ ಅಂತ ಹೇಳಿ ನಾಳೆಗೆ ಆರ್ಡರ್ಸ್ ಇಟ್ಕೊಂಡಿದ್ದಾರೆ ಒಂದು ಮಾರನೇ ದಿನನೇ.
This WP is disposed of?
WP without making me as a party disposed of. My lord may kindly say I am not a party to that.
Where is that
84
order?
ಅಲ್ಲಿ.
Where is that
General,
order?
page 84. General award na 84.
Yes, 90.
90.
There is a rider also.
Page 90, my lord. Yes. Kindly see the last order, your last.
93.
General award pass set aside ಮಾಡಿ consent award pass ಮಾಡಿ ಅಂತ relief ಕೇಳಿದ್ರೆ I was not a party to that.
ಇಲ್ಲ, ಆಟೋಮೆಟಿಕ್ ಜನರಲ್ ಅವಾರ್ಡ್ ಸ್ಟ್ಯಾಂಡ್ ರೆಸ್ಟೋರೆಂಟ್ ಅಂತ ಇದೆಯಲ್ಲ ಅದರಲ್ಲಿ.
ಅದೇ ಹಿಂಗಿದ್ರು ಸಹ ಅಡ್ವಾನ್ಸ್ ಮಾಡ್ಕೊಂಡು
Lordship may say,
when there is a dispute ಅಂತ ಅಂದ್ರೆ
in view of the disputes on civil court judgments, the Lordship may direct a lot to this for the complaint, maybe urgent notice, maybe other parties. Meanwhile, I will secure instructions. I don't want to take a risk.
advance ಮಾಡ್ಕೊಂಡು
DG accepts notice for R1. Chief Chandrasekhar accepts notice for R2 and R3. Issue notice to R4. 3 ಗೆ ಅದನ್ನ ಹೇಳ್ತಾರೆ.
Yes, number 8.
R4 you will.
Issue notice to R4.
3.
Council is also permitted to take out notice on Sri Jagdish Baliga, who appeared for R4 in WP 4878/2024. Till the next date of hearing, the third respondent shall not disperse the compensation to the fourth respondent or to any other entity.
Or anybody ಅಂತ
Or anybody.
anybody.
Relist on next Monday.
ಏನ್ ಇಂಟರ್ವ್ಯೂ ಮಾಡ್ರಿ ಯಾವ ಬೇಕಾದ್ರೆ ಹಾಕ್ಬೋದು ಅಷ್ಟೇ. ಮತ್ತೆ ನೋಟಿಸ್ ಬರ್ಬೇಕು ಅವ್ರಿಗೆ.
ಅಲ್ಲ, ಜಗದೀಶ್ ಬಾಳಿಗ ಅವ್ರಿಗೆ ಟೇಕ್ ಔಟ್ ನೋಟಿಸ್ on ಜಗದೀಶ್
ಅವ್ರು
ಬಾಳಿಗ.
ತಗೋತೇನೆ.
Monday I'll dispose it.
Yes, your lord.
18th ಹಾಕೋಬೋದು ಅಂತ.
17th, 16th.
18th it may take 18th ಮಲ 18th.
May see kind delivery of the order, others my 11th.
ಇಲ್ಲೇ ಅವರೇ ಇದಾರಲ್ಲ.
Yes, sir. ಅವ್ರು ಏನ್ ಬೇಕಾದ್ರೂ ಮಾಡ್ತಾರೆ ಚಿತ್ರಗುಪ್ತರು, ಸ್ಪೆಷಲ್ ಅಂಡ್ ಅಕ್ವಿಷನ್ ಆಫೀಸ್.
ಏನ್ ಮಾಡಕ್ಕಾಗತ್ತೆ? Where is he?
In this case, I am for the petition.
Yes.
Lord, this is the plaintiff petition.
Where is the other side? He did not come on the last occasion also.
But 2-3 ಡೇಟ್ ಇಂದ ಬಂದಿಲ್ಲ ಸರ್.
ಒಂದು ರೆಕಾರ್ಡ್ ಕೊಡು. ಇದ್ರ This is a revision by the unsuccessful plaintiff. So the plaintiff instituted a suit for recovery of a sum of rupees 75,750 along with interest at 12% per annum, contending that she and the defendant were relatives related to each other, and she had approached her and requested for a hand loan of rupees 75,000. And she had accordingly lent a sum of rupees 75,000 on 18/9/2014 by cash. She stated that the time of giving the hand loan, the defendant had executed an on-demand promissory note and a consideration receipt in her favor. And in terms of the said promissory note, she paid the interest up to 2014, but thereafter defaulted. As a consequence, she got a legal notice issued on 12/2/2015, which was returned unserved. She stated that the postal authorities, however, gave her an endorsement that the notice had been duly served on the defendant on 14/2/2015. And since this demand was not complied with, she was constrained to file the suit. The defendant entered appearance and denied the entire stand taken by the plaintiff. She stated that the plaintiff was a total stranger and she never had any financial problems so as to approach her for an hand loan. She also denied the execution of the on-demand promissory note and the consideration receipt. In support of her case, the plaintiff examined herself examined herself and got 4 documents admitted in evidence and marked as exhibits. The defendant also got herself examined, but did not choose to produce any documents. The trial court, on consideration of the pleadings and the evidence, came to the conclusion that the plaintiff was unable to establish that she was in a position to lend a sum of rupees 75,000. And she had not examined the 2 witnesses who had affixed the signatures to the promissory note and consideration receipt, and therefore her claim could not be accepted. The trial court accordingly dismissed the suit, as against which the present revision is filed. Then counsel for the petitioner contended that the execution of the promissory note was in fact categorically admitted during the course of cross-examination by the defendant. And in the light of this admission, the necessity of examining the witnesses would not at all arise. He submitted that since the defendant had admitted that her husband was doing chit transactions with the plaintiff for rupees 1.5 lakhs each, and she had executed a pronote, she had executed the promissory note and the consideration receipt in that regard, by itself established the financial transaction, and therefore the trial court could not have dismissed the suit. Next paragraph. In the course of cross-examination of the defendant, she has stated as follows. As could be seen from the above, the defendant admitted that she had books of accounts which was maintained by the plaintiff's brother in respect of the collection of the chit amount, but she chose not to produce that document. More importantly, she admitted that about 17 to 18 years ago, her husband was doing 2 chit transactions with the plaintiff for a sum of rupees 1.5 lakhs each. And in respect of those 2 transactions, she had executed P1 and P2. In my view, in the light of this clear admission that there was a chit transaction between the plaintiff and the defendant and her husband, and the defendant herself clearly admitted the execution of the promissory note and the consideration receipt, the finding of the trial court that there was no hand loan given by the plaintiff cannot be accepted. If the defendant herself admitted that there were chit transactions. The mere fact that she was working in BBMP and therefore did not need to take a loan would all fall to the ground. I am therefore of the view that the impugned judgment and decree passed with the trial court cannot be sustained, and consequently it is sustained. It is consequently set aside. As a consequence, in the light of the admission of the defendant that she had executed the promissory note and the consideration receipt, the suit is decreed as paid for. ಎಷ್ಟು ಕೇಳಿದ್ರೆ interest? 1%. Suit is decreed for some more rupees, 75,750. So the said sum should carry an interest at the rate of 9% per annum from the date of the loan, from 18/9, 6% on the date of the suit till the date of its realization. Division is accordingly allowed. Much.
Serial number 18.
Serial number?
8 minutes. List 2. Second list. 19th your lordship.
Date ಕೊಡ್ತಾರೆ ಯಾವ್ದು ಬೇಕು date.
Serial number 55.
Lordship, serial number 18.
To serial number
7,
12.
19.
To serial number 12.
Serial number
day after
18.
day after- Serial number 12, list 2, day after tomorrow.
Lordship, serial number 18.
Serial number 12 may be taken up next week, Manoj.
I have been waiting through and through. I'm not there after.
Next week it will be taken up.
That is the only problem.
Wednesday, it's already some other matters, date has been fixed.
Yes, some problem. We'll have it next day after tomorrow. Let us see what left. Or if you're ready now, I'll take it up now.
Please, Manoj.
If you're ready now, I'll take it up now. Are you ready?
Please, Manoj.
ಇದಾದ್ಮೇಲೆ ಮೆನ್ಷನ್ ಆಮೇಲೆ ತೊಳ್ತೀನಿ ಬೇಕಾದ್ರೆ.
Sorry, man.
Day after tomorrow.
Serial number 9, my lord, in the second list. Monday, my lord.
Date ಕೊಡ್ತಾರೆ ನೋಡ್ಕೊಂಡು ಡೇಟ್ ಕೊಡಿ.
Serial number 2 ಮೇಲೆ.
ಹಾ. ಎಲ್ಲಿದಾರೋ?
Serial number 2, next week.
Date ಕೊಡಿ.
Serial number 18, my lord.
List 1, serial number 55, your lordship. Any date next week, your lordship. It is
Already given a date.
Yes, please.
List number 2, serial number 2.
Sir.
Daily wage employees.
Lordship, serial number 18.
We'll give you dates.
ಬರ್ಕೊಂಡ್ರೆ ಸೀರಿಯಲ್ ನಂಬರ್ 7 ಬರ್ಕೊಂಡ್ರ ಸೆಕೆಂಡ್ ಲಿಸ್ಟ್ 19th ಗೆ
Serial number 30. ನಾಳಿದ್ದು ಆಚರಣೆ 13.
Serial number 3.
List 2, 13. List 2, 13.
Sir, 10. Serial number 10, sir.
So,
Second list 2. Monday.
Serial number 3.
so serial number 18.
Monday. Yes. ನಾನು ಕೇಳಿದ್ದೀನಿ ಸಾಹೇಬ್ರಿಗೆ ಮಂಡೇ ಅಂತ ಹೇಳಿದ್ದಾರೆ.
Sir, what officer? Serial number 10, 16.
17R4
Extend my plus date 18 or 19. 18 or 19 will be. 17. Serial number 17.
This number one, serial number 25, 16th ಹಾಕೊಂಡಿದ್ದಾರಲ್ಲ. Thank you.